has awarded cost upon the defendant, but in the said paragraph, inadvertently it is recorded that defendant is directed to pay the cost of rupees 1 lakh to the defendant instead of to the plaintiff. Accordingly, paragraph 14 shall be 14 in the order dated 17 July 2025 shall be read as accordingly, comma, the defendant is directed to pay the cost of rupees 1 lakh to the plaintiff. This order may be incorporated with the order. Yes.
Well, may I have your lordship's kind leave to mention a matter that by an order dated my lord April 29th, your lordship had been pleased to my lord grant me leave to my lord correct the defects. That has been done, my lord, but the reaffirmation and the re-verification has not been done.
Within a week thereafter?
Yes, so that has not been done, my lord. So I require your lordship's extension, my lord, for this.
Counsel for the plaintiff mention the matter and submits that by an order dated 29th April 2025, this court allowed the plaintiff to re-verify and reaffirm the affidavit within a week after the after the defect is rectified. He submitted that defects have already been rectified, but he prays for extension of time to re-verify and reaffirmation of the affidavit in the plaintiff. In view of the submission made by the counsel for the plaintiff, time to re-verify and reaffirmation of the affidavit of the plaintiff is extended for a further period of 1 week from
2 weeks,
2 weeks from date.
The writ of summons, my lord, kindly.
Immediately thereafter, the plaintiff is directed to lodge the writ of summons.
Grateful, my lord.
And may I have your lordship's leave to mention the matter, my lord? This is the South Point matter which was fixed at 12 o'clock at noon. My lord, Mr. Bachawat mentioned before your lordship, my lord, he's down with...
Inform the other side, come at 12.
At 12, my lord.
Inform the other side.
Yes, I've given notice. Is mentioning upon notice anyway.
Next.
For the respondent.
For the review applicant,
my lord, I am for the respondent number 2 and 4.
Yes. This court has allowed the review by deleting the name of Bhaskar Oja and correcting the name of the father of Alok Oja, Chimanlal Oja.
Very good. Lord, I am extremely sorry. The note was...
You tell Tuesday you're not given.
Sir, actually, my learned advocate on record, he couldn't do it.
By that time, I completed me.
I'm extremely sorry.
Okay, no problem.
extremely good.
My lord, only one thing, my lord, may I submit?
Yes.
My lord, Girish Ojha died in 2016. That fact we recently came to know from a death certificate that we obtained from Belgium, where he expired.
So, no, that is also recorded. That is also recorded in my order, this review order. That
the plaintiff may take steps, my lord, in carrying out appropriate.
No, that I cannot pass an order because suit is dismissed. Suit is dismissed.
Yes, yes, yes.
That I cannot, but I am only directed department to amend the cost title in terms of this.
In terms of the order, now plaintiff is informed about the Girish Ojha's.
So they have to take steps.
Death, they can take steps. This is well information being flowed because Girish Ojha's death, my lord, was not known to everybody. Yes. No, it was known. It was known to the plaintiffs. Yes, but plaintiff may not feign ignorance, but now they know, so they can regularize it.
Yes.
Through a proper.
We'll take a
No, it has been. This court is also recorded after the order dated. This. It is also confirmed by the parties that the Girish Ojha expired on 9th of June 2016 at Brussels, Belgium.
Yes.
I have recorded this.
Yes. Obliged.
Grateful.
Deeply obliged, your lordship.
In this matter, in this matter, I am on behalf of the plaintiff. The commission is going out right from 8 March 2023. 10 extensions were given by your lordships. 10 extensions. My lord, only 1 hour commission. My lord, I have given a list of dates, my lord. 8 February 2023, commission started. Only 1 hour commission has been held. And my lord, the other side is cross-examining. I cannot stop them. 15 sittings are there, my lord. My only pray before your lordship, my lord, substantial time has been elapsed, my lord. Only, my lord, the other side will indicate that how many sittings they will take. They has already taken 15 sittings. Cross-examination
Cross-examination
of three of the PW3
PW witness is going on still.
Yes, my lord.
still.
I am recalling all these things. Let them come in before.
My lord, let them come before.
The commissioner.
My lord,
Kindly give
because it is
I am recalling all these things.
My lord.
Commissioner fees also I am recalling.
it is too
Let-
much.
You are playing
It
with
is
the
too
court. 2023 appointment commissioner was appointed 15 seating. By 15 seating, this court would have been disposed of whole suit.
my lord, kindly give liberty to file, my lord,
My-
the report as on date, my lord. The super the
So plaintiff witness has not been examined, and when the defendant witness will be examined.
my lord.
If you are not having the guts to tackle the parties, why you are taking the burden of commissioner?
My lord, on the different occasions, the plaintiff
Why you not inform the court?
and my lord, the witness is taking too much time. My
So why you not inform the court? 3 years.
The witness.
I will pass an order. You return the amount along with the interest.
my lord, if your lordship kindly give directions to the file the report, my lord, then I will file.
What report?
My lord,
Every time you have a liberty, if the parties are not coming to you and not
no, my lord, 35th number of sitting has been held, my lord, and the depositions of the depositions of questions number 537 has been recorded, my lord.
15 sitting. So you are also need not to come to the court. Every sitting you will get your fee.
My lord.
My lord, the witness is taking time. my
Need
lord,
not to
too much
appear the court. You are earning your own fee from the commission.
My lord, if any question is put to the witness, she is taking too much time to indicate that particular documents, my lord. And my lord, there are
And for 1 hour, after 1 hour, they are telling there will be a double the sitting.
You are
After
appearing for whom?
for the plaintiff, my lord.
Then who is for the defendant? Who is for the defendant?
my lord,
Let the issue notice to the defendant. Let matter come to Monday on as to be mentioned. The matter is listed as to be mentioned for filing report by the commissioner appointed by this court for examination of the witness on commission. Full stop. Counsel for the plaintiff submit that the commissioner was appointed by an order dated 8th of February 2023. Till date, the examination of the plaintiff witness is going on and 15 sitting has been held. Again, the commissioner is praying for time extension of time to complete the commission. Though none appears on behalf of the defendant, for giving an opportunity of hearing to the defendant, the case is adjourned. Let the matter appear on Tuesday as to be mentioned. Tuesday, what is the date? And what is the date?
My lord, total 35 sittings. My lord, Tuesday, my lord, Tuesday, I have a problem. My lord, any day, Wednesday, I have a doctor's appointment on Tuesday.
Then Monday, Wednesday?
Yes, my lord.
On 6th of August 2025, the plaintiff is directed to, plaintiff as well as the commissioner is directed to inform the date to the defendant.
But it was actually 35 sittings total.
35
sittings.
35 sorry.
I pay for the defendant back, my lord.
Yes.
And for the plaintiff lordship, this was that section 8 matter. The
What has happened in the Supreme Court?
SLP has been dismissed, my lord.
SLP has been dismissed on the ground that the documents that were produced before the mediation, we should not have filed an FIR. So on
Correct.
that ground, but the order has not come. Lordship keeps it on to be mentioned on Monday. Probably by that time, the order will be there. Lordship will record the order and then
SLP, main SLP or the interlocutor? Main SLP.
main SLP.
So, what can be
Nothing will remain in the suit, but I'll.
That forged documents were given at mediation. We have filed an FIR. The Supreme Court got angry with that.
That FIR, the police has given a report that the documents are not forged.
That we have challenged the Naraji petition and it was allowed. It was allowed.
But it cannot be said that it has been forged document.
I don't think
Whatever. We do not. I do not
how
need.
two persons are taking the benefit of the document of the mediation.
Mediation, my lord.
The law provides.
No.
Then
That is where it got.
the court also cannot go into the documents or the submission relied in before the mediation.
That is exactly the problem that we had faced.
Yes.
As per the submission made by the consul for the plaintiff, let the matter appear on 6th August for to be mentioned.
Yes, by that time the order will be there. Highly obliged.
Yes.
Mention this matter for correction.
Matter number 3.
Yes, sir.
Yes.
I appear for the plaintiff petitioner, Your Lordship.
For correction of your lordship.
Lordship, Your Lordship, this is my suit for eviction of the tenant. By Your Lordship, last order dated 22nd July, Your Lordship had given them a week to file the additional little statement, which they wanted to, because there were 2 paragraphs missing from the plaint, which they were supplied to it later. And Your Lordship had disposed of the GA2. What is before Your Lordship today is only GA3, which is my application for occupational rent, which has been fixed 3 weeks hence from date of the order. So I believe this has come up at the defendant's behalf.
For GA2, my lord, I have praying for correction of the order, my lord. In the last line, my lord, it is submitted, it was recorded in the order that, my lord, the written statement is affirmed, additional written, but it is not affirmed, my lord.
Mentioned before the court.
My lord, it was, my lord, it was only stamp punch I have mentioned, my lord. Somehow, my lord, there was some mistake.
Still you are not affirmed them.
My lord, I could not, because, my lord, the stamp punch was of 3 months before, my lord, of April, and my lord.
What will you do?
My lord,
The court is not going to correct any. Yes, call the.
From my lord, if your lordship,
Sorry.
kindly, my lord, I won't be able to file the additional written statement, my lord. I won't be a file, my lord. Extension, my lord. Without extension, my lord, I won't be able to file.
Call the matter. Call the matter.
But I'm appealing.
Grateful.
This was mentioned at my instance yesterday, Miller. My written statement is ready, Miller. It couldn't be affirmed because the court fees couldn't be paid because of the name of the defendant contains Messrs, which contains a special character. So I was praying, my lord, that kindly grant me leave to get it stamped and affirmed today. Within the
when you receive the writ of summons?
It was, I'll just.
7th of April, my lord.
7th April, yes.
7th April.
Yes. We have time till 5th of August.
So what do you want now?
Ready to get it stamped and affirmed, and the official court fees should be leave to deposit.
When your 120 days going to be over?
5th August.
5th of August.
5th of
August.
So okay, I am fixing on 4th.
But the difficulty is online. I'm unable to pay. If
Why?
I apply it, I'll get only 4 days, in which we'll not be able.
Okay, I am granting leave to file the return statement along with the contract and without the court fee. Liberty to file the court fee within a week.
Yes, madam. That is sufficient.
Yes, it is affirmed.
Yes, no, it cannot be affirmed. It is stamp punched.
Leave is granted.
I'm moved.
Leave is granted to file the return statement along with the contract claim without the court fee, with the undertaking that the court fee will be paid within a week by 7th of August 2025. List the matter on 8th of August 2020. Let the matter appear on 8th.
I'm deeply obliged. My lord has listed this matter on
8th.
On 8th. I shall.
Yes.
Well, some led by learned senior counsel Mr. Joy Shah is appearing online.
I had mentioned this matter yesterday.
Yes.
The matter had been kept on my application for injunction had been kept on 7th August. I was in some difficulty on that date, my lord. I was asking for a reschedulement. So, my lord, since there are several senior counsels on the other side also, it was, my lord, at their request placed as to be mentioned so that at a convenient date, my lord, could be, my lord, granted by your lordship. My lord, subject to, my lord, what, my lord, your lordship, my lord, I was, my lord, praying, my lord, kindly permit me to come to your lordship, my lord, either 4th evening, Monday evening, or, my lord, Tuesday morning, my lord, any day. That is, Monday. I will not take much time, my lord. Just.
अब कुछ है डेट है क्या? हाँ? 7th August. Who is for the other side? You.
I'm there. I am for respondents number 5 to 15.
When you 11th you will be available?
11th. Well, in that case, kindly have it on 14th, my lord.
14th in.
If your lordship diary permits.
The other party is having some difficulty.
Sir, 4th করলে হবে স্যার
My lord, I'm not available from 7 to 24.
7 to 24.
I yesterday.
Yes, my lord, my friend had called me, my lord. He has some medical emergency, my lord, for which he has to take somebody, my lord, to Chennai, my lord, for some.
28. देखो कोई है तो टाइम नहीं है 11:30 12:30 12:30 भी नहीं है okay let it fix on 27th August
27th, my lord. My lord, I have obtained leave, my lord, from your lordship under 12A. They have also taken out an application for revocation of that leave. 27th is all right, my lord. Very well. I'll come at 27th. Any day, my lord. Any time that your lord.
Thank you, sir.
Is it your lordship pleasure to, my lord, allot any time, my lord?
time is difficulty it will be in 28 3:45 28 क्या Thursday okay 28 at
my lord, 27.
28 at 3:45
27.
28 at
28 your lordship is keeping.
3:45 p.m.
My lord, kindly keep it on 27th, my lord. Requesting my friends, my lord, it will be done on 27th, my lord. Any time, my lord.
Made by the council for the plaintiff on the ground that the matter is fixed on 7th of August 2025, but the council for the plaintiff is having some personal difficulties. Accordingly, the hearing of the case is rescheduled to 27th of August 2025 instead of 7th of August 2025. Let the matter appear on 27th of August at the top under the heading new motion or adjourned motion?
New motion, my lord. It's
New motion.
Under the heading new motion.
Both the
My lord,
applications.
I am very grateful, my lord. My lord, your lordship has recorded personal difficulty. It's not personal difficulty, my lord.
Due to some personal. Okay. I will. Due to
lordship. I am so grateful.
Difficulty na. So due to some praise for fixing the matter to some other date.
I am so grateful.
Yes.
My lord, I appear on behalf of the plaintiff, my lord, pursuant to your lordship's leave for correction of necessary correction. I have made it. Now I am praying for leave under clause 12 of patent.
Made all corrections.
Yes.
Report.
Report
आया कैसा करेक्शन कहाँ से पता चला फुट पे दे दिया फुट पे किया Yes, why clause 12?
Clause 12.
Why clause 12?
Well, because the plaintiff's office is situated within the original side jurisdiction and the defendant's office is situated outside original side jurisdiction. And most of the transaction has been made in the office of the plaintiff and the part cause of action is made within the jurisdiction.
The plaintiff has filed the present suit praying for a decree for a sum of rupees 15,67,911 along with interest at the rate of 18% per annum. Counsel for the plaintiff submit that the plaintiff is within the jurisdiction of this court and dependent is outside the jurisdiction of this court. He submitted part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Consider the submission made by the counsel for the plaintiff, peruse the materials on record, leave under clause 12 of the latest patent is granted, subject to scrutiny by the police is granted, plaint is admitted, subject to scrutiny by the department.
Get to lordship.
Yes.
Let's second one is same pair, same leave was granted, correction has been made.
Same outside within.
Grateful to lordship.
Yes, next.
Item number 8.
Lordship, in item number 8, I am appearing on behalf of the plaintiff. On the last occasion, Lordship was granted leave to make correction under Article 12 of the Letter Patent Act, Lordship. Accordingly, we may have made the corrections. Lordship, kindly issue writ of summon upon the defendants, Lordship.
Why writ of summon? Why mention? Why you are not lodged the writ of summon before the
Lordship, there is no direction by your Lordship. There
There's
was
no
only
necessity. If the print is otherwise so ready, then you have to lodge the writ of summon.
Lordship, we will serve the
How many defendants?
there are, Lordship, 10 defendants, Lordship.
Scrutiny has been completed. Scrutiny is done.
Yes, Lordship.
Counsel for the plaintiff submitted. Scrutiny has been completed and placed for you to lodge for lodging writ of summons. In view of the submission made by the counsel for the plaintiff is directed to lodge the writ of summons within a week from date.
Oblige, Lordship.
Next.
Lord, your Lordship had directed me to consider my Lord Dhanbad Wells and come back today. I have done that. Well, I want to just show certain paragraphs of two judgments, my Lord, subject to only one thing, my Lord. If your Lordship is not convinced, my Lordship will permit me to withdraw with the court fees, my Lord. Two paragraphs from Dhanbad Wells and one paragraph of Yamini Manohar, and my Lord, 3 paragraphs of the plaint and 1 document. That is all that I want to show your Lordship. My Lord, first is, my Lord, paragraph 43 of my Lord Dhanbad Wells. Where Lord Yamini Manohar has been considered. Lord, it does not say that Yamini Manohar is not good law because Lord,
no, it is relied.
Yes, my Lord. Now, in that context, paragraph 44, my Lord, of Dhanbad Wells. Thus, it becomes clear from perusal of the aforesaid decision that the test under 12A is not whether the prayer for urgent interim relief actually comes to be allowed or not, but whether or not an examination of the nature and subject matter of the suit, the cause of action, the prayer of urgent interim relief by the plaintiff could be said to be contemplable when the matter is seen from the standpoint of the plaintiff. From my standpoint, my Lord, in the case at hand, indisputably no urgent relief was prayed for at the time of institution of the suit. Here, my Lord, I am praying for an urgent relief. The application is ready. Now, my Lord, that paragraph of Yamini Manohar, which I am relying upon, is, my Lord, paragraph my Lord 8. Yamini Manohar ta dao. No, in fact, paragraph 10, which is on the last page. Well, we are of the opinion that when a plaint is filed under Commercial Codes Act with a prayer for urgent interim relief, the commercial court should examine the nature, the subject matter of the suit, the cause of action, the prayer. The prayer for urgent relief should not be a guise in the mask to wriggle out of 12A. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. Non-grant of interim relief at the ad interim stage when the plaint is taken up for registration and admission will not justify dismissal of a commercial suit. Now, my Lord, if your Lordship is pleased to take the plaint once. Page 84.
Yes.
My Lord, it's from the defendant to, my Lord, the plaintiff. He writes, "Dear Mr. Mano, just to update you, due to delay in the supply of packaging material, our shipments got delayed. We would definitely be able to pay you the 50% in the coming week as committed." This is 1 year back. When this light, my Lord, paragraph 7, 8, and 10 of the plaint, if your Lordship is pleased to consider. 7 is, my Lord, I have said that despite repeated assurances, they have failed and neglected to make payment. And, my Lord, contrary to, my Lord, the acknowledgement and of the admitted liability, and they have admitted it, my Lord, in an email. And my final demand is of June 25. They have not paid. My Lord, in this context, my Lord, I will also beseech your Lordship to kindly consider, my Lord, paragraph 41 and 42. My Lord, in fact, my Lord, 42.7 of Rahul S. Shah. Yes, my Lord. Well,
for contemplation.
Yes, my Lord. But that is in the petition, my Lord, because
contemplation, you read the Garville.
Yes, my Lord.
And the Asha Enterprise.
Yes, my Lord.
That has been defined. Okay, whatever.
Lordship, kindly, my Lord. If your Lordship thinks, my Lord, then we'll come back. Otherwise, it's entirely in your Lordship's discretion, my Lord. But the circumstances from the standpoint of the plaintiff is such that it contemplates urgent relief. That is all that I'm saying.
Why? Because see, it is 2024.
Yes, my Lord.
2024
yes,
is
my Lord.
admitted. He will
1 year I have waited. That is
That is the problem. And if there is an evidence that they are siphoning off immediately.
Well, that I have stated the company is in a bad condition because there's large dues in the market. That is in the application.
Application.
Well, because the suit contemplates interim relief. The interim relief has to be in the application.
Go to the mediation.
My lord, may I do this, my lord? May I then, my lord, take back the plate?
Correct.
And with
I am allowing you to
Very
withdraw.
Yes, my lordship permits me
Initiate
that.
the pre-mediation, and also I am
No, my
allowing
lord, I'll try and
take the court fee.
No, I'll take the court fees. I'll try and come back with some further particulars. If I may, my lord.
So what,
Lordship
only,
permits.
only to withdraw?
Yes, my lord. If your lordship is not convinced on, my lord, urgent interim relief, then I'll have to, my lord. I'll do that.
Counsel for the plaintiff prays for withdrawal of the present suit with the liberty to file a press if any occasion arise. Accordingly, CS form of census dismissed as withdrawn. The plaintiff is and the department is directed to refund the court fee.
The lordship is granted the liberty to file a fresh. So great.
If occasion arise.
Hello, occasion. It's great.
Leave is granted to submit written statement along with the contract without court fee, which we undertaking that court will be by 7th, subject to acceptance of the. Yes, call the matter.
Let's give the. My lord, may I just seek one leave, my lord? My learned friend was addressing your lordship on behalf of the plaintiff.
Okay, you come.
My lord, I'll take 5 minutes, my lord, no more.
You are for the plaintiff 3, defendant number 3.
My lord, only one point I want to argue. My lord, what has fallen from your lordship, my lord, we bow down to it. My lord, an order here, or my lord, a relief claimed here, should not render infructuous, my lord, what has been filed there. So your lordship can make that clear, my lord, I have no problem. But I want to, my lord, show your lordship one thing. My lord, kindly, my lord, so that your lordship doesn't have to turn all the, give them a copy. Yeah. Your lordship doesn't have to turn all, my lord, so many pages. Copy. My lord, I have made a compilation.
Yes.
My lord, of all, my lord, where is my iPad?
It's open security.
Now, my lord, kindly see, my lord, the first demand, my lord, is, my lord, a letter dated 7th April 2025. My lord, from my lord, if your lordship has a look at the index, it gives all the page numbers, my lord, of my lord, the documents. And all of them have been placed before your lordship.
Thank you.
My lord, kindly, my lord, come to, my lord, the first, my lord, page, my lord. This is, my lord, the letter of 7th of April 2025, page 561.
Yes.
It is, my lord, kindly note one thing. It is by the lender, which is Piramal Finance, who is, my lord, the party to the loan agreement. My lord, this is for overdue TDS, nothing more.
Correct.
Now, my lord, there is a letter, another letter of 7th April, my lord, which is, my lord, also, my lord, by Piramal Finance. My lord, at page 3 of the compilation, my lord, this, my lord, relates to, my lord, the loan agreement. And your lordship, my lord, will find, my lord, that the demand here, my lord, paragraph 3 at page 4. Please note that borrower has defaulted in repayment of principal and net interest due payable as per the terms of the loan agreement as on 5th April 2025, that is so and so. Despite repeated requests, you have failed and neglected. So it's an event of default. No problem. In view thereof, kindly note this. We hereby call upon you to cure the default forthwith and make repayment of the balance net outstanding amount within 7 days. So, my lord, there is a opportunity given for, my lord, curing the default. My lord, on, my lord, 7th of April, which is, my lord, of 7 days.
Correct.
Because, my lord, the default occurred, event of default, my lord, was of 5th of April. Now, kindly take the third letter, my lord, which is a letter of 15th April 2025 from Piramal Trustee Services. My lord, it's at page 567.
Yes.
Now, my lord, they are not the lender. Kindly mark this, my lord. They are, my lord, not the lender. But, my lord, they say, my lord, at page 7, my lord, of the compilation, page 567, we Piramal Trusteeship Services Private Limited, acting as security trustee, write to you on behalf of the lender with respect to the loan agreement. Now, my lord, kindly come to page 8. I'm doing that. Page 8 of compilation, my lord. Kindly have a look at page 8 of compilation.
Yes, yes.
Clause 2. The total overdue amount in due and payable as on 14th April 2025 under the loan agreement is 15 crore 80 including penalty. In the above circumstances, we hereby provide a final opportunity and call upon you to repay the overdue amounts and cure all the defaults forthwith within another 3 days of receipt of this notice. So this, my lord, is not written directly by the finance company. It is written by the security trustee, but on behalf of the finance company. Now, my lord, kindly come to 22nd April, my lord, 2025. This is, my lord, written by, again, your lordship will find, in this case, the lender, yes. Piramal Finance. Kindly turn over, my lord, the page. My lord, it's page 10 of the compilation, page 570 of the petition.
Yes.
My lord, paragraph 2. The total overdue amount due and payable as on April 22 under loan agreement is 15 so-and-so, including penal interest. In the above circumstances, we provide a final opportunity and call upon you to repay the overdue amounts and cure all the defaults. It's immediately on receipt of this notice, failing which. So again, my lord, an opportunity, my lord, is given to cure. Now, my lord, kindly come to, my lord, page, my lord, the next document, which is 28th May. My lord, on respect of which, my lord, a lot of submissions have been made. Now, my lord, kindly have a look, my lord, at, my lord, the loan agreement. My lord, I'll trouble your lordship here. My lord, the loan agreement. My lord, it starts at page 156. 1 minute. My lord, it's volume 1, my lord. Volume 1.
Yes.
My lord, kindly come to, my lord, the loan agreement, which is at page, my lord, 156. Yes. Kindly come to clause 16 at page, my lord, 170.
Yes.
Now, my lord, kindly see each of the events or circumstances set out in the following subclauses of this clause 16 is an event of default. It is hereby agreed to between the parties hereto that the lender shall have the sole discretion to determine whether an event constitutes an event of default. So, my lord, now it's the decision only of the lender, and the lender shall have the right to exercise such right to determine an event of default at its sole discretion and without any recourse to the borrower, and that such determination by the lender shall be final, valid, and binding. So, my lord, they are, my lord, to determine, my lord, whether, my lord, there is, my lord, a default. Then, my lord, 16.1. Non-payment. The borrower does not pay on the due date any amount payable pursuant to a finance document.
Yes.
So, my lord, here, there has been a default. My lord, till, my lord, April, my lord, 22, as your lordship has seen, my lord, opportunity is being given to cure the default, which is only to the extent of 15 crores odd, including, my lord. Okay. Now, my lord, if, my lord, an event of default occurs and, my lord, it is not cured, kindly come to clause 17, my lord, which is, my lord, at page, my lord, 173. My lord, right at the bottom.
Yes.
On the occurrence of an event of default, the lender, kindly mark the words, it has to be the lender. The lender may in that event have the rights described hereunder, and the rights available under applicable law as well as under any security document created in accordance with these terms and conditions. So now, my lord, what is the right? The right is
cancel or terminate the
cancel or terminate any available commitment. Now, my lord, kindly see 17.1.2. This is very important. Declare that all or part of the loan, together with accrued interest and all other amounts accrued or outstanding under the finance document, be immediately due and payable, whereupon they shall become immediately due and payable. So, my lord, if there is an event of default, I have not cured it, this is open to them. To, my lord, then demand the entire amount. But, my lord, greatest of respect, who can do the recalling? This is under the loan agreement by the lender. Now, kindly have a look at, my lord, 28th of May, 2025. It is issued by the trust security trustee. It is not issued by the lender. My lord, page 587.
Yes.
Now, my lord, the security trustee, my lord, has no right to recall. Under the loan agreement, it is only, my lord, the lender, my lord, who can, my lord, recall.
Yes.
Now, this document, kindly now come to, my lord, the letter of 13 June 2025, which is page 20, my lord, of, my lord, the compilation. Now, kindly see, my lord, who writes this. Again, my lord, the security trustee, not, my lord, the lender. And, my lord, kindly see page 595 bottom. My lord, item 4. My lord, 28th May 2025 is referred to as a recall notice. But recall notice is not by the lender. Then, my lord, kindly come to compilation page 21. My lord, page 590, which is page 596 of the petition. As you are aware, vide the recall notice, the facilities amounting to 106 crores loan extended under the loan agreement inter alia stood recalled. Now, my lord, with the greatest of respect, there is no recall under the loan agreement. A security trustee, my lord, cannot, my lord, under the loan agreement, declare everything to be, my lord, due and payable.
Yes.
That has to be done by the lender. Now, my lord, kindly see, my lord, para 2. In view of recall of loan, how? My lord, by the letter of 23rd May, the total amount of so-and-so became due and payable by you as of 11th June 2025. Pursuant thereto, by our communication dated 9 June, it was informed, these are not recall notices, that a total of so-and-so is outstanding and is due and payable. Despite this,
You still fail to neglect.
yes. My lord, my lord, they can, my lord, I am, my lord, only showing your lordships, my lord, that today, my lord, even today, till today, my lord, there is no, my lord, recall notice for the entire amount. Because, my lord, what was argued before your lordship is that, my lord, before the amount was paid,
Yes.
my lord, 2 days before, my lord, they had, my lord, filed, my lord, the section, my lord, section 7 proceedings. My lord, before, my lord, the, my lord,
IBC.
my lord, and to before the adjudicating authority. My lord, maybe, but my lord, that default, my lord, today, my lord, has not resulted in a recall notice for the entire amount. And my lord, thereafter, my lord, what was outstanding of 15 crore or, my lord, has been paid. And Mr. Shah made a submission, my lord, yesterday, that, my lord, the next, my lord, due amount has also, my lord, been paid. My lord, those are my submissions.
Thank you. Thank you.
Do you want to show this?
No, I do not.
Thank you.
Obliged.
Well, I'll try to, my lord, sum it up very briefly. My lord, your lordship has heard us, my lord, for the most part. My lord, there are just some issues, my lord, which needs to be clarified. Your lordship has already heard Mr. Mukherjee on, my lord, why the recall notices are bad.
Yes.
I will not labor on that anymore. I will not repeat myself. But the fact is that ultimately, come what may, only one thing your lordship has seen. At times they give 3 days, at times they get 7 days, at times they get 15 days. Why? Because the agreement by itself does not specify as to what is the period within which you may cure the default and what is the period after which you cannot cure the default. That is why the discrepant periods in the different letters, sometimes 3 days, sometimes 7 days, sometimes 15 days. And I've pointed out to your lordship that ultimately, this is an arbitrary imposition because they can't say as to we must cure it within 3 days or 7 days or 15 days, because 2.3 says that I may cure by paying default interest, and even if I do not pay the default interest, that can also be cured. So that is my submission so far as this is concerned. So no specified period within which the default has to be cured for the purpose of invoking the default interest provision under clause 2.3. And the fact is that it has been cured.
Yes.
Your lordship has also seen that where no time is specified, then it is the reasonable time concept that applies. And for that the Supreme Court judgment has been cited before your lordship. I don't want to trouble you. Third thing, your lordship has also been said that in any event, the purported default that has been committed is waived. And in that context, your lordship has also seen the judgment as to what would amount to waiver. Now, here, waiver is that when I accept the default interest, then the question is if I'm saying that I'm recalling the loan, then how can I accept the default interest? Here, they've accepted payment of the default interest. I've showed your lordship that. And the second submission that I had made in this regard was with regard to section 59 of the Contract Act, which says appropriation of payments. If I make the payment in respect of a particular component of a debt, then it must be applied to that component and nothing else. Now, if your lordship now sees, I've then shown your lordship the Indus Biotech judgment, which shows us to what would be the scope of adjudication. In that matter, your lordship remembers, in Indus Biotech, I placed paragraphs 34 and 35. The question was as to whether a debt exists or not should be first determined in arbitration. And the Supreme Court said that yes, the NCLT was right, because the NCLT says I can't decide these questions. It must first be decided in arbitration. If the arbitral tribunal holds that yes, this is a quantified or crystallized debt, then of course you can file a section 7. But otherwise your section 7 is premature. That judgment I have shown your lordship. Now, all that is left is if your lordship sees now the section 63 argument. Section 63, your lordship has seen the language. It is very clear. Only subject matter which the NCLT can adjudicate. Now, so far as this is concerned, my learned friends have shown your lordship the innovative judgment. Let me straight away deal with the innovative judgment first. Just 2 paragraphs I want to show you, lordship. Paragraph page 437 of the judgment. Innovative is, 2018 1 Supreme Court cases 407.
Yes.
Just 2 paragraphs. What is the scope of adjudication? Let us understand. I don't want to show you lordship section 63 or 231 again. I'm sure lordship is tired of that now. Please see just 2 paragraphs. These are paragraphs on which Mr. Sarkar had also relied on. I want to read them in perspective. The scheme of the code is to ensure that when a default takes place, in the sense that a debt becomes due and is not paid, the insolvency resolution process begins. 27 and 28.
Yes.
Yes. The scheme of the code is to ensure that when default takes place, in the sense that a debt becomes due and is not paid, the insolvency resolution process begins. Default is defined in section 3, subsection 12 in very wide terms as meaning non-payment of a debt once it becomes due and payable, which includes non-payment of even part thereof or an installment amount. For the meaning of debt, we have to go to section 3, subsection 11, which in turn tells us that a debt means a liability of obligation in respect of a claim And for the meaning of claim, we have to go back to section 3, subsection 6, which defines claim to mean a right to payment even if it is disputed. The code gets triggered the moment default is of rupees 1 lakh or more. Now it's 1 crore. The corporate insolvency resolution process may be triggered. Now, this is very important. By the corporate debtor itself, that's the section 10 proceeding voluntary winding up, or a financial creditor or operational creditor. Now, I cannot initiate this. So, I cannot go there seeking a declaration that my pledge should be protected, my mortgage should be protected.
Yes.
And that is exactly where your lordship has seen the judgment in the case of Nahar Industries.
Yes.
A distinction is made by the code between debts owed to financial creditor, etc. I will not trouble you with that. Then 28. When it comes to a financial creditor triggering the process, then when it comes to the operational creditor triggering the process. So, I'll not read the whole paragraph. It says, it can be triggered by the corporate debt only in case of a voluntary insolvency proceeding, or by a financial creditor, or by an operational creditor. I cannot go there seeking a declaration that I have a right to protect my my pledge or my mortgages. Now, here, therefore, the confine is very limited. It is, a proceeding initiated by a financial creditor or, an operational creditor for determination as to whether there's a debt and a consequent default in payment of the debt. I am not, asking for any of that adjudication. If, the NCLT is approached, NCLT is completely free to, adjudicate the question. In the context of, my pledge and my mortgages, what am I saying? You don't even have to approach a court. You can simply, invoke the mortgage or the pledge. In that case, will I be left with recourse? Now, in this context, please see the Cotton Corporation judgment, which my learned friend had showed. Let kindly see, Cotton Corporation has to be placed in the proper perspective. Let kindly see what it says. Please see paragraph 8 and paragraph 9.
Yes.
Allow me to please read it a little slowly. It is therefore necessary to unravel the underlying intentment of the provision contained in section 41(6). It must at once be considered that section 41 deals with perpetual injunction, and it may well be considered that it has nothing to do with interim or temporary injunction as provided under section 37 are dealt with by the Code of Civil Procedure. To begin with, now this is the important part. To begin with, it can be said without fear of contradiction that anyone having a right that is a legally protected interest complains of its infringement and seeks relief through the court must have an unhindered, uninterrupted access to law courts. Now, today, this right that I am seeking to exercise is being sought to be thwarted by saying that, you are in effect seeking an injunction. No. All the cases, your lordship will find, almost without exception, that, parties had come to court specifically seeking restrain the initiation of a proceeding. All that I am saying is, today, I cannot wait for the insolvency court to come to a conclusion as to whether there's a debt of default for the purpose of protecting my pledge.
Yes. Yes.
Let's please also, in this regard, just see one line at paragraph 9. Viewed from a slightly different angle, it would appear that the legal system in our country envisages obtaining of redressal of wrong or relief against unjust denial thereof by approaching the court set up for the purpose and invested with power, both substantive and procedural, to do justice, that is to grant relief against invasion or violation of legally protected interests, which are jurisprudentially called rights. If a person complaining of invasion or violation of his right is injuncted from approaching the court set up to grant relief by an action brought by the opposite side against whom he has a claim and which he wanted to enforce through court, he would have to first to defend the action, establishing that he has a just claim, and he cannot be restrained from approaching the court to obtain relief. I am alert on this. I cannot approach the NCLT for obtaining this relief. I have to approach your lordship's court. And my lord, today it can't be therefore said that you are by a device trying to prevent me from filing my Section 7 proceeding. No. Section 7 proceeding is against the borrower. Cannot be against, my lord, the pledger or the mortgager. It can also cover a guarantor. But, my lord, that is not the case here. My lord, we are concerned with our pledge and mortgage immediately. My lord, so therefore I have no right of accessing. Then, my lord, will my right, my lord, to seek relief through a court which I may otherwise access be thwarted by, my lord, citing Section 41B. Whole purpose of 41B has been spelled out in Cotton Corporation judgment. Now, my lord, so far as this is concerned, in this context, my lord, I'll just show you, lordship, my lord, two small paragraphs of two judgments.
What would be effect if the interim order is passed? What would be effect of this?
No, my lord, your lordship will say that, my lord, I will not, my lord, you can't, my lord, ultimately rely on these notices for the purpose of invoking the pledge, because your lordship will have to, for the purpose of, my lord, deciding the lists here, my lord, decide as to, my lord, where there's a default. My lord, if there's a default, they can invoke the pledge, or, my lord, ultimately enforce the mortgage. But if there's no default, they can't. But, my lord, that does not mean independently. My lord, when the NCLT is approached, NCLT's, my lord, scope of adjudication is different. It will see, my lord, if is there, my lord, default, my lord, insofar as, my lord, the books of records, etc. are concerned. My lord, that is independent adjudication. That is vis-a-vis by the borrower. Here, your lordship is deciding the matter in the context of, my lord, the case brought. I am, my lord, confining myself only to the interim application. Case brought by, my lord, the pledger and mortgager.
Correct.
So, my lord, I am not saying that your lordship will make it clear. The court has, my lord, always the power to mold reliefs. Your lordship will make it clear that, my lord, this will not otherwise influence, my lord, the proceedings that have been filed under Section 7, according to my learned friends.
Okay.
There is no difficulty there. My lord, only, my lord, two short paragraphs of, my lord, two judgments. Huh? Everyone wants to, my lord, interrupt me.
No, I'm not interrupting.
Yes. No, it
Well,
is
just two small properties. Well,
it is an
ultimately,
interesting subject. That is.
yes.
I just didn't want Mr. Shah to close the argument on our behalf. That's all.
No. Embassy type. I'll not show all the judge. I just show two embassy. Well, this is, well, the other judgment. Well, judgment I want to show embassy properties. Well, this is. Well, please see paragraph 30. I'll not, well, cite too many paragraphs of this judgment. Although, well, there are several very interesting paragraphs.
Para 30?
30. Let me see what the Supreme Court says. The NCLT is not even a civil court, which has the jurisdiction by virtue of Section 9 of the Code of Civil Procedure to try all suits of a civil nature, excepting suits of which their cognizance is expressly or impliedly barred. Therefore, NCLT can exercise only such powers within the contours of jurisdiction as prescribed by the statute, the law in respect of which is called upon to administer. And then, my lord, hence let us see how the jurisdiction powers conferred upon the NCLT. Now, my lord, here, my lord, the question was one of renewal of a lease. And, my lord, the argument was that you cannot seek not to renew the lease or to terminate the lease, because, my lord, ultimately that would interfere with the resolution process. The NCLT held, the Supreme Court held, no, you can't interfere in matters of contract. My lord, I shall just show your lordship that. My lord, just see paragraph 31 once. NCLT and CLAT are constituted under the IBC, but under sections 408, 410 of the Companies Act, without specifically defining the powers and functions. Section 408 of the Companies Act simply states that the central government shall constitute a national company law tribunal. Let us, my lord, ignore that. Then please, my lord, have a look at paragraph 36. Interestingly, there are separate provisions in both Part 2 and Part 3 of the IBC 2016 ousting the jurisdiction of civil courts. While Section 63 contained in Part 2 bars the jurisdiction of a civil court in respect of any matter on which NCLT and CLAT will have jurisdiction, Section 180 contained in Part 3 bars the jurisdiction of civil courts in respect of DRT, DRT. My lord, we are not concerned with that. So, my lord, here it's spelled out again that expressly, my lord, what is, my lord, within the ambit of the NCLT and CLAT to decide. Then paragraph 37. Or, my lord, kindly ignore paragraph 37. Please come to paragraph 40. Well, I'll ignore paragraph 40 also. I'll just confine to paragraph 41. Therefore, in the light of statutory scheme as culled out from various provisions of the IBC, it is clear that whatever the corporate debtor has to exercise, wherever the corporate debtor has to exercise a right that falls outside the purview of IBC, especially in the realm of public law, they cannot, through the resolution professional, take a bypass and go before the NCLT for enforcement of such right. And well, at paragraph 45, we'll actually find that, my lord, here the question was of the government's refusal to extend a lease.
Yes.
Paragraph 45, a lot of stress was made on the effect of section 14 of IBC on the deemed extension of lease, but we do not think that the moratorium provision in section 14 could have any impact upon the right of the government to refuse extension of lease. And then we decide that, my lord, paragraph 46, therefore, in fine, our answer to the first question would be that NCLT did not have jurisdiction to entertain an application against the government of Karnataka for a direction to execute supplemental lease deeds for the extension of the mining lease. Now, my lord, therefore, my lord, the confines of NCLT's jurisdiction is recognized and, my lord, is accepted. Well, that is, my lord, what becomes very important. And, my lord, ultimately, in the course of saying all that, two things, my lord, that emerge. Number one is, my lord, so far as the civil court's jurisdiction is concerned, it can't be, my lord, ousted, my lord, for everything and everything. It's, my lord, specifically, ouster must be limited to jurisdiction that NCLT can exercise. NCLT cannot exercise jurisdiction over a non-borrower, who is, my lord, a security provider. And, my lord, cannot decide these questions of, my lord, validity of pledge, mortgage, their enforcement, etc., etc. And, my lord, one more judgment, just, my lord, to complete this narrative, Tata Consultancy. টাটা কনসালটেন্সি আমাকে দেখালে তো তোমরা হ্যাঁ টাটা কনসালটেন্সি well I don't know whether pages will tally. Kindly just give me a moment. 16. Para 16, yes. Yes. Well, at paragraph 16, your lordship will please have a look at.
16.
Paragraph 16. Well, the questions were, well, based on the appeal, two issues have arisen for consideration before this court. Whether the NCLT can exercise its residuary jurisdiction under section 60, subsection 5C, IBC to adjudicate upon the contractual dispute between the parties. And, well, whether in exercise of such residuary jurisdiction, it can impose an ad interim order of termination, etc. Then your lordship will please have a look at, well, paragraph 26. 26 and 30, my lord, two paragraphs I should show your lordship. Admittedly, the appellant is neither supplying any goods or services to the corporate debtor in terms of 26, my lord.
In Gujarat Supra.
Yes, your lordship is right. Gujarat Urja. My lord, Gujarat Urja is, my lord, referred to there.
Yes.
And, my lord, then, my lord, makes a distinction. Please see paragraph 30. My lord, 28, my lord, friends want to show you lordship. Gujarat Urja is again quoted.
Yes.
Gujarat Urja, in the contract in question, was terminated by a third party based on an ipso facto clause. That is, the fact of insolvency itself constituted an event of default. It was in that context that the court held that the contractual dispute between the parties arose in relation to the insolvency of the corporate debtor, and it was amenable. Well, pausing here for a moment. Well, ultimately, what the courts held is that if there's a question that arises directly out of insolvency, then, my lord, the NCLT can exercise jurisdiction. Otherwise, no. And, my lord, in this context, paragraph 30, while in the present case, the second issue formulated by this court has no bearing, we would like to issue a note of caution to NCLT and NCLAT regarding interference with the party's contractual right to terminate a contract. Even if the contractual dispute arises in relation to insolvency, a party can be restrained from terminating the contract only if it is central to the success of the CIRP. Well, ultimately, that is the object. And, my lord, CIRP of whom? If the CIRP of the resolution process is borrower, no one else but the borrower. Now, my lord, this, my lord, brings me to the last, my lord, limb. My lord, your lordship will kindly see. Now, my lord, so far as the section 41 question is concerned, your lordship has seen Cotton Corporation. Now, my lord, Cotton Corporation has clearly said that I must be left to exercise, my lord, my right of recourse to justice. Now, my lord, two sections of, my lord, the specific relief act, which have not been interdicted by, my lord, section 41, are, my lord, sections 34 and 38. My lord, kindly see 34. 34 is the right of declaration. I can approach a court, my lord, to seek a declaration of my right. Now, my lord, what is the declaration I'm effectively seeking here? Because when I say that these notices are bad, maybe in the context of only pledge and, my lord, mortgage,
So declaration.
I'm seeking a declaration. And well, that is I'm not prevented from seeking a declaration of under 41. 41 says I cannot ask a court to injunct another court from entertaining an action. Similarly, my lord, please see, my lord, section 38, right to seek, my lord, perpetual injunction. Now, my lord, that right to seek injunction, your lordship will find from the language of section 38, flows from my rights which emanate from a contract.
Yes.
And my lord, my contractual right is that, my lord, I have a right to, my lord, pay, my lord, a loan, my lord, even beyond the stipulated period, if I pay, my lord, default interest on that loan. And I've done that. Now, my lord, just the last sentence with which I want to, my lord, conclude my submission is this, my lord, that, my lord, here at the end of the day, my lord, we are looking at, my lord, three things, my lord, when your lordship always sees, my lord, the balance of convenience, irreparable injury, etc. Now, my lord, the question is, my lord, today, if my learned friends now, my lord, seek to restrain me from obtaining any relief from your lordship on the ground only of, my lord, absence of jurisdiction under section 63 and, my lord, the restrictive covenant under section 41, then, my lord, the question is how will my lord, how will I, my lord, obtain a remedy? NCLT will not give me that remedy. NCLT cannot. On the contrary, my lord, they may get a declaration from the NCLT that yes, the debt is due by the borrower. That's all. But, my lord, that will ultimately not prevent me, my lord, from protecting my rights, because, my lord, I have an independent right to protect my pledged shares and very valuable shares in a company, my lord, in Rajasthan, 66% shares. My lord, the entire shares will be taken away. I will be left, my lord, without any recourse. So, my lord, if I have been able to make out a prima facie case, and well, here, my lord, so far as the prima facie case is concerned, it's not an absolute case. Your lordship is only seeing whether I have an arguable case. If I have an arguable case and I've made out an arguable case, then, my lord, the balance of convenience and irreparable. These are my submissions.
Thank you.
For 5 minutes. When you try an argument after Mr. Mukherjee and Mr. Shah, the best submission is to say, may I just adopt their arguments? And Malad, sit down. That would have been the best, but Malad.
That's why if the group of the advocates are appearing, so we are watching what the submission will meet the seniors. Say we adopt.
Malad, just Malad, today, Malad, I'm just following on what Malad, Mr. Mukherjee and Mr. Shah Malad have already submitted. Malad, I don't know why, Malad, whenever Malad, a civil court, Malad, is to look at, and here, Malad, the High Court is to look at, Malad, a civil dispute, then, Malad, the IBC is thrown at them.
You are appearing for whom?
Malad, I'm for petitioner, plaintiff number 1, Malad. Petitioner 1.
Yes.
Malad, the IBC doesn't say, let's abolish section 9 of the Civil Procedure Code, or let's abolish the Contract Act. Also, let's abolish every other civil remedy possible.
Parameters are different.
Correct. IBC, Malad, is confined to, Malad, its jurisdiction.
Correct.
Which is, Malad, whether, Malad, a section 7, if a filed on section 9 or section 7, Malad, whether it will be admitted or not admitted when there's a debt and default. Now, Malad, in nowhere in our arguments, we have said, please injunct them from following their section 7. I don't know why, Malad, that was picked up quite naturally, Malad, to overcome, Malad, whatever arguments have been made by us, to say, no, look, they're trying to stop section 7. Malad, section 7, Malad, in its own jurisdiction. Yes. We are, Malad, this is, Malad, a case, Malad, which is confined and, Malad, considering, Malad, a contractual dispute with regard to, Malad, invocation of pledge.
Yes.
That is, Malad, the right, Malad, which we are claiming. Now, Malad, very interesting, Malad. And kindly, Malad, keep it in mind, Malad, the defend number 1 and 2 are, Malad, private NBFCs. Because we have also, Malad, submitted that, Malad, there is a malafide intent with regard to, Malad, the question of, Malad, now trying to go after saying that, oh, you have defaulted for the whole amount. Because installments were to be paid, Malad, it had over, Malad, a period of years, Malad, to be paid. You have defaulted, therefore you give the whole money, otherwise we have to pay. Now, Malad, kindly look at, Malad, the bunch, Malad, which was handed over, Malad, by Mr. Mukherjee. Because, my lord, it is our case, my lord, that time has never been the essence of the contract with regard to, my lord, recall payment of the installments. Because what is, my lord, if I don't pay...
Mr. Shah has argued on the other day.
My lord, I just want to show one thing. My lord, kindly look at page 1 of, my lord, that is, my lord, a notice of 7th April
Yes.
2025.
Yes.
Now, kindly see, my lord, paragraph 5. What is the amount time, my lord, given to me, my lord, for 4th line? 7 days.
Yes, 7 days.
7 days. This is, my lord, 7th April 2025.
Correct.
Then, my lord, kindly come to the next notice. Page 5, internal page 7, April 15th.
Yes.
Kindly see, my lord, now page 8. Paragraph 3.
3 days.
3 days. So 7 days, 3 days, it's the same installment. There is, my lord, no fixed time to say, my lord, what is, my lord, there's no contractual. Then, my lord, kindly look at the next notice, my lord, which is, my lord, April 22 at page 9. At page 10, my lord, paragraph 3. Immediately.
Provide a final opportunity.
Yes. So 7 days, 3 days, immediately. Now, my lord, again, kindly look at, my lord, May 28. Which is, my lord, at page 5, internal page 12. My lord, at page 14. At page 14, my lord, paragraph 5, second sign, 15 days. So, my lord, where is it? That, my lord, it is said,
So
it will be...
This notice of the 28th May, forgo the earlier notices. Forgo the earlier notices.
Lord,
First.
Yes. My lord, I'm sorry, my lord. What I'm on is, my lord, there is no days in which, my lord, this is all arbitrary, picked up. Because, my lord, what is the effect of this? They are getting interest along with, my lord, the installment, my lord, which is there. And, my lord, in 5, sorry, my lord, on the question of, my lord, kindly, I'm sorry, my lord, in internal page 13, my lord, on the question of, my lord, forgo, I don't think, my lord, perhaps, my lord, they don't do that. Kindly see, my lord, at the top, item 3, notices issued from time to, including notices April 17, April 15, April 22.
Correct.
So everything. So I'm only showing, my lord, these dates are not meant to be, my lord, sacrosanct.
If there is no essence of time.
Correct. My lord, if, my lord, time is not of the essence, now because what has happened after that? My lord, I paid, my lord, the entire installment of June, which has been accepted by them with interest. Paid in June, April installment. July also now, my lord, paid. Yes. So the question of, my lord, whether they have, my lord, elected to remedy the breach or not is, my lord, very important. Because today, my lord, knows in a contractual situation, if, my lord, there is a fundamental breach, then one can terminate the contract, which is not exactly, my lord, what can happen. If it is not a fundamental breach, then you can accept performance and sue for damages. Now, suing for damages here, of course, means, my lord, getting interest on the amount. And that's exactly, my lord, what they have done.
And that provides in the agreement.
Correct.
Provides in the agreement
Correct.
the penal right.
Correct.
Penal interest.
A penal interest. So, my lord, therefore, my lord, it is not that you can now terminate the whole contract, because that's exactly, my lord, what they're trying to do. Now, if you are, then, my lord, that's a disputed question.
So what would be the effect on the penal interest if you are going to recall?
Sorry, my lord.
What would be the effect of the penal interest if the contract provides the penal interest?
Yes.
And he has not paid,
you
are liable to pay the penal interest.
Yes. But
if it is not the contract is not time is not the essence of contract, so which time you can?
Well, when there's a fundamental breach, let us say, my lord, I do not pay, my lord, for the next 6 months.
Correct. That's what I'm telling.
That's
so
right.
When
it has to be such a breach of which is so fundamental in nature, which really destroys the agreement.
Though subject to, then though you are paying.
Yes.
And they are accepting.
Correct. Today, my lord, possible. I do not pay, my lord, for 6 months. They go on repeating and then say, sorry, enough is enough. This is such a fundamental breach. I want to terminate the contract. That is when, my lord, the right arises. Because today, my lord, we are on, my lord, absolutely a purely, my lord, a contractual issue.
When the last payment was made? In the
My lord,
July?
in July.
July, which date you made the payment?
My lord, in the supplementary, my lord, we have said so.
28 July.
Page 44, my lord, 28 July.
28 July, 1 crore 65.
And my lord, we have said also, please note that we have made a payment of rupees 19 through RTG as per attached statement. Please adjust the same towards the installment due on 5th July 2025.
No reply to this.
No reply.
No, they've accepted, appropriated.
My lord, no reply, it's been appropriated. And my lord also knows, my lord, when you write and say that you appropriate against a certain installment, if you do that, then you're accepting it. Otherwise, you can't. When, my lord, if I generally made payment, you could have generally accepted. But when I say, I'm sorry, this is with regard to your July installment, when you accept it, you're accepting it only for the July installment. That's, my lord, under the contract itself.
Okay.
Section 59.
Give the contract. Section 59. Yes, Mr.
Yes. My lord, kindly look at, my lord. It is not that, my lord, they can also play, my lord. It can't be hot and cold. If you accept it, you accept it with regard to that payment. Achha. My lord, this is. No.
Take from Mr. Banerjee. Take from Mr. Banerjee.
এখানে আছে বলা যাবে না My lord, kindly look at, my lord, section 59.
Yes.
Where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances implying that the payment is to be applied to the discharge of some particular debt. Payment, if accepted, must be applied accordingly. Today, my lord, therefore, there is no default with regard to, my lord, either the April installment or the July installment. And this is, my lord, when the matter is going on.
Yes.
My lord, let us be, my lord, very clear. My lord, we cannot and we are not asking for any stay, anything to do, my lord, with the insolvency proceeding. That, my lord, we have to fight out, my lord, our own battle there. Whether there's a debt, whether there's a default or not, my lord, that's a different issue. But today, my lord, here I am concerned with, my lord, the apprehension is that this invocation in breach of the contract would enable someone else to come in and take over, my lord, that bond. And which is, my lord, what we want, my lord, to be stayed, my lord, so far as this is concerned. Now, my lord, very important, my lord, another thing, my lord, my learned friends did not, my lord, today, my lord, as section 7 has been filed, we couldn't stop it, nor can we, my lord, we can't, my lord, go and say, no, no, don't file section 7, I filed a suit here. Section 7, my lord, will take its own course. Today, my lord, it's no one's case that with this, the reliefs I have claimed for, I can go to, my lord, the National Company Law Tribunal and, my lord, say, please grant me an order of injunction. Because this is, my lord, very important. Because if I have a right now, if my lord is today, my lord, satisfied that yes, you, the plaintiff, you have a prima facie case with regard to the contractual points you urge. And, my lord, of course, there is irreparable injury, my lord, if the pledge is, my lord, invoked, when, my lord, I can show that they have accepted, my lord, payment of installment.
Yes.
So if I have that right, my lord, I must have a remedy. My lord, it is not enough. My lord, today, my lord, it's not, my lord, it's like, my lord, whenever, my lord, someone is trying to do something, you put them the fear of, my lord, a ghost or, my lord, something like that. To say, oh, no, look, don't do anything, IBC. Yes. Lord, I do not understand, my lord, we have not taken away, my lord, the High Court. We have not taken away, my lord, the Contract Act. These things, my lord, has to be, my lord, before, my lord, a court and before, my lord, someone, my lord, who has to look at it and see, my lord, whether it is done or not. So, my lord, I think, my lord, those are, my lord, our submissions, my lord. And, my lord, just one more thing. My lord, kindly look at, my lord, that page 274, my lord, I had shown, my lord, kindly just make a note of it. Which again, my lord, I don't think, my lord, it has been really answered. This is Mullah, the pledge agreement. Because I am I am the erstwhile borrower and Mullah, the person Mullah, who's pledged all this. 273, Mullah, sorry, 273.
Yes, invocation of pledge.
Yes, Mullah sees upon the occurrence and during the continuance of the following events. Now, today, Mullah, read with Mullah section 59. Section 59 of the Contract Act. Section 56. No? 55. And Mullah, also section 55 of the contract. Mullah, kindly look at Mullah, these two sections. I think Mullah, we are squarely covered Mullah, under section 55 and 59. Kindly look at Mullah, section 55. Because we are on contractual principles here. We are not Mullah, on anything else. Whether you succeed there or not in the IBC, it's up to you. And not we want Mullah, any restriction on that. Kindly see Mullah, when a party to a contract promises to do certain thing, specified time or certain things, fails to do such thing, before the contract or such, or so much of it has not been performed because voidable option of promise if the intention of the parties was that time should be the essence of the contract. Very important. If time was of the essence, Mullah, time is not of the essence. Then effect of such failure when time is not essence, Mullah sees, if it was not the intention of the parties that time should be of the essence of the contract, contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promisor for any loss occasioned to him by such failure.
Yes.
And Mullah, this is exactly Mullah, what Mullah is happening here. You're taking penal interest. You can't now terminate the whole contract. There has to be Mullah, more than Mullah, a failure of one installment. And when now Mullah, we have paid it off. For you to Mullah breach, because what is happening, Mullah, they have terminated the contract. Asking for the whole money means Mullah, they have terminated the contract and Mullah, they want Mullah, the entire contract to go now. This is Mullah, what Mullah, we are trying to stop. So Mullah, and Mullah, Mullah, in
offer kiya na, what is the answer they give?
Mullah, in the page 40, sorry, Mullah, page 42 of the supplementary affidavit.
Very important. 28 July ko mail hai. Offer to pay for July. What is the answer?
Mullah, kindly look at Mullah. Yes, this is very important. Mullah, page 4. I'm so sorry, Mullah. I'm just troubling Mullah. This is last. Mullah, from Piramal, kindly see page 42. After Mullah, I have offered. They say, please recover.
July installment, they say, please recover. Page 44 दिखाई दे ना. You showed
44. 44 का answer है.
Then answer to.
Mullah, this is an answer, correct. Very important. Mullah, answer to page 44.
1251 का है.
Yeah, please take it. Page 42, Mullah will find. Then Mullah, they say, please recover. Which Mullah, they are going 40 ahead. 40 का
answer. Page 40 भी 28 जुलाई का ही है. हम सुबह शाम करके पेमेंट कर रहा था ना.
So 40.
Sorry, Mullah, page 40. Page 40.
44. You have 44 on 28. You have sent the payment of 19.30.
No, I'm sorry, Mullah. Just kindly look at page 40, Mullah. Page 40. Page 40.
Correct.
Yes, very important. The balance in the account is 165 lakhs. Mullah, this is the PFA statement of Middleton master account. Balance in the account is from the customer collection of the project at 42 Middleton. Thus, you are requested to request the aggregate request to recover the aggregate amount of 165 lakhs from the account towards the installment due on 5th July 2025. To that, Mullah, page 42, they say, please recover.
Page 6.
And Mullah, the current payment, Mullah, are given Mullah at page 6.
No. Kindly see page 40.
Yes, Mullah.
Page 40 sent on 28 at 11:52.
Yeah, 10:31.
11:52.
The time doesn't.
So,
where is the reply to this?
40 and 42 is 10:30. That is prior to that. So this 42.
42 bottom.
No. 42 is connected with the 44. Kindly come to the 44.
Oh, yes, my lord, is correct.
44 you deposited
Correct.
19.3 and send, and they have given yes recover this.
Correct.
So that means the 19.3 was accepted by an email dated email of 10:31.
Correct. I only want to show, my lord, please recover means, my lord, whatever I'm offering for 5th July, they are accepting it. In fact, my lord, page 42, my lord, there's another email, my lord, at the bottom. My lord, says July 8, 1009. There also, my lord, because what was happening, my lord, this is, my lord, getting, my lord, in the escrow account, the money is coming in, my lord, from the flat buyers. And that was the arrangement. As soon as it comes in, my lord, we tell them that please take it and adjust it towards the installment.
Yes.
And my lord, that's what's being done. 42 at the bottom, my lord, will also find.
Yes, Middleton Master account so.
Thus, you are requested to recover the aggregate amount from the account towards payment of 5th July 2025. So April is paid when you ask. And July again, my lord, is paid, my lord, because of, my lord, you ask. And section 59 says it is only appropriated towards that. So you can't say that, no, I have accepted the installment, no, but I will still pretend that there is a fundamental breach of the contract.
Okay.
And, my lord, the table, my lord, which we have given, my lord, all the details, page, my lord, 6. Page 6.
Yes.
And the loan, my lord, has never become, my lord, NPA. My lord, those are submissions, my lord, kindly, my lord. I'm so grateful, my lord. I'm sorry, my lord, I took up the additional, my lord, 10 minutes, my lord, which I'm grateful.
Thank you. Yes.
Lord, I appear for the respondent numbers 1 and 2. We've been hit by 3-barrel gun now today, my lord, and they virtually re-argued the matter. Kindly give us some time next week, my lord, and any convenient date, my lord, in the second half, please.
Sarkar said we are doing nothing now.
That
we are understood.
Well, the arrangement will continue because Mr. Sarkar Malad made a statement, Malad, that they're not doing anything.
That is, of course, we are before court, Malad. We are not going to do anything except what is already being done. Kindly give us some any time next week, tomorrow, other than 6th, please, my lord.
6th, any day, my lord, is
Wednesday of.
My lord, Mr. Sarkar has requested.
Other than Monday and Tuesday.
Yes, my lord.
So any day, fix it. My lord, I'm taking my lord's leave. My lord, I've got a. I'm taking.
My lord, other than 6th, my lord. Monday, Tuesday, and 6th, please. Other than 6th.
Tuesday, Wednesday, 3 दिन हो गया ना.
Friday वो रख दिया ना.
7th या 8th बोल रहा.
That. ठीक है 7 तारीख को मॉर्निंग रख. Learned counsel for the plaintiffs have concluded their argument and reply, but have relied upon one supplementary affidavit as well as 2 judgments. Accordingly, counsel for the defendants prays for time to give reply to the said citations and the supplementary affidavit. In view of the above, case adjourned. Let the matter appear on 7th August at the top under the heading new motion.
All right, the second half, my lord.
Second half तो सब fixed होगा. Already fixed. Second half में सब fixed है. All fixed matter.
3 months waiting, my lord. For second half, 3 months waiting.
3 months waiting. I am passing an interim order, then you come after 3 months.
Now, after hearing us, I'm sure your lordship will change your mind, my lord. Lordships I've heard only once. Your lordship doesn't make up his mind without hearing.
No, yeah, I'm telling. If you want the 3 months, then I'm
only I think my learned friend is requesting because Mr. Sarkar is not in the country. He would appear virtual. That is why he was requesting if it could be second half. Otherwise, my lord, I will address.
Second half, you know, my timetable already fixed matters are there. If any matter is adjourned, then it can be, but without it cannot be.
Now I'm told, my lord, post puja. My lord, second half diary now is post puja.
Okay, come on 7. Let's see to that. In the meantime, what can be.
Very well. Grateful, man.
At 15 minutes, I appear.
Defendant, my lord. I'm led by Mr. Lakmani, who is appearing virtually.
My lord, I'm sorry for not being there physically today.
No problem. Yes.
My lord, if your lordship will kindly take this short supplementary affidavit that I have filed. May I, my lord, just summarize, my lord, the property, if your lordship recalls, my lord, the property, my lord, that I suggest, my lord, I won't, my lord, alienate. My lord, this property comprises 2 small plots of land, a plot number 67 and plot number 68. Now, my lord, these 2 plots have been amalgamated and collectively they are somewhere around 450 square feet. Now, my lord, the shop referred to, my lord, in these documents, my lord, the deed, etc., the shop. My lord, the shop means the land, because, my lord, there are these small plots which are meant, my lord, for shops with extra floors to be constructed. Like a lordship will, my lord, often find on the way to the airport, my lord, many small shops, one after the other, with a G+3 or a G+4 structure, where the land area is small. So, my lord, it's being referred to as a shop, but actually it's a plot of land. Now, my lord, this land has been amalgamated, the 2 plots, on which there is a 5-storied building, basement, ground, first, second, and third. Now, my lord, the second and third floor collectively fetch a rental of 14,000 rupees a month. The first floor, my lord, fetches a rental of 8,000 rupees a month. And, my lord, the ground and the basement, my lord, are privately being used, my lord, by the owner, my clients. So, my lord, this is, my lord, the nature of rental that I am, my lord, deriving from the plot. Now, my lord, as per the stamp duty reckoner, the valuation of each small plot is about 16 lakhs. 16 lakhs. So the my lord, that's, my lord, because valuation has to be done, my lord, plot wise. So, my lord, for each small plot, the value as per the stamp duty reckoner, which is not the market value, my lord, I like to clarify that. This is, my lord, only, my lord, the minimum value for the purpose of calculation of stamp duty. That no matter what price you sell the property at, the minimum that the government will charge you for the purpose of stamp duty would be calculated on this. My lord, on that basis, my lord, this is, my lord, a stamp duty, my lord, minimum calculation. This, my lord, under no circumstances, my lord, is the market value. And, my lord, in that neighborhood, and your lordship, my lord, would be aware in general, the market value of a property, my lord, that the property can actually fetch is much higher, my lord, usually than, my lord, what my lord, is shown in the government stamp duty reckoner for the purpose of calculation of stamp duty. Now, my lord, kindly appreciate this one more thing. My lord, construction price alone per square feet is, my lord, in Calcutta about 2,400 to 2,500 rupees per square feet. Just the construction price of making a building. My lord, they're slightly marginally higher, not very different from Calcutta. My lord, Jaipur just marginally higher, about 2,600 rupees market price of construction of a building. My lord, there is 2,000 square feet in total on this property. Because each story, as I said, my lord, 5 stories, basement, ground, 1, 2, and 3. Each of these, my lord, 5 floors have 400 square feet. So the total floor space area in this building, my lord, is about 2,000 square feet. So, my lord, even if we just merely go by the construction, my lord, price, construction value, my lord, as per the market rate, my lord, would, my lord, be 2,000 into 2,600, which would, my lord, be 52 or 53 lakhs. Keeping aside, my lord, the value of the land. So, my lord, my respectful submission is that, my lord, the claim, my lord, that has been made against me, it's a principal claim of 74 lakhs in one suit, 20 lakhs in the other. Of course, I will argue that this is, my lord, barred by limitation, no documentation on record, nothing. But, my lord, nonetheless, your lordship has injuncted me and that order wasn't challenged. So I, my lord, today, there's an obligation upon me to, my lord, show my bona fide and, my lord, furnish some security to at least safeguard the principal amount. Now, my lord, there are some part payments which I've admittedly made. About 4.5 lakhs as per the pleadings in one suit and about 70,000 as per the pleadings, my lord, in the other suit. So, my lord, about 5 to 5.5 lakhs worth of part payments as per the pleadings, my lord, of the plaints. I have of course paid more, but even if we stick to just the plaints, my lord, there are about 5.5 lakhs worth of payments which I have made as far back as 2011. After which, it's the case that I didn't make any further payments, but there were some confirmations given by a chartered accountant. Those confirmations also, my lord, the emails I'll show your lordship, are of 2014 and 2017. After 2017, the next email is of 2023. So another my lord argument that I would take is that after 2017 for 3 years, if there is no confirmation, assuming that indeed it was my chartered accountant who my lord gave those confirmations, my lord, even then my lord, if for a period of 3 years if there is no confirmation, my lord, the debt becomes still time bound. A confirmation after 2017 ought to have been within 2020. Now, my lord, kindly consider, my lord, in these
yes,
circumstances.
Kindly considers the deed, what they have annexed. This is firstly illegible, and little that we could make out of it. And he takes, Lordship is looking at CS number 650 of 2000.
Supplementary.
Yes, 614, supplementary to the 649.
649, yes.
Yes. Kindly takes the area of the land, which is at page 12. It's a site plan. Page 12 of the supplementary affidavit.
Yes.
At the bottom of the page, total area 18.58 square meters. That comes to roughly around 250 to 300 square feet.
Well,
They have built a 5-storied building with 300 square feet land, and then claiming this is worth crores. And but even if we take both the plots together, that comes to roughly around 500 square feet. 5-storied building on a 500 square feet land they have built. And we have also found out that we have put in the latitude and longitude on the Google Maps. It's a farmland. Kindly take. So. It's a farmland. In the middle of farms they have built. They have claimed to have built this building on a 400 square feet land. 5-storied. And they are claiming each story is costs around how much ever lakhs, and it goes above the claims made in the suit. But how can this be believed? And apart from the deed that they have furnished, Lordship would recall Lordship had passed an order restraining them from operating certain bank accounts. Affidavits were exchanged in that application. Now, the affidavit which has come in response to this application, they have disclosed that those particular bank accounts need not have even more than a lakh. One bank account had some thousands, another bank account had some hundreds. At that point of time, they did not for once disclose that these bank accounts do not have the balance at all. So we of course didn't know how much is the balance. We thought that the accounts have sufficient balance. That's why we prayed for orders against those accounts. But they should have pointed out before your Lordship that there's no even if an order of injunction is passed, it will be not be fruitful at all.
Okay, in that case, let the matter go to the mediation. Bring all the documents before the mediator. Settle the issue.
But we can. It is never. It's always possible to mediate. But my lord, insofar as my security is concerned,
I am not touching the interim order with regard to the document which they are relying upon. You are disputing that.
I am disputing. I am only saying that, my lord, I have given details of 5 new bank accounts here in this application. And I have also given details of one particular land in respect of which they have furnished this particular document. Lordship will restrain them from operating insofar as my principal amount is concerned in the suit, while I am not even touching upon the interest. Insofar as the principal amount is concerned, in whichever account of the details of which I have furnished, then we can, because the Lordship, the order which the Lordship has passed previously, that is not protecting me any further, even according to the defendant.
Yes.
My lord, admittedly, if you go by the supplementary affidavit, the government rates which are given is around 16 plus 16, around 32 lakhs odd. And admittedly, from their plaint, we have already paid around 7 lakhs. If you aggregate those, already 40 lakhs is secured, my lord. At least liberty may be given.
This is 2014. You obtained this.
No, yesterday only, my lord, I have obtained this on 29th. The supplementary affidavit, the query, after Lordship, direction, I have myself obtained this from the online site.
But the value which has been ascribed by the government is around 45 lakhs.
So that is authenticated. That is what the government value, my lord. It is not done by any valuer or something like that, but it is by the government value as it was fallen from your lordship. I myself took out the query. So at least, my lord, the 45 lakhs is already secured, which I am myself giving for security.
So what about the
My lord, Mr. Lakmani is here. He'll continue.
It's also a self-valuation report. It's only a query. It's not the ascertainment of the stamp
My lord,
duty which
that
has
is
to be
how
paid, etc.
it is paid, my lord, over
But
here
I'm
also.
not, my lord, I am disputing this document. I'm
Sir,
disputing
let
the value.
if
I'm
they are
saying, my lord, this building could not have been constructed. Even if constructed, that will not fetch as much value that my learned friend, my lord, wants.
Okay, Mr. Mani, let the matter, the pleadings have been completed.
yes, my
My
lord,
lord,
pleadings
in
have-
the application pleadings, the affidavits have been exchanged. They have not filed any written statement in the suit. Suit is an
Not
undependent.
with regard to the
The application affidavits have been exchanged.
my lord, they,
But insofar as the bank accounts are concerned, Lordship will restrain them from operating
my lord, they,
insofar as the
My lord,
principal amount is
my lord, here I have something to submit. My lord, this is, my lord, a serious concern. My lord, there are 11, my lord, 11 bank accounts, my lord, had been injuncted. But, my lord, your lordship was pleased, my lord, not to continue that order. If your lordship sees, my lord, the order of, my lord, injunction was passed on a day, my lord, when none represented the defendants, despite, my lord, me having taken three days time to file my affidavit. Perhaps, my lord, your lordship was upset, none appeared, my lord, and therefore your lordship, my lord, passed a blanket order, my lord, injuncting everything. All now, my lord, there is one, my lord, bank account, which is, my lord, the bank account of the Yes Bank. And, my lord, in so far as this bank account is concerned, my lord, another flat, my lord, has been, my lord, mortgaged with the bank.
my lord, the order is on June 19.
Order dated?
June 19. June 19.
Your
And
lordship will
the
kindly
injunction-
modify that order, my lord. My lord, at least allow me to continue my business. I mean, my entire life has come to a standstill, my lord. My father suffered
You
a
are telling
stroke.
that
My mother's a housewife.
You are telling that in this bank account there is no amount.
Which,
my lord,
no, my lord, kindly, my lord, your lordship's order, your lordship will, for a moment, my lord, just take. Your lordship, my lord, has injuncted, my lord, me from, my lord, alienating any property or dealing with any bank account. So there was a blanket injunction that was only until the next date. After that, the matter has been taken up on, my lord, 2 occasions, and your lordship wasn't pleased to, my lord, extend that order. Yet, my lord, I told my client as an abundant caution just to wait for a clarification from my lordship before, my lord, he can operate the bank account. On my personal request, my lord, he has not operated the bank account. I am saying, my lord, only for the time being, until your lordship decides the matter finally, at least, my lord, let me operate one account through which I do my railway business. Because, my lord, laborers are there. My lord, kindly
my lord, I do not want to stop their business. What I want
The
is
court has not court. Where is the order? That's why where is the order?
my lord, 19 June 2020.
19 June the correction order.
which order?
My lord,
Ms. Shah,
in
please
that
show
on,
the ex parte order.
my lord, on 19 June, if you see the paragraph,
Which order? To follow?
Where is the main order?
10 September is the main order, my lord, on 19.
10 September is an order passed in the previous application.
19
Where is the interim order, madam?
What did it say? 19 June 2025, my lord, is the order where, my lord, there are corrections. Above that correction, there is written, my lord, I just should indicate the paragraph. Until next date of hearing, that was on 27 June.
Yes.
There was the injunction. Thereafter,
Yes,
the
paragraph 7. Paragraph 7 till the next date of hearing. Defendants are restrained
Yes.
for the time being.
Where,
Any of
where?
the
Yes.
paragraph 7
Paragraph
of 19th June order. 19th June 2025.
The last second an advocate appearing for the given undertaking before this court, he will file the affidavit disclosing the details of the account and valuation of the property, but has not filed the same and has withdrawn his power. Accordingly, defendants are restrained from time being for dealing with any of the properties and the bank accounts. Yes.
and, my lord,
For the
please
time being.
appreciate the fact that
They
there
have not
is a
furnished
change
details
of
of the bank
AOR.
account.
Details. Have you furnished?
Yes, my lord, I have.
Where is the details?
My lord, I have.
Bank account details have been furnished.
I have filed one affidavit in opposition pursuant to.
So where is the details?
My lord, page 48, my lord. Page 48, my lord, of the affidavit in opposition.
51.
48 of affidavit in opposition of GA
4.
GA4, my lord. Page 48. So, my lord, there is a flat, my lord, which is injuncted, and there is this bank account which is injuncted, which, my lord, today.
My lord, this is complete. I'm so sorry to point
yes,
this out.
48 is your bank account.
My lord,
Bank
yes, my lord, may I, my lord, just clarify to your lordship. My lord, in this bank account, there is not much money. I'm told today, my lord, the balance is about 1 lakh for around 1,40,000. And my lord, account statements also, my lord, are not updated post September. because my lord, we could not operate this account, and this account has now become a dormant account where the money stuck is about 1,40,000 rupees. So my lord, this my lord secures my learned friend my lord only to the extent of 1,40,000 rupees. Apart from this, my lord,
that's why you are telling that as per this on 19 June order, you are not able to operate any of the bank account. Where is the other bank account? I will clarify this. You can, in which you are having the sufficient money, then I will pass an order. You can operate the bank account, leaving aside this, the principal amount. That's all.
my lord, very well. My lord, may I only, my lord, say this? My lord, that may, my lord, put me in further difficulty, my lord, because, my lord, the money, my lord, in this, there is no actual money, my lord, as such. There is a...
of my application. My lord, I've given details of seven
Yes.
bank accounts.
Your lordship will see, my lord, their application.
Only one. That is also
Where is the details of the other
thousands.
7 bank accounts?
This should not have been done.
My lord, my friends have given the details. My lord, kindly take page 6 of GA4, my lord.
GA4?
GA4 is
yes,
this
my lord.
application. Page 6.
Yes.
Now, my lord, yes, now
What is
page
the details
6.
of this account? Have you
Now, my
given
lord,
you have given the details of your account in which you are only having the 1 lakh.
on which your lordship had given an injunction, my lord. On which your lordship had given an injunction. My lord, the direction
of a separate account. And this given a open, none of the bank account can be dealt with.
But, my lord, previously there was an injunction over this account on by order 10 September. Thereafter, this injunction was passed because the learned erstwhile advocate was not appearing, and that is the reason this order was passed, my lord. My lord, kindly appreciate on the very
Madam, kindly come to the, please satisfy this court with regard to the, kindly come to the 19 June order, 7th paragraph. Where is the details furnished by you with regard to your accounts? That's why this court has passed a blanket order on 19 June. Because you're not, earlier your advocate, whoever, maybe he has given an undertaking, he will furnish the details. When this court has asked the details on the date fix, he has withdrawn the power.
My lord, may I clarify this, my lord? My lord, I believe, my lord, there was some misunderstanding. My lord, we have, my lord, disclosed only, my lord, the particulars of one bank account which was injuncted. For your lordship to ascertain, my lord, what is the worth of the injunction which has been granted?
I am clarifying that you are free to deal with the accounts, keeping any of the account, keeping aside the principal amount. That's all.
My lord, may I just indicate one thing, my lord? My lord, kindly take, my lord, account number 6 on page 7. There is an account number 6. Just 1 minute, my lord. I want to clarify something very important.
Yes, bank.
Now, my lord, this account, my lord, is the account from which I, my lord, carry out my business with the railways, which has come to a standstill. Now, my lord, this account, I have a credit facility for which, my lord, a flat is mortgaged, my lord, to the Yes Bank. So, my lord, this credit facility, my lord, it usually, my lord, runs, my lord, on an overdraft basis because, my lord, my mortgage is with the bank. So this account essentially is, my lord, running in a manner of a loan. So, my lord, at least this account, insofar as this account is, because, my lord, laborers are to be paid, my lord, transporters are to be paid, my lord, this will, my lord, have a, my lord, multiplying effect. My lord, there'll be 100 creditors, my lord, rushing to your lordships against me if, my lord, this account is stopped, because all payments, my lord, are linked to this account. My lord, railway authorities are to be paid. My lord, materials are to be purchased.
Okay, you deal with the said account. I am not restraining only with regard to you deal with any of the account by keeping aside the principal amount of 70 lakhs.
May I then say this, my lord, principal amount, my lord, my lord, without alienating, my lord, that property, without, my lord, alienating the property, my lord, that I have, my lord, disclosed to your lordship, which is my other asset, my lord, a commercial building from which, my lord, I've been getting handsome rent, and, my lord, which, my lord, is a 5-storied building, ground, basement 1, 2, and 3.
Or you're harping upon the property. I am appointing a special officer. He will go and collect all the rent from month by month, so that amount can be realized. I am giving option to you. You are telling that there are property let out to the tenants, 16,000 per month they are getting from each.
14,000 and 8,000, 22,000 in total.
Okay, no problem.
My lord, I will not, my lord, may I just, my lord, that would amount to an attachment. My lord, just consider, my lord, I will not alienate, my lord, I have to, my lord, today show that if there is a decree against me in the suit, there will be means for me to meet that decree. My lord, today, my lord, I am not.
This court has given you an opportunity to give the total details of the account. Your advocate has appeared before this court, given an undertaking on the next date, he will come before this court with the total details. When the date was fixed, your advocate has come before this court and he retired from the court. Retired
Milord,
from the
I
court.
will.
Correct.
Milord, I
When
will.
he retired from
On the
the
next
court,
date, I
court
will.
has passed an order for blanket order. Now you had appeared. You are for the last 1 week. You are telling before this court you are ready to give the other property so that your bank account can be released. The property which you are shown.
Yes.
Neither this court is clear nor the plaintiff is clear with regard to the property which you are mentioning. Whether it is allotted to you, whether it is
My lord, we are the
whatever it
owner
is.
of the
Milord,
land.
the deed,
Now,
registered deed, Milord.
and till date, though you have filed the affidavit in opposition, you have not disclosed the total details. Only you disclose very cleverly one on the account in which only you are having the 1 lakh rupees.
I will disclose all accounts, Milord, within a week. Kindly, Milord.
Till that this interim order continue. Or I will pass. I will clarify the order dated 19 June. You can operate the bank account, any of the bank account, leaving aside the 17 lakh rupees, 70 lakh, 70 lakh.
70 lakhs, Milord, minus, Milord, whatever Lordship feels is the value of the property, Milord. Kindly, Milord, it ultimately, Milord, it's
My lord, this
Milord,
property at
Milord,
least
this
values
property I am
32 lakhs, my lord.
sorry.
Milord, the
If
deed
you
is
are
an.
not able to produce the total details of the bank and you are producing the property, the court cannot understand the property of the Rajasthan. Where is the allotment order?
My lord, the registered deed I have annexed, my lord.
The deed might be changed.
Under affidavit, I am saying that I am the.
And this is not of the Calcutta, it is outside of the Calcutta. It is very risky. It is very risky. And the counsel for the defendant prays for modification of the order dated 19th June 2025, wherein this court has restrained the defendant for dealing with any of the properties and the bank account till the next date of hearing, and the same was extended from time to time. Now the defendant has filed a supplementary affidavit disclosing two properties, one property.
Two plots, my lord, joined together.
On amalgamated property as their version.
Has disclosed two plots of land within bracket premises number 67 and 68, covering an area of 18.57 square meters, 18, thereby having a collective amalgamated area of about 37.14 square meters. He submits that the defendant will not mortgage and alienate the said property, and thus the plaintiff may be allowed, the defendant may be allowed to operate the bank account. Counsel for the plaintiff raised objection with the property of the description of the property which the defendant had disclosed in supplementary affidavit. This court also failed to understand whether the property has been acquired by the defendant or whether the property is of a commercial property or whether the property is in mortgage to any other bank or any other financial institution. In view of the above, this court is not inclined to accept the supplementary affidavit filed by the defendant. This court also find that since the hearing of the since beginning, this court has directed the defendants to file the statement of accounts, but till date the defendants only disclose one of the details of the account, in which only 1 lakh rupees is standing in the name of the defendant, and the defendant failed to disclose the details of the other 7 accounts.
Yes, seven.
Apart from this, kindly record my
other 6 accounts.
Miss Shah, can I please give an undertaking that we'll give the details in 7 days?
Yes, yes, we
This
can.
court find that the
We can.
defendant not inclined to furnish the details of the accounts.
Milord, may I only request, Milord?
The accounts which the plaintiff has disclosed in the application being GF1 in paragraph
11.
Kindly give us a week's time, Milord. We will disclose all details.
of GF4 of 2025. According the order dated 19 July 2025 is June 2025 is modified only to the extent that the defendants are free to operate the bank account subject to keeping aside an amount of rupees.
That 74 lakhs is the principal amount in this suit.
My lord, admittedly, they have admitted in their plain that we have paid certain amount. My lord, kindly deduct
5
those.
lakhs in 2011.
Yes.
My lord, at least kindly deduct those amount and let the
74 lakhs the principal amount in this suit and in the
total. What is the total?
total is 94 lakhs, my lord. But in their
94
plain, they have admitted that we have already
94 lakhs. 94 lakhs till the further order of this court.
My lord, in their plain, my lord, they have admitted that we have paid certain amount. They let that amount be deducted, my lord.
But may I give one clarification, Lordship? In the previously recorded that 19 June order was continued from time to time. That was not done. That was not extended.
No, it was never told, my lord.
So
It was
19
never
June
told.
2025, the next day, that order was not extended.
My lord, it was never told, my lord, before your lordship to extend such order.
Okay. Let the matter appear. And it is
Milord,
informed
may I
that the pleadings have been completed. Let the matter appear on 12th August 2025 for hearing of GA4 and GA5.
GA5 is their due application, nature of a
GA5.
demurrer.
My lord,
Milord, may I only make
yes.
May I only make one request, my lord? My lord, like for instance, my lord, in the Yes Bank account, my lord, it always, my lord, is in the negative because I have given a mortgage. Now, my lord, I am told there is a certain, my lord, limit, my lord, up to which, my lord, I can avail credit facilities. So, if your lordship, my lord, restrains me from operating without leaving aside a sum, if your lordship may just clarify, my lord, that, my lord,
with the total details of the statement, then we'll see.
Without exhausting the credit limit to the tune of 90 whatever lakhs, my lord, if the language can be
Details of the statement, sir. Come with the total details of the statement. We'll see to that.
But GA5, and GA5 is their demurrer application. I can file my affidavit in a week, my lord. Or, my lord, if your lordship passes directions for affidavit in GA5, I can file my affidavit in opposition in a week. They can respond.
Counsel for the plaintiff prays for time to file affidavit in opposition GA5. Let the affidavit in opposition be filed within a week. Reply can be there to be filed within a week thereafter. कितना 12 तारीख को बोला था ना, तो 12 नहीं होगा, 19 को रखो.
Grateful.
Grateful, my lord. Grateful.
Yes. Record an order. Though the matter is specifically scheduled for hearing, but due to some personal difficulties of the defendant counsel appearing for the defendant number, appearing for the defendant number 2 in CS 16 of 2024 and plaintiff in CS 21 of 2024. According cases adjourned, let the matter appear. Khali kal bhi hai?
No, date has to be fixed.
Appear on.
Your lordship kindly fixes
No.
that date.
Fresh date has to be fixed.
8 and 9 September at 12 noon. I'm good. 8 and 9 September
at 12 noon.
12 noon. Yes, next.
Milord, I appear for the plaintiff, Milord. When a witness commissioner was appointed, Milord, it has not been completed, Milord. We are praying for an extension of time, Milord. Took us some time for discovery inspection, Milord. Additional judge's book of fair book had to be filed, Milord. It's done, Milord.
Lord, I'm appearing.
Given by the Commissioner, my lord.
But I'm sorry, I'm appearing on online mode, Your Lordship.
So what is the stage before the commissioner?
Just started, my lord. Preliminary one date has been fixed.
Plaintiff evidence.
Defendant's evidence.
Defendant's evidence.
Lordship, a tentative date of 5th August has been fixed, my lord, subject to the extension, Your Lordship.
So how many witnesses you will produce?
Only one, my lord.
You are for the
plaintiff, lord.
So your witness is over.
My witness is over.
Only defendant witness.
Only defendant is left.
It is submitted by the learned counsel for the parties that the defendant witness examination of the defendant witness is going on before the learned advocate commissioner appointed by this court. It is further submitted. It is informed that the next date is fixed on 8th of August. 8th or 5th of August?
5th of August.
5th of August 2025.
5th of August, my lord.
2025. In view of the submission made by the counsel for the parties, time to file report by the commissioner is extended for a further period of 4 weeks. Within 4 weeks, it will be over.
My lord, kindly makes it middle of September, my lord. It's a immediate person, my lord.
Is extended till 15th of September 2025. The commissioner is directed to file the report on 19th of September 2025. List the matter on 19th September for filing report.
Grateful to your lordship.
Next.
My lord, in item number 20, my lord.
Did I appear for the
I'm for the
petitioner in
plaintiff,
item 20?
IAGA number 2 is their application for acceptance of WS, where my lord, within 30 days, the permissible statutory limit, they have not filed the WS and they are beyond that time, but within 120 out.
My application, may I be permitted to place? My lord, recall, I had moved my application where I said, my lord, I have been made a party only because I happen to be a director. The defendant number 2 is the petitioner in GA3, my lord. But there is no allegation with regard to the defendant number 2, except that he was a director and that he had signed letters on behalf of the first defendant, which is the company who had taken the loan. That's the sum and substance of the allegations made in the plaint, my lord. But, my lord, I therefore made an application for striking off the name of the defendant number 2 from the array of parties. That's my application, which is GA3, my lord.
My lord,
may I?
We need to use an affidavit, my lord.
Which one?
The GA3 that Mr. Singh is talking about.
Who has filed an application for extension of time?
Yes, Mr. Singh, that I was trying to discuss.
J2.
J2.
And GA3 is for deletion of name.
They had asked for, my lord,
there appears to be some confusion. My lord, the brief that I have, my lord, GA2 is my learned friend's application seeking judgment, my lord, on admission. So, my lord, I might be wrong, my lord.
GA2 is for extension of.
Yes, my lord.
Very well, I stand corrected.
By the filed by.
My lord.
Must be by both the defendants, my lord.
Directors of the defendant number 1.
Yes, 92nd days they have filed it.
So I am disposing of GA2.
Very well, my lord.
Let me file the affidavit and it will be decided.
My lord, in GA3, my lord, subject, my lord, I take the plaint on its face value, my lord. They can't improve the plaint.
I also take the plaint on its face, my lord.
Yes, no affidavit is required in this case.
I see whatever I am going. I would like to say that should be on record.
Okay, let me file the affidavit. What can be?
Very well. Very well. No problem.
It might be loud and clear to say the contention of the parties.
Where is the written statement is ready?
Yes, it's absolutely ready, affirmed and ready, my lord.
Counsel for the defendant. Who has filed this? One of the directors of the defendant. Who has filed this?
One of the directors, defendant
number 1.
Defendant number 2. Who has sought for deletion? I am
the director of defendant number 1 and as such I am competent. In whose behalf this application is filed? Defendant number case salute.
On behalf of defendant number 1, it is filed by defendant number 2 though.
Yes, Mr. Singh, it's a defendant number 1.
My lord, I'm sorry, my lord, I don't have this application with me right now, my lord. Except that I have a copy of the affirmed copy of the written statement with me.
No, but this GA2, it is written that I am the directors, one of the directors of the defendant number 1, as such I am competent to affirm this affidavit. So he is not. It's not
Yes,
for
it
the
is
defendant
on,
number 2.
on behalf of defendant oblique petitioner number 2. So it should be defendant number 2 of that
Where
petition.
is? Where?
But I'm
No.
in the master summon, I believe, my lord. Yes, in the master summon I have read. And I and Rajendra Kumar Saraogi, yes, my lord, defendant number 2. Because he has affirmed, my lord.
Yes, on behalf of the first defendant.
Defendant number 1 company. Now he has sought for
Yes.
deletion anyways, that we will
Yes,
take.
I have to file written statement.
Yes, Mr. Singh,
Deletion I can always
certainly.
ask for.
Certainly.
क्या बोला? Defendant number 1 has filed the present application, being GA-Com 2 of 2025, praying for extension of time to file return statement. It is submitted that the defendant number 1 has received the summon on 19th of March 2025.
19th of March.
19th of March 2025.
And no explanation.
After receipt of the summons, the authorized officer of the defendant number 1 has contacted the learned advocate and instructed to take appropriate steps on behalf of the defendant number 1. The authorized officer has communicated the said to the advocate on record, but was not able to provide the documents and instructions, and as such, and to the advocate on record, and as such, the written statement could not be filed within a period of 30 days. But now the written statement is ready and already affirmed. If this court will and the time come on, the defendant will file the written statement within a day in the department. Yes, what is the submission?
Some cost I may prefer only. I'm leaving it to Lordship in entirety.
Counsel for the plaintiff raised objection and submitted that the defendant has received the summon on 19th of March 2025, but has not shown any cause as to why the defendant has not filed the written statement within a period of 30 days, and he raised objection of the application. But the learned counsel for the respective parties peruse the materials on record. This court find that the defendant number 1 has received the writ of summon on 19th of March 2025. Subsequently, he has contacted the advocate, but he could not provide the documents and the instruction, due to which the advocate on record could not prepare the written statement within a period of 30 days. It is found that now the defendant is ready with the written statement within the outer period of 120 days. And as such, this court is of the view one opportunity should be given to the defendant to file the written statement, subject to payment of cost of rupees 5,000 in the with the High Court Legal Service Authority within a week from date. In view of the above, the defendant is directed to file the written statement in the department by 5th of August.
Very well, it's ready. I'll file it.
5th of August 2025. And the department is directed to accept the written statement subject to scrutiny by the department.
I'm deeply obliged.
Of the cost shall be shown before this court on the next.
They have given us a copy. Only that is permissible if they have already filed it within the department, because we are not yet know that whether they have filed it in the department or not, as per Order 8 Rule 1.
You have not filed it.
But it could not have been filed without leave of the court. Now we'll file it.
Now then the 120 days is over.
No, the application has been made within time. The department will not accept after time when it passes. That's the difficulty. The application was taken up within time.
Now this court has already made it clear the written statement should be within 20 days, not the application.
Yes, Order 8 Rule 1.
Not the application.
But I'll have to check whether this has been actually filed or not. Today I'm not in court, but physically.
So if you are saying that you are having the written statement, how it can
I have an affirmed copy, but whether this has been actually filed with the department.
That's why, because there
I'll have to check.
Unless and until within 120 days, this is not on record. It is not. This court is not having the jurisdiction or authority to accept the written statements. And third,
kindly make it not today in that even minute. I'll have to check this.
That is, the time is over.
Yes.
120 days is over.
It had to be filed.
No, I don't know whether this has been actually filed today. I'm not there, One minute. All that I want to do is I want to check with my advocate on record whether this has been actually filed before the department or not. Kindly, my lord, kindly pass it over, or my lord, kindly make it not today. My lord, I'll check and come back.
The counsel for the defendant prays for time. According case is adjourned, let the matter appear on 6th August.
And only for this short point, my lord. And GA3, my lord, may there be a reaction for affidavit?
The defendant has filed an application being GA-Com 3 of 2025, praying for deletion of the name of the defendant number 2.
Yes, sir.
Number 2. Counsel for the plaintiff prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be 1 week thereafter. This GA3 of 2025 on 26th of August 2025.
May their submission be recorded, otherwise there will be an attempt to file it in the department post.
They will not accept. Department will not accept unless the
And my lord is making this matter returnable. GA2 is returnable on Monday.
As per the prayer made by the counsel for the plaintiff,
the
hearing of GA2 is adjourned. This is the matter on
Till 5th. Very well.
6th
I'll
August.
check and come back.
Yes.
Already pleased to fix it on 6th August, my lord.
Next.
Your Lordship, I'm appearing on behalf of the plaintiff, Your Lordship.
21 and 22, I appear for the defendant numbers
Your
1,
Lordship.
2, 3, 5, and 6.
Your Lordship, in this
Had
matter,
directed
Your Lordship had
parties to
passed a
complete
direction
and inspection.
for the plaintiffs to file the statement of truth, affidavit documents, etc., Your Lordship. The order was passed on 17th of June, Your Lordship. But when we went to file those documents, Your Lordship, they wanted a fresh Vakalatnama and the affidavit of competency, which was not ready on that day. So we had to go and give it on the following day. But since the leave was only granted for 17th of June, Your Lordship, they did not take the documents. We had mentioned it, Your Lordship, on July 17th, Your Lordship, when Your Lordship said that it will be taken up, Your Lordship, when the matter is
Have you served the
we have served wrong time back. They have filed the written statement.
So what do you want now?
We want to file these documents, and Your Lordship, the inspection is going on. It is not yet completed, Your Lordship.
You are not filing the department. You
They
filed the
will complete
Vakalatnama.
unless yes,
File the Vakalatnama.
yes, Your Lordship.
When you filed?
The following day, Your Lordship, 18th.
So if you file the Vakalatnama, why the department?
Because Your Lordship, leave was only given for the course of the day.
So how much time the you will complete the
The
inspection?
defendants
Have you disclosed the document?
Yes,
Yes,
the
Your Lordship.
defendants are taking inspection of the plaintiff's documents. We have to go to Garden Reach and only on the weekend.
Where?
Only Garden Reach and only on Fridays. So,
why?
Because the government officers.
No, they can go any day, Your Lordship.
We have been informed. We have
They
been
can
informed
go
that
any day.
it is convenient for them to have all the papers ready on Fridays.
They have it ready, Your Lordship. Whenever they want to go, they can go.
And when you will
Lordship would extend it for another. Yes, the next date fixed is on 1st of August. Lordship extends it for 4 weeks.
Counsel for the plaintiff submitted. The plaintiff has disclosed the document to the defendant for inspection, and the inspection is going on. Counsel for the defendant submitted. They required some further time to complete the inspection of the document of the plaintiff. Counsel for the defendant further submit that they will disclose their document to the plaintiff.
They've already disclosed.
Disclosed.
After we complete the inspection, they shall be taking inspection of our document.
Already disclosed. Counsel for the defendant submit the defendant also disclose their document to the defendant and to the plaintiff. And counsel for the plaintiff will complete the inspection. After completion of the inspection by the defendant to the document of the plaintiff. Counsel for the plaintiff submit that though this court has granted leave to file the document in the department in course of the day by an order dated 17 June 2025, but on that day there was no Vakalatnama and affidavit competency of the learned advocate on record who is now appearing on behalf of the plaintiff, and has said the document was not acceptable. In view of now, police submit that now the defendant plaintiff advocate on record already filed the affidavit Vakalatnama along with the affidavit competency. Thus, the plaintiff is directed to file the document in the department by 6th of August 2025. The parties are directed to complete their discovery and inspection of the document within 3 weeks.
4 weeks, Your Lordship.
Within 4 weeks, full stop. On completion of the inspection of the documents, the parties are directed to file their affidavit of admission and denial document within 2 weeks thereafter. Full stop. In the meantime, the parties are also directed to exchange their suggested issues. Yes.
Your Lordship, one more thing, Your Lordship. These two applications are appearing in the list, Your Lordship, but these two applications have been disposed of, Your Lordship.
Disposed of, yes.
Disposed?
Yes, but since there is no recording, Your Lordship.
The matter appear on after 6 weeks, na? Let the matter appear on 22nd of September 2025 for framing of issues.
Yes.
Yes, what are the applications?
GA3 and GA4, Your Lordship. Those were for extension of
Time
time
to
to
file written statement.
That is accepted.
Yes, Your Lordship.
Not disposed of.
It was not
How it
disposed
is
of.
been accepted?
Your Lordship, it was order was passed on May 5th, and then Your Lordship.
Lordship's records.
5th May.
Yes. There were 2 written statements, Your Lordship.
Both for the extension.
No, Your Lordship. For one was, Your Lordship, for amended written statement to be filed, but that was not allowed, Your Lordship. And the second was for filing of written statement by 2, 5, and 6, Your Lordship.
Lordship, the amended written statement was also allowed to the effect that Your Lordship
Only the
has
cost
submitted
title, Your Lordship.
the
They wanted
comments
to amend in
amend
between.
the cost title, which we have done, and we have filed it in the department, Your Lordship. So GA3 and 4.
Defendant number 1 and 2 already filed the written statement before the transfer of the case in this one.
Yes.
Defendant number 1 and 2
Defendant number 1
directed
and
to take appropriate steps for amendment in the cost
Yes.
title
Yes.
of the written statement filed on September 2019. Also to file statement of truth and document with 1999. As regard the defendant number 2 and 5, they are given liberty to file the written statement within 30 days from the date of receipt. You have filed the written statement to the amended print.
They have
There is
filed,
no-
Your
there is no
Lordship,
counter-
and they have served us a
It has been
copy.
filed
Your
in the
Lordship.
Defendant number 2 and 5,
As
they
per
are
Your Lordship,
given to file the written statement within 13 days from the date of receipt of copy of the amended print along with the documents from the plaintiff the not required.
Lordship, we have filed everything.
Already
All
filed.
documents have been filed in the department. So GA3 and GA4 may be disposed of, Your Lordship.
ये ठीक है.
भी नहीं, but
So already all written statement is accepted.
Yes, Your Lordship.
It is fine from the record. 2 interlocutory applications being GF3 of 2024 and GF5 4 of 2024.
GA4 and GA3.
GA3 of 2025 and GA4 of 2025 is pending. Is pending, and wherein the defendant number 1 and 3 and the defendant number 4, 5, and 6.
2, 5, and 6.
2, 5, and 6 are prayed for extension of time to file written statement. It is fine from the record. The written statement is already on record and been accepted. And as such, no further order is required to be passed in the both applications. Accordingly, GA-COM 3 of 2025 and GA-COM 4 of 2025 is disposed of. Are disposed of.
Deputized.
तो जो डेट दिखा वो फ्रेमिंग ऑफ इश्यूज है ना.
On the last occasion, my lord, they have said, my lord, that this defendant was in custody, my lord. So, my lord, fresh interim order should be required, my lord. Now, my lord, that position has possibly changed because, my lord, the defendant has been released or enlarged on bail, my lord.
So in that general, but what about the yes?
My lord, 6 weeks time was granted to file the affidavit. That, my lord, we'll be in a position to file beforehand, my lord.
within 2 weeks, my lord.
When you have been granted bail?
My lord, on 23rd of July, my lord.
23rd of July. By High Court or by
My lord,
trial
by
court?
trial court.
By trial court. Yes.
my lord,
You have not filed the affidavit.
My lord, affidavit, my lord, we have by order dated, my lord, 16th, my lord, your 18th July, my lord, your lord was pleased to grant us
Extended till 23rd September.
6 weeks times to file the affidavit. My lord, we can file it beforehand, my lord. Within 2 weeks we shall file. My lord. Since he is out on bail, my lord, we could be in a position to file the affidavit.
And you also disclose the affidavit of
my lord, my lord, because my lord, the primary case which they are resting on, my lord, that the bank guarantee has been, my lord, wrong.
Correct.
My lord, in that case, my lord, they had also lodged an FIR, my lord. In that FIR, my lord, FRT has been submitted. Now, my lord, police has found that, my lord, I am not involved in any such kind of offences, my lord. I have not been charge sheeted. So, my lord,
offense, see, how the 420? How the police can investigate? They're telling that they have given the amount to you as a indemnity, but as a performance guarantee, and you invoke that.
Against that, they have on the
What the
sales
police
fact,
will, what
my
the
lord,
police, it is not the case that their signature has been forged or the document is forged.
their contention was that the possibly a xerox copy of the bank guarantee was given, and that was, my lord, thereafter involved. That is a case made out, my lord. Now, my lord, in that on the self-same allegation, my lord, FIR was also registered, my lord. In that FIR, my lord, I have been, my lord, discharged, my lord. The police investigators found that, my lord, I am not guilty, my lord. So, my lord, we need to.
But the fact remains whether you revoke the bank guarantee or not.
That has been involved.
Then, if you revoke the bank guarantee without the notice, that with regard to the criminal case, that is different thing, and the court is not going to enter into the matter.
Interim order in terms of prayer was granted by your lordship, my lord. I was just humbly beseeching.
Correct. That I am passing an order at the time of filing an affidavit. You give the total affidavit of assets.
My prayer D. But I was also seeking my lord, prayer C, because my lord, now that he is enlarged on bail, lordship has seen the newspaper publication. It's a bank fraud that he has committed.
That is
26 crores. Now
telling.
the investigation is on, possibly, and the bank will attach everything.
Is
because
the
it's
bank
a fraud.
your old account, freeze the account or not?
No, till date, my lord.
As the police has seized the account.
Till date, no seizure notice has been
It will be done immediately. It's a bank complaint, bank fraud.
It's a bank fraud. It might be the police might have been freeze your account.
Well, I was in this today on this juncture. I was humbly beseeching my lord, if my mother affidavit could come in, my lord.
Correct. I am not telling, but you only I will pass in the affidavit. You disclose your total assets. That's all.
That will do.
That's all. I am not passing any order. In the affidavit you disclose all the assets.
That we will do.
And security lordship can't pass without an affidavit.
Well, because my attachment has already been
But
done.
I am not. That's why I given an opportunity to you come here.
Because my attachment has already been done on the initial date only, my lord.
By an order dated 18 July 2025, this court directed the defendant to file affidavit in opposition within 6 weeks. A reply there to be filed within 2 weeks thereafter. In the meantime, the circumstances of the case has been changed, and the defendant, Mr. Madhusudan Ajit Saria, was arrested in connection with on the allegation of forgery of the document involving an amount of rupees 26.80 crore of loan. Police counsel for the defendant submitted that after this case the defendant was arrested. Now he has been released in terms of the bail granted by the London trial court. Considering the above, this court direct the defendant to disclose the affidavit of assets in the affidavit in opposition. क्या बोला? Above the order dated 18th July 2025 is modified only to the extent that at the time of filing the affidavit in opposition, the defendant shall also disclose the affidavit of assets in the details of the assets. Details of the assets in the affidavit.
But your lordship be kind enough to make an order in terms of prayer D. Either assets either held in personal capacity or any other entity, because defendant is saying that it's a
Details
partnership.
of the assets.
My lord, because my question, my argument relating to the maintainability of the suit still remains, my lord.
Yes, yes.
Their agreement was with Agarwal Paisapur, which is a partnership firm.
Very well,
Now, my
that
lord,
will be-
defendant is one of the partner, my lord. There are no other partner has not been added as a party. Firm has not been added as.
Okay, I will hear you. No problem. I will hear you.
Prayer D, if your lordship
No,
makes
my
it very
Let them
Very well, let them
let them disclose, then we'll see to them.
grateful.
Next.
But I appear
Already did, है ना?
Well, lordship is keeping the matter on
23rd September.
interim order is still 23rd September.
Let the matter appear on 23rd September.
23rd September. But if they could come up with the affidavit before we could
Let them file. Let them file.
Grateful.
Next.
But I appear on behalf of the my lord, petitioner, my lord. And this is my application under Order 13, a summary judgment. My lord, the petitioner herein, my lord, is an international travel service agency. And
Where is the writ of summons?
my lord, this was the
Writ of
report
summons
given by-
served?
Yes, my lord, but this was the report given by the sheriff's office.
Dependent not entered upon. Where is the writ of summons? Whether writ of summons served or not?
Yes, my lord. It was
There
my lord, it was attempted, but the door was locked, my lord.
Then
But that therefore, my
where
lord,
is the
my lord, the
service?
suit is of November 2022.
Correct. That's why you have to produce the writ of summons, whether it is served or not.
My lord, may I attempt to serve upon the defendant once again?
Huh?
Serve this application upon the defendant once again.
Which application? No, see, sir, you file the suit.
Yes, my lord.
Correct. File the suit, writ of summons not served. I don't know whether there is no report. Now you filed an application under what 12.6 or
13A. summary
13A. 13A summary judgment.
But this
Unless the plaintiff is not been served, unless the defendant not been served, the 13A can be taken into consideration.
My lord, the report that has come, my lord, the parcel carrying the document says item on hold, door locked, and intimation served. That was on 24th of March 2025.
So where is the other recourse you have taken after the door lock? Door lock is not a good service.
My lord, will kindly, my lord, allow me to serve once again and come back.
Counsel for the plaintiff press for time to take appropriate steps for service of writ of summons as well as the notice of GA4.
Yes. Yes, my
GA4
lord.
of 2025 upon the defendant. Let the press writ of summons as well as the notice in connection with GA4 be served upon the defendants. List the matter on 19th August.
I'm grateful.
दे दो उसको दे दो
Your motion. Item number 25. I appear for the defendant number 6 and 7.
My lord, I am appearing for the petitioner, my lord.
Yes.
My lord, I am
Yes,
late.
Mr. I'm there, ma'am. My lord, I appear for the petitioner. I was only praying for not today, please, my lord, if it could be granted, please, my lord. I've argued
I'm appearing for defendant numbers 11 and 12, my lord.
Your Lordship, I am for the defendants number 13 and 14, led by Mr. Tonoy Chakraborty in this matter.
My lord, we've advanced our arguments. In reply, we've dealt with 6, 7, 10. Now, my lord, 11 and 12 and 13 and 14 are left to be dealt. Kindly grant me an accommodation only for today, please, my lord.
Not today.
My lord, so my concern GA-Com 10. My lord, that is for acceptance of written statement. That may be a formal order may be passed.
When you receive the written statement,
Lord,
when
it
you
was-
receive writ of summons.
My lord, the date of summon, it was delayed by 113 days. My lord.
When you receive the writ of summons, sir.
My lord, I have stated that in my.
You give your application. What is the application?
GA-Com 10. On 30th of September 2025. 4.
You received the writ of summons on
30th of September 2024.
where 30 September.
30.
Yes, when you file the written statement.
My lord, I filed after 113 days, and that was with the leave of the honorable court. I've already filed in the department.
When
Only
you
that
filed,
is-
when you filed, not
department to make a file. That exact date is
okay.
I've given the reasons in paragraph.
Counsel for the plaintiff prays for a day's accommodation. Accordingly, case is adjourned.
Your Lordship, one humble submission, if I may make, on behalf of the defendants number 13 and 14, is that we had filed an application for vacating of the interim order, that is GACOM 11 of 2025. We had received the affidavit in opposition online via email on 25th of July 2025, and the hard copy was received by us on 28th of July 2025. This was way beyond the time that was stipulated by Your Lordship in Your Lordship's order dated 2nd of May 2025. I was only praying with Your Lordship if the time for affidavit of reply can be extended, Your Lordship.
Counsel for the 15 and 16.
13 and 14.
Counsel for the defendant number 13 and 14 submit that he has received the affidavit in opposition in connection GA number
GA 11 of 2025.
GA number 11 and GA number
11
12.
of
Number 11 GACOM 11 and 2025 and GACOM 11 and 12 of 2025 only on 25th of July 2025, and it prays for time to file affidavit reply. Let affidavit reply be filed by 1 week. By
Your Lordship, 2 weeks if Your Lordship may so please.
Full stop. Full stop. The ऊपर क्या बोला? ठीक है. उसके बाद ये बोला है ना?
My lord, the plaintiff would like to file his opposition, my lord, to GA 11 and GA 12.
But you are sleeping all the.
My lord, given that it's they mentioned.
Mr. Tucker mentioned that not today. You are not mentioned that you will file the affidavit. The counsel for the defendant number
1, 2, 3, and 5.
1, 2, 3, and 5 submit that he has filed an application being GACOM 10 of 2025, praying for extension of time to file written statement. He submitted with the leave of this court. He has submitted the written statement in the department. In view of the above, department is directed to place the written statement, if any, filed by the defendant number 5.
1, 2, 3, and 5.
1, 2, 3, and 5 on the next date fix. List the matter. 2 weeks, है ना? List the matter on 19th August 2022.
My lord,
My lord,
to indicate, my lord, the interim order is expiring on 5th of August, my lord.
Counsel for the plaintiff submit that interim order on the up to 5th of August 2025. According prays for extension of the interim order. In view of the above, interim order extended till 19th August 2025 or until further order, whichever.
My lord, my form 2, that is my section 45 application, may come up that day.
That will come.
Yes, it will come. It's list. I'm grateful to man.
Your Lordship, one humble submission. On 19th of August, I have some personal difficulty. Can it be on 20th or any subsequent date, Your Lordship?
20th. Interim order be 20th, huh? Yes, next.
Grateful, Your Lordship. Grateful.
But I sincerely apologize, my lord.
Yes.
Grateful, Your Lordship.
Grateful, my lord.
Lordship, I appear for the defendant in this matter. I'm being led by Mr. Shuddhashotta Banerjee. Today, due to the adverse conditions, he is not present here. So I'm praying for a not today.
I appear for the plaintiff in this matter, my lord. This is that matter, my lord, where initially an application in the combined nature of a section 10 12A revocation and also, my lord, vacating was filed. Thereafter, it was the other prayers were given a go by.
Not today. Come tomorrow. Not today.
Grateful.
But I appear for the plaintiff. I had concluded my submissions on the last day.
I can continue with the
Continue. Brief.
I'm here to continue to that.
The affidavit in opposition is absolutely my fault, Millard. The affidavit in opposition, which Lordship was Millard searching since Millard 2021, Millard. It was Millard with him. He kept it in the folder Millard in his office. কালকে দিও Millard GA1, if your lordship takes Millard GA1, there is also a GA2.
What is the GA1?
GA1 is an application in nature of order 38 rule 5 coupled with an order of injunction restraining the respondent from withdrawing any sums from the bank account without securing or keeping aside the said amount of 195,000,000. So 1.95 crores. An alternative to furnish the security for the said sum. That is GA1.
Attachment
So
of bank attachment of the accounts of the respondent being mentioned here in above.
So Millard, this is in nature of Millard order 38 rule 5. I take it. Now Millard, if your lordship takes GA2, so GA2 sir, now there are 2 volumes.
GA2 is
also, if your lordship takes page 19,
the same security of 1,95 crore.
Yes, and take there is an order of order seeking for appointment of special officer. That's there, and take possession of the books. Millard, also order 38.
Yes, same.
So Millard, today in none of the application, either GA1 or GA2 Millard, Millard, there is any order for judgment upon admission. So Millard, it's a simple Millard order 38 rule 5 petition in relation to an unsecured money claim. Now, if your lordship takes Millard the petition once, what is his case and why he wants a drastic order of injunction? First, let us take Millard GA1. ঠিক আছে তুই বলছো একটাই করবো আচ্ছা একটু লোকজনও করা হচ্ছে if your lordship take GA1, kindly Millard have a look at Asterix Enterprise Private Limited is a NBFC, the plaintiff. The defendant number 1 is an individual. Now the case is sometimes in month 2016, the respondent para 3 approached the petitioner for the purpose of obtaining loan and financial assistance for 1.5 crores. And the said loan was granted. If your now lordships kindly take Millard, there are allegations. Upon inquiry, it was found that the respondent para 4 is associated with 9 companies as their directors and 2 LLPs as designated partners. The said limited liability partnership LLP for which the loan was sought has been floated sometime in 2011. The respondent was designated as its partner from March 2030. But Millard, so far as this matter is concerned, he has been sued in his personal capacity. So Millard, if your lordship takes and paragraph 5, this loan amount was transmitted on 8th of February 2016. So Millard, my first point before going to anything further, Millard, amounts have been paid by checks.
Then consummate. नहीं वो तो सब्जेक्ट टू एक्सेप्टेंस GA10 डिस्पोज खाली फाइल की है GA10 करके GA10 को डिस्पोज अप करना है इसीलिए तो रिटर्न स्टेटमेंट मंगाया है yes
if your lordship Millard takes
so these are the loan
so Millard, in normal case it's an unsecured loan, money is payable by the defendant. If it is on demand, 3 years from date of payment. So if your lordship takes on the face of it, I go by his pleading because today I am defending a order 38 rule 5 action. If your lordship takes on the face of it, the amount was basically last paid the main loan amount according to the case made out by the plaintiff in the year 2016, that is March 2016. So the suit has to be brought within 19, that was not brought. This was brought something in 2020.
2020.
The answer to that, my learned friend tries to give in the petition that there is a deposit of TDS. While deposit of TDS by itself perhaps may not, I am fortified with the judgment, extend the period of limitation or not. My learned friend has relied on a balance confirmation or an acknowledgement by the defendant, which I say this is not the signature because this is not his signature. It is the signature of someone else. Or it's not my signature, it's from one of the authorized representative of the defendant. That's the case there. Now, if your lordship looks at and its signature which is annexed, on the face of it, lordship will see these are not the signature of the defendant. So, whether my authorized representative signature can bind me when I say that I have not signed. So, this is point number 2. These are on merits of the matter. Point number 3, I am defending not a judgment upon admission, but I am defending order 38 rule 5 in question. Whether that because the unsecured money claim. Now, whether in this the pleadings or the case made out at GA1 I take first, whether the case has been made out for passing such a drastic order because he is asking for injunction on the bank account. If your lordship kindly have a look at 3 paragraphs only, I'll not waste lordship time so much. I try to be nowadays very short as possible. Whether for the purpose of, if I even proceed for the basis, admittedly money is taken. It's a money claim. Now, kindly take para 26 is the only averment at page 11. Switch over.
Yes.
Admittedly, para 26 is the only averment so far as GA and para 27 GA1 is concerned. Is it sufficient, to pass an order of attachment under order 38 rule 5? This is all he has pleaded. Now, this lordship's view is there. The view of other judges, honorable judges are there, which said this is all he has said. There is extreme urgency in the matter in the facts and circumstances, process of dealing, transferring, alienating the property. If notice is given, they will dispose of the property. I may put it in a lighter way. This can be a pleading to circumvent 12A. Can be,
Nowadays, that is also not.
But this cannot be, something, to circumvent or, order 38 rule 5 proceeding. 12A can be, can be. There is a, para in Dhanbad fuels, which says,
Yes, it has to be done. Yes.
Submission from the bar and, documents. 12A you can. It can be an, a prayer or a, pleading to circumvent 12. I put it in this way, but perhaps it's not a prayer, pleading, which warrants a order 35, order 38, rule 5 order. This is all there in the petition. So this is GA1 in question. Because we lawyers, we get briefs. We nowadays, I am very little bit, I am not so much happy. Last paragraphs, nowadays are also not coming to me for writing anymore. Few last, because
that's why the interlocutory court. Otherwise, where the advocates will go?
Absolutely. This lordship understands this is for the bar also.
Correct.
One matter, I was arguing, for the defendant. If Justice Tandon was sitting in courtroom number 2, it was section 134 of the Trademarks Act, Principal Office. That time there was no clarification. That I took the point, Hindustan Lever had Principal Office in Bombay. So in view of Sanjay Dalia, this court will not go. So he heard me patiently, but he delivered a judgment against me, relied on Food Corporation. He said, Mr. Ghosh, I am past this order for the benefit of the bar. So Millard, now Millard, kindly Millard, takes Millard. His Millard.
That's why this court is of the view, okay, advocates have to file an application and the court has a duty to dispose of.
I come with a petition. End of the day, Millard, I want Millard that Lordship hears me. Mr. Gupta is Millard has a smile. Millard, irrespective of the outcome of the matter in question. Sometimes if I win Millard, now Millard, sometimes I'm happy. And when I was Millard of my line in years age, I was very happy. Now Millard, if your Lordship now kindly take the pleading so far as GA number 2 is concerned. Para 18 onwards, very cryptic Millard, few paragraphs I paste and I get affidavit and go to the judgment straight away. In the instant proceedings, the respondent has alleged
page
number 10 of GA2.
Yes.
Because these are taken together. Why he has filed 2 Millard, I do not know. In the instant proceedings, the respondent has alleged that the entire principal loan amount has been paid to one Santi Kumar Surana in 2019. Now, my case in the affidavit is Santi Surana, who was the person who was like a conduct pipe Millard, who was basically negotiating between us. I have paid the money. The said Santi Surana is a finance broker, admitted Millard. The same was never authorized to receive money on behalf of the petitioner at any point of time in this regard. Upon confronting Millard Santi Kumar Surana about such allegation, he has issued a letter dated 2nd August denying the aforesaid allegation made by the respondent and also confirmed those allegations are absolutely false. Now, Millard, kindly 19. The petitioner states the cumulative assets of the respondent would not suffice the outstanding due of the creditor, and any decree that may be passed would be rendered as a paper decree unless Millard 1 crore 95 lakhs is not secured. Now, Millard, kindly have a look at the next page. The entire substrata of the business activities of respondents have gone down. As per the petitioner has been able to ascertain that the respondent has lost the entire business. This will be further evident from the fact the respondent took huge loans, whether secured or unsecured, against the fixed assets when various other security without any intention of repaying them, as the assets would not be of any value at the time of execution of the decree, and he gets to the siphon of the main sums to obtain and thereafter. The petitioner also got the details from the said finance Santi Surana, the unsecured loan received by the petitioner. So as on date, Millard, the petitioner Millard has Millard of the petitioner. Now Millard asterisk 1.5, this is present, 7-star corporation, the different entities. 50 lakhs, Prabha Surana, Millard 7.5 lakhs. We are Millard concerned with 1.5 asterisk as a subject matter of this suit in question. The petitioner had already filed an interlocutory petition being GA number whereby inter alia sought for attachment, was not aware of any of the fixed assets of the petitioner. So he has filed a second application. And Millard, the order was passed injuncting the Millard respondent from withdrawing the money from the bank account. Now Millard, kindly next have a look at para 23. Amidst the ongoing proceedings, the petitioner has discovered that the respondent is taking steps to create charge over all the assets by obtaining huge loan in his favor for the companies and or LLP in which is a director or a designated partner respectively. Such action of the respondent would eventually frustrate the claim of the petitioner since the respondent is proceeding to dispose of and or encumber the assets. At this juncture, the petitioner also came to learn from the said Santi Surana from his letter dated 2nd August 2021, annexed hearing, and that he very informed that his wife Prabha Surana has, so Millard, this is Millard, not his proceedings. This is the Santi Surana's proceedings. How can it has a bearing here? Prabha Surana filed CS number such and such against the respondent for recovery of 7.5 crores with him with interest accrued thereon, and also forwarded a copy of the said suit and the petitioner filed by Prabha Surana. Interim order was passed. The details of the properties have been set out with. So he has given the details of the property of the petitioner here, which are situated are flats in Alipur Park Place. Copies of the petition filed by Prabha Surana as annex. Millard, if Millard, kindly Millard, this Millard, it's like Millard, a very difficult situation. If, my lord, I have a property, what is the object of Order 38 Rule 5? The object of Order 38 Rule 5 is, my lord, to secure something which ultimately Lordship, my lord, sees, my lord, that I do not have sufficient assets. If at all the decree is passed, to, my lord, basically, my lord, to execute the decree. Now, my lord, if I have substantial assets in paragraph 24 herein, my lord, where is, my lord, the necessity for, my lord, injuncting my bank account? This is his case. These are mutually destructive. If I have a substantial 3 flats in question in Alipur court, I am a solvent person. I have taken a loan. So where is the question of, my lord, injuncting my bank account? Because the value of the flats in question in Alipur Park Road would be more than taking the Prabhasurana's, my lord, loan also into account. Kindly look at, my lord, the property, Alipur Park Place, one of the posh area of Calcutta, my lord, Alipur Park Place. So, my lord, if I have these 3 properties, my lord, according to him, it's unencumbered. Then where is the question of, my lord, attaching my bank account in question?
Yes.
The first part. Now, my lord, he says, my lord, now, my lord, the petitioner ascertained reliable source, so the respondent already taken step to dispose of the above immovable property in order to launder money, etc., etc. So, my lord, he has said, my lord, I am now trying to dispose of the flat in question. My lord, my lord, there can be, my lord, if that is so, or if Lordship finds so, then Lordship can call upon, my lord, me to disclose my assets. Lordship can do. What is your asset as on this date? I injunct you from. But, my lord, to, my lord, continue this injunction against my property on the basis of his pleadings, which do not meet, my lord, Order 38 Rule 5 principles. Because, my lord, you have to show, my lord, I am more or less defunct and I have already disposed of the property. I have money only in the bank account and I'm going to dispose of, also, my lord, deal with the bank account. This is all. Because ultimately, it's an unsecured money claim. My lord, the judgment of Rahul Shah, my lord, we always cite. When I am on this side, we always cite. Please give me this. But it has now been clarified that Rahul Shah is not an absolute proposition that in all money claims, there should be an injunction. It also, my lord, it also has been clarified further that Rahul Shah do not either expressly or impliedly overtake, my lord, Ramantik, which is the old view, which is followed by Kohinoor's team. My lord, if that be so, my lord, injunction, my lord, for asking on money claim should not be granted, particularly, my lord, restraining operation of bank account. You can ask me to produce, give some form of indemnity before the court if at all you find it's necessary. That is exactly in the division bench. My lord, I had occasion to argue this, my lord. From Order 38 Rule 5, we have to put in, my lord, some sort of, my lord, security by way of your undertaking before the register original site. But injunction on bank account, my lord, perhaps cannot continue. So this is, my lord, moreover, my lord, what is said, my lord, in the argument. I have, my lord, arguments on merits, and I straight away go to, my lord, show the judgments in question. Except tomorrow, any other day. Lord, professional tomorrow.
Counsel for the defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 6th August.
Grateful.
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 May it please your lordship, I am appearing on behalf of the decree holder for execution of a decree arising out of a money recovery suit, money lent and advance. Today has been fixed, for examination of the judgment debtor. But I have looked at, before the judgment debtor steps in, I must point this out to your lordship, If your lordship kindly sees the affidavit assets, that is not in the proper form. Most importantly, it doesn't disclose what is necessary. In this respect, may I kindly hand up to your lordship. Ultimately, I will be relying on this Delhi High Court judgment. It also Delhi High Court judgment. Because there is, your lordship knows, this has to be in form number 16A of Appendix C. May I hand up, Copy give to Mr. Mitra, please. Will kindly come to paragraph 5, of the report.
Yes.
So, what is absent? I'll indicate first from the report, from the form. Number 6. Present annual income, monthly income, weekly income. This is not mentioned. And there are 3 matters taken together. I'll come to the others one by one. But Nilkant Shah, who is appearing in items number in EC 511 and EC 08, he is there, as the judgment debtor. He has filed same affidavit assets, but he has not disclosed item number 6. Item number 6, cannot be avoided, because this is exactly where he says that he has to disclose what is his present income, be it annual, monthly, weekly, after paying income tax, is as follows. He is a partner. Now, second thing, point number 7, whether he is owning the house in which he lives and what is the value of it must be mentioned. There is no comment to that. Point number 9, following debts are due to me, from whom he says I have a personal loan of 10 lakh. Most certainly he will be having, because your lordship has passed a decree based on that. But that is also a misdescription, because there are 2 decrees passed against him. Now, if your lordship kindly sees the affidavit assets, his annual income is not there. However, he says that in paragraph 5 of his assets, affidavit assets, he says, I am one of the partners of a firm.
Where?
Paragraph 5 of his affidavit assets. He says, I am one of the partners of Messrs. Prionti Construction, having office at Dokhindara Road, Kolkata.
Which affidavit you are taking?
In EC 511.
511. 511.
Yes, my lord.
I am one of the partner.
Yes. 511. That is the first matter appeared. So, if your lordship sees, point number 5, first and foremost, he doesn't disclose his annual income. It is nowhere there in the affidavit assets. So, that is the material non-disclosure. The second point, is that he doesn't say, he says that he is a partner, which means that he is having some income and it is a construction company. Then your lordship will see he has disclosed 4 bank accounts. He has not disclosed any other additional property. If your lordship sees, house property, and there is also, the form says that there is also one further classification of any other property. Most certainly, he will be having other property, because if he is a partner of a firm, he will be having a capital invested in that firm, which is going to be his asset. So, he has to mention that as his asset, because the firm is continuing, it has not been dissolved. But still that his capital remains to be his asset. He has not disclosed that. This is another misdescription or non-disclosure, Finally, your lordship will kindly see paragraph 7 at page 4 of the affidavit assets.
Yes.
I have taken personal loan for a sum of rupees 10 lakh. This is, a misdescription and wrong disclosure for 2 reasons. First, the form says very clearly, point number 9 of the form, that is Appendix A, 16A, Form 16A, it says from where and to, from whom. No, it is a quotation from the CPC.
Yes, yes, yes.
From and to whom. That has to be mentioned. Now, your lordship was pleased to pass 2 decrees against this particular individual. So he has taken 2 loans, not 1. Here he says, talks about only 1. So on the face of it, it is not the correct disclosure. The second, I do not know whether he is talking about the loan which he has taken from me. It may be some other loan, but he has to disclose from whom he has taken and of what amount, because that is the requirement under the code. Now, if your lordship kindly sees, Milord, further requirement at paragraph 6 of the report which I have handed up, Milord.
Yes.
This is, Milord, the judgment of the Honorable Delhi High Court. It is reported, Milord, in 2016. Delhi Law Times, page 302.
Yes.
Milord, I have shown your lordship paragraph 5. Paragraph 6. In order to satisfy whether the judgment debtor has the means to satisfy the decree, and further that the judgment debtor has disclosed all his assets, judgment debtor has to be directed to give a declaration and verify the aforesaid affidavit under Order 21, Rule 41, Sub-Rule 2 of the Code. Now, there is a description. This is also missing. Now, paragraph 7. If the judgment debtor does not truly or sufficiently disclose his assets in the aforesaid affidavit under Order 21, Rule 41(2) of the Code of Civil Procedure, the court can execute the inherent powers under Section 151 by directing the judgment debtor to file a further affidavit of assets, income and expenditure in the format provided in Annexure A. In such and such, it was reported, affidavit of income and assets provided in Form 16A of Appendix E under Order 21, Rule 41(2) of the Code of Civil Procedure. Order 21, Rule 41(3) of the Code of Civil Procedure empowers the court in execution of a money decree to examine the judgment debtor to ascertain the properties owned by him. Order 21, Rule 41, Sub-Rule 2 further empowers the court to direct judgment debtor to file an affidavit as stating the particulars of the assets of the judgment debtor. Upon disobedience of such an order, Order 21, Rule 41, Sub-Rule 3 of the Code empowers the court to send the judgment debtor to civil prison for a term not exceeding 3 months. The form of the affidavit required to be filed by the judgment debtor under Order 21 of the Code is provided in Form 16A. Initially, matrimonial courts were directing the parties to file the affidavit in the format given in Form 16A under Order 21 of the Code, but the litigants were not truly disclosing their income in the said affidavit, as has happened here. This court is of the view that the format of affidavit of assets, income and expenditure provided in Form 16A of the Appendix E of the Code is not comprehensive to discover the complete income, assets and expenditure of the parties in matrimonial litigation, and therefore there is a need to formulate a comprehensive affidavit of assets, income and expenditure. Now, Milord, paragraph 8. Where the judgment debtor is a company, the court can direct all directors of the judgment debtor to file their personal affidavit containing particulars assets set out in paragraph 14. Milord, may I just pause over here to indicate in Milord item EC 512, which is against a partnership firm where this Neelkanth Shah is a partner. There also, Milord, there is an anomaly because partnership firm has not produced this affidavit of assets. And Neelkanth Shah over there in his affidavit of assets gives a description of having current accounts, which is not disclosed here. But anyways, that is also, Milord, defective. The statement of judgment debtor as to his inability to satisfy the decree may initiate attention of the decree holder to Section 6(2) of the Provincial Insolvency Act 1920, which provides for an insolvency notice, and the decree holder may invoke the same. Conclusion. This court is of the view that in cases of execution of decree for recovery of money, it would be appropriate to direct the judgment debtor at the initial stage itself to file the affidavit of assets as on the date of institution of the suit, as well as the current date, that is date of swearing the affidavit in Form 16A, Appendix E under Order 21, Rule 41(2) of the Code, along with statement of all their bank accounts for the last 3 years within 30 days of the receipt of the notice, and to remain present for being orally examined under Order 21. The judgment debtor be directed to verify the affidavit in terms of para 6 above, it is clarified that the application under Order 21 of the Code of Civil Procedure is not required to be in writing, and such an order can be passed on oral prayer of the decree holder. In the event of default of the judgment debtor, well, this is, I'm relying on this portion, to file the affidavit within the stipulated time, the judgment debtor be detained in civil prison for a term not exceeding 3 months under Order 41 Rule under Order 21 Rule 41 Sub Rule 3. If the judgment debtor's affidavit does not truly or sufficiently disclose his assets, further affidavit be directed to be filed in terms of para 7 and 8 above. The judgment debtor be also examined under Order 21 of the Code to receive such information or documents as will aid in execution of the decree. So, my lord, placing, and this, my lord, the observation, which is the part of the conclusion, is a general observation passed by the court, keeping in mind the provisions of Order 21 and the purport and scope behind it. Here, my lord, this is not the first opportunity this court has given. And, my lord, on the last occasion, they had already filed an affidavit of asset, which they withdrew because it was defective. My lord, this is perhaps the 4th or 5th time.
No, we have not withdrawn anything. We have not withdrawn. Yes, then
Your lordship, my lord, will see. And this is, my lord, the 4th time that chance was given to the particular judgment debtor who has, my lord, now come up before your lordship and has not given proper and truthful information. Your lordship has seen from the affidavit that it is, my lord, something looking alike Form 16A. So, my lord, I can reasonably presume that deliberately he has not disclosed his annual income and from whom he has taken the loan. My lord, of course, he is physically present over here. I'm not asking for civil detention. That will not help me get the money. But, my lord, a very short time be given to him so that he can rectify the defects in all the affidavits. Because all the affidavits are containing the same defects. In EC 512, where he is a partner, his son is a partner and his wife are partners, the same defects appear in the affidavit. And in that part, EC 512, the partnership firm has not filed an affidavit of assets. There has to be a person, my lord, saying that this is the affidavit of assets of the partnership firm. So that has to have 4 affidavit of assets. They have filed 3. My lord, these are the defects, my lord, and this is my submission. It would not be proper for me to examine this judgment debtor today in the absence of a proper affidavit assets.
Yes. My lord, so far, this discrepancy in the affidavit of asset, lordship will see the judgment debtors. There are the partnership firm.
No, 511 partnership firm is not the judgment.
Others. The partnership firm, the partners. So it's all the Neelkanth Shah, his wife, son, the partnership firm. Initially, the affidavit of asset was filed by 2 of them. So that then the objection was taken. It fell from your lordship. You know, you have to file the asset for all the persons. So now that is the only thing. The second day we have filed the affidavit for all the persons. Now the first question from the day 1, which is I'm harping, whether this court executing this decree has jurisdiction to execute this decree or not.
Why?
Why? The court has passed the decree, but none of the properties, whether it is in the what is the execution or the properties I have disclosed, is within the original side limits of this honorable court. So to find out that, it is important for my witness, for my client to go to the box, to ascertain to that extent whether he is having any property within the jurisdiction.
If you have suffered from a decree, correct? Decree is not challenged.
No.
Now they file the execution. Execution is only one way to desist the execution, you know. What is the way to desist the execution?
That, so far 47 or 41, we have not availed of that.
Correct. You are not availed.
We are not availed of
that.
Now to the jurisdiction.
Jurisdiction will come once the decree is passed. If this court finds that the property which he will declare in the affidavit of assets outside the court of outside the original side, there is a procedure in the
transfer.
Court
Transfer.
either through the
Yes,
Concerned
the
court,
procedure
or
is
the
there.
decree can be transferred to
My
the
lord.
assembly. These are the two things that is separate, because you cannot desist without the proper course.
No,
You say that the property is not, the court is not having jurisdiction. The court has passed a decree.
He always has the yes, always. I have to file it over here.
Correct.
It's not an arbitration award that I go and I know.
So, and
But
if you
that has to be
take-
ascertained first.
Yes, if that's why, if you file the affidavit of assets, in the affidavit of assets is found that the property which is within the jurisdiction of this court, this court cannot execute, there are provision under the law. If it is not found that, then either the decree holder will be
Other
take
provisions.
up
Now,
whatever.
Lordship will now see the asset once. The asset which I have disclosed are identical in is all the same. Now the asset
No, assets which are declared
It's a
the
defective affidavit.
Now that this is as per, nobody is raising, now Mr. Banerjee has raised the
My
objection.
manager has raised the objection.
Correct. So as per the 21 rule 41(3), the appendix A.
Now
that
on
format is
appendix
to be
A,
used.
now yes, what I found 7 and 9 in detail.
No. Kindly
Six.
come
I was
total.
also on 6.
On 6,
Total,
my
total.
present annual income, monthly income. This is evident from the balance sheet.
So that's why that
This
different
is
thing.
evident.
First you have to come, balance sheet is a document.
Balance sheet is
a document. That document is to be supported by an affidavit.
No, we have not been served with any balance sheet.
No,
I don't
that's
know whether it's an annexure or not.
So if you, because this form does not show that you have to file the document.
No, does not show.
Does not show.
Only the declaration.
Declaration. So if this declaration, for testing that, if you file this declaration under 21 rule 2
form,
correct, under 21 rule 41(2), is it fine? And if the decree holder telling that this declaration is not for, then the witness can be examined on doc, and you can produce the document. Yes,
Then
this
if
is
required.
that is different.
So
the first step is that you have to follow this form.
Is absolutely, in terms of the forms, have to improve these affidavits. I'll improve these affidavits because I find that
the CPC
6. No, this form is quoted over here. I found.
No, quoted. Let me see.
Yes,
Your Lordship can.
No? Now, Lordship will see. Lordship is at কোনটাতে আছে? নীলকণ্ঠ।
5-1.
Yes, this is 511. Yes, 511. This is an affidavit asset of Nilkanto Shah. He gives his full name, where he resides at. Then the 3, whether he is married. 4 is the person's dependent on me. 5 is the employment, trade and profession. He says I am a partner. 6 is my present yearly or weekly income after payment of income tax. This is missing. Then it says 6 is I own and possess the following bank accounts. What is the, and the bank accounts details are given over here. Then the stock, the bank details, which is the 8, my lord, the bank accounts. The bank accounts I have given. Now, stock is nil, the others house property. The house property is 8D. The house property is mentioned 1 BHK. Other property is nil. Other security is nil. Now we come to 9. 9 is following debts are due to me. Give particulars from of rupees. So here it is only a personal loan of rupees 10 lakhs.
Against whom?
So it's a father particulars.
Yes,
So it's a father particulars. So far 9 is concerned.
Correct.
That is missing. I admit.
Then come to this declaration form.
The declaration is not here in form 16.
16, there is no declaration.
There is no
but the affidavit has to be supported by the declaration.
Yes. No, that. No, that is not there. Man. If the declaration is required under the rules, we have gone by this affidavit and affirmed it.
Correct.
এটা হচ্ছে কোথা order 21 rule order দেখে নিচ্ছি declarationটা লাগে কোথায় আছে দেখি order 21 rule 41
Further, the judgment debtor has to disclose the assets and the judgment has to be given declaration and verify. So if it is affidavit, so
I have given the affidavit.
If it is affidavit, then in the affidavit you have to say the declaration, it is true to correct.
No, that is given here. That is there, the above statements are true to my knowledge.
Which statement? Which paragraph?
And the entire must be the foregoing paragraphs. The last, the jurate portion, my 8. The statement contained the foregoing.
Okay, I am directing you to file this separate affidavit in terms of form 16.
Only 16A.
16A.
Not a declaration, because I don't find the declaration over here.
My lord, I am relying on paragraph 6 of the judgment to ensure that here is one litigant who has deliberately suppressed. For him, the declaration becomes furthermore important.
No, this declaration, then I have to.
But there is no doubt that this person has deliberately done this.
This declaration can be under the rules of the Delhi High Court. So
I am beseeching your lordship to adopt it.
Is concerned, my lord, this declaration.
There has to be some indication whether he is in a position to pay my debt or not. Because we are not concerned with any other thing.
No, this declaration I don't think is part of the Civil Procedure Code.
Let me see.
Origin se rules nahi hai. Origin se rules hai. Declaration to কোনো দিন দিইনি ভাই আমরা। Now, declaration টা কোথায় আছে?
Yes.
If your lordship is looking at the declaration, then my lord, there is no appeal from your lordship's decree.
No, that's nahi. The declaration which the Delhi High Court has given, under which provision?
My lord, the provision is the Delhi High Court states it.
What?
Under Order 41, under Order 21, Rule 40.
Format.
Yes. Now the format, yes, it is not there.
Not there.
It's not there. Now the Delhi High Court has suggested this format. There is no doubt or.
So we have not adopted.
No, your lordship has not adopted. I am imploring your lordship to kindly, my lord, ensure, since this is the third occasion, so that for this particular case, this format should be adopted, and there is sufficient reason. Because this is the third time when this is happening.
No, with regard to that, we are having our own original side rules. And
but original side rules follows this.
That's why the follows this.
Yes, my lord.
This follows the CPC. CPC for having some format. The format that is the
that is there. Yes.
And the last paragraph, he has to say whether it is correct, true to the best of my knowledge, or documents, whatever. He has stated that true to the best of my knowledge. He has stated that.
Yes, he has said foregoing paragraphs.
Foregoing paragraphs are true to my knowledge. But I will satisfy. He has to satisfy which paragraph is document.
That will, Millard,
I will do that.
That will, Millard, be sufficient.
That as per the format which
yes.
we have
I'll
adopted.
do that.
Yes.
A bit detail on that.
Detail.
Paragraph blank to blank knowledge belief.
Knowledge with regard to the
knowledge record belief. I'll do that.
That you specify.
I'll personally see that is
the assets which are declared is correct.
For the particulars.
And the particular true and correct.
True.
Automatically. Need not to give that if his statement is... If
No,
his
no. Because
statement
in
is
sum and
constituted-
substance, it is meaning that. What has fallen from your lordship in sum and substance, it is meaning that.
Yes. Yes.
And
Mr.
Milord, with 512, this EC 512, Neelkant Shah must file his affidavit assets. It may be a replication because Neelkant Shah has not filed his affidavit assets.
Will file.
4 should
No,
file, so
give
he has not
512.
filed. EC 512 EC 512. There are 3 affidavit assets, one on behalf of the partnership firm, and then 2 partners. Right? Neelkant Shah 4 জন দিয়েছে।
হ্যাঁ দিয়েছে, I have given
একটু
you.
দেখেন।
Yes, it's 512 Neelkant Shah has filed.
Neelkant Shah on whose behalf?
Neelkant Shah,
Is it Bob the...
I'm one of the partners.
Mangla Shah. And Neelkant Shah and Mangla Shah. 2 have filed.
Yes. Anindo Shah is also filed. Anindo Shah is another partner, is also filed.
So is there of the partner, has the partnership firm filed?
Let it disclose.
Partnership firm must file his affidavit. That is my point.
It disclose. It's a partnership, it's a proprietorship, or it
No,
is
no,
limited.
partnership.
So let it disclose.
It is already disclosed. Partnership firm was, Milord, a party defendant. Decree
Correct.
passed against partnership.
You obtain decree. Now he has to give the affidavit.
He
If
must
he give
give
the
the
affidavit, there is a partnership. If it's a partnership cannot be one person.
Milord,
Partnership
exactly.
have given the affidavit.
Exactly. Now, what is happening, Milord? There are 3 partners. 3 partners, according to them, 3 partners have filed their affidavits as partners. Mother partnership firm affidavit of asset is not there. So they are not disclosing what are the assets of the firm. And it is the firm which is the wealthy person.
So as per this format, all the things will come. It is a firm, it is a partnership.
Firm must.
It
Firm
will come.
must. Yes.
16A.
Because firm, Milord, is party number 1. Defendant.
Correct.
Defendant number 1. And here,
In the
512 cost title, you will see.
There are 138 proceedings.
512.
Milo will kindly see the cost title.
My full name is Neelkant Saha. First is.
No, Milord will see the cost title once. Milord.
Yes. Priyanti
First is Priyanti. That is the partnership firm. So there will be partnership firm's affidavit asset. Now number 2 is Neelkant Shah. Number 3 Mangala Shah. Number 4 is Anindo Shah. So 4 affidavit assets.
So
I'm only saying 4 is not there, 3 is there.
Neelkant Saha has given 2 affidavits.
That is mistaken. That has to be the affidavit assets of the firm, disclosing what is the assets of the firm.
If firm cannot come.
But he has
he has to take the resolution.
Yes, as per 16A, through following the procedure as Milord laid down in law.
Correct.
Under order 29.
The 2 of Neelkant.
Okay, bhul hoyeche dada. He has nowhere said that he is doing it
So these are the
as
2.
a partner.
These are the 2.
That is the confusion.
These are 2.
These are 2. There is and EC 08 also by Neelkant Shah. The same defects are there in the affidavit of assets. My same submission, Milord.
Yes, Mr. Mitro. How soon you will file?
Fortnight?
Milord, I will be beseeching for a week, Milord. Your Lordship's order is so old now.
Only difficulty is, my lord.
Commercial
So far Neelkant Shah is concerned, is present in court today. He is suffering from Alzheimer's. So
We have some documents.
we have medical documents. Even if he is put to the box, he can walk. You see him, nothing, no problem. But if he is put to the box, and if Mr. Banerjee questions him, even the court questions him, within 5 minutes the court will understand the question is X, is answering Y. So for him to give a affidavit, will take some time. Because he is the main man.
My instruction is otherwise. His conduct in the magisterial criminal court is very, very agile.
Now,
but I leave it to your Lordship, Milord.
In 138 proceedings, they are pressing for a mediation. And the matter has gone for mediation also.
Because of the reason that we do not want the judgment debtors to be behind the bars. That will not enrich us.
No. That will not enrich anybody.
Yes.
Now, the 45 lakhs decree, they want 90 lakhs out of it.
The plaintiff and the counsel for the decree holder has drawn the attention of the court to the affidavit of assets filed by the judgment debtor. This is EC Com 511. Filed by the judgment debtor, Mr. Neelkant, NIL Neelkanta, KNTH Kanta Shah. Mr. Rohit Banerjee, an advocate appearing for the decree holder, submit that the affidavit of assets filed by the judgment debtor is not in accordance with the provisions of Order 21, Rule 41 within bracket 2 of the Code of Civil Procedure. He submits that in the execution proceeding, the judgment debtor has to file the affidavit of assets in form number 1616 within bracket capital A साथ में capital A within bracket नहीं होगा साथ में capital A full stop. Learned counsel for the Mr. Banerjee has relied upon the judgment passed judgment in the case of Messrs. Bhandari Engineering and Builders Private Limited versus versus
Maharia Raj.
Maharia MAHARA Maharia Raj joint venture and others. He submits that in the similar case, the Honorable Delhi High Court has held that the judgment debtor has to file the affidavit of assets under Form 16A. Full stop. Mr. Banerjee further draw the attention of this court to the affidavit of assets filed by the judgment debtor in the present case and stated that the judgment debtor has not disclosed his present annual / monthly / weekly income after paying the income tax, and the judgment debtor has also not disclosed whether he has owned his house where he lives and what is the value of his property. He further submit that the judgment debtor though has stated that he has taken personal loan of rupees 10 lakhs, but he has not stated from whom he has taken. Mr. Aniruddha Mitra, learned advocate appearing for the judgment debtor, submits that this is the format we have adopted and filing in every cases. Now the decree holder has raised the objection with regard to the format of the affidavit of assets in terms of Form 16 capital A as provided under Order 21 Rule 41 within bracket 2. Order 21 Rule 41 within bracket 2 of the Code of Civil Procedure, Mr. Mitra submits that if 2 weeks time is granted, he will file the affidavit of assets in terms of Form 16A as provided under law. Heard the learned counsel for the respective parties peruse the affidavit of assets filed by the judgment debtor, namely Neelkant Shah, and the judgment relied by Mr. Banerjee in the case of Bhandari Engineers and Builders within bracket Supra. Admittedly, the plaintiff has filed the present execution case for execution of the decree passed by this court. The judgment debtor has filed the affidavit of assets, but has not filed the said affidavit in form number 16 capital A as provided under Order 21 Rule 41 within bracket 2 of the CPC. Full stop. The Delhi High Court in the above judgment has held that the judgment debtor is required to file the affidavit of assets in Form 16A. Full stop. Form 16A within bracket affidavit of assets to be made by the judgment debtor. Again bracket close, फिर again bracket under Order 21 XXX XX1, Rule 41 within bracket 2 of the CPC reads as follows. 8 of ये कर देना, set out कर दो, ठीक है?
From the civil procedure.
This court find that in the affidavit of assets filed by the judgment debtor in paragraph 8, comma, the judgment debtor has stated that inverted comma, that the statement contained in foregoing paragraphs of the affidavit are true to my knowledge. Inverted comma close. This court find that this said statement made by the judgment debtor is not serve any fruitful serve any purpose. If the judgment debtor declares his affidavit, his assets on affidavit under form 16A, comma, the judgment debtor has to affirm the affidavit stating the fact that number I. The statement contained in paragraphs so and so dot 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 TO2 dot 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 are derived from records. Full stop. The number second. The statement made in paragraphs dot dot 2 dot dot are true to the best of my knowledge and belief. Number next. The rest of the statements are my humble submission, the submission before this court. Next, the above stated, the statement made by the judgment debtor are true and correct. Full stop. Let the judgment debtor, the judgment debtor is directed to file fresh affidavit of assets under form 16A with the above mentioned statement within a period of 2 weeks.
2 weeks, my lord. Should be
2 weeks.
Can it be the 18th after that weekend of the
within period of 2 weeks?
We file it by 18th of August. Then any day, my lord's diary permits.
On or before 18th of August 2025, after serving the copy to the learned counsel for the decree holder, list the matter on 20th August 2025.
20th August.
Now, my lord, this would be identical to item to EC08. EC08, it would be identical.
208 item number?
Item number. Item 12, my lord.
ये अभी जो है कौन सा नंबर का है? ये 10 है
EC08
10 हुआ ना, और 12 no,
12
second 11
08
08 12 11 ये 10 होगा, 10 and 12 same order होगा, और 11 and 13 are different. 11 is different. 11
is your lordship dictated the order in 511.
Item 11. No.
Oh.
Item 10 is 511.
Yes. Item number
11.
Item
number
number
11 is item 10. 10 I dictated. And this is in
10 and 12 is same.
11,
Item
12.
11 is, my lord, where
10 and 12.
my lord,
yes.
The same thing, my lord, your lordship can, my lord, retain. It is only that the format of all the judgment debtors, 4 judgment debtors are there. And firm must file it separately.
Debtors बोला है ना 11 में आएगा judgment debtors, ठीक है, और नीचे होगा the judgment debtors are directed, all the partners are directed,
all the judgment debtors,
they are parties.
Debtors, yes.
All the judgment debtors are directed to file the affidavit under form 16A. बाकी सब हुए सब एक खाली debtors होगा, उसमें ज्यादा है, इसमें एक है, ठीक है.
Your lordship has dictated the above to file the assets along with the above statement. That is the declaration your lordship has. That would be declaration.
Along with ऊपर में ना.
No, not the declaration.
No. The declaration dictated by the court.
Yes,
declaration. That we will do it.
Declaration, not the statement.
Well, this will become a reported judgment.
Yes.
Because this portion was.
I am so glad. Mr.
Portions are never there.
Mr. Mitra is already a senior advocate.
Will go to Mr. Banerjee.
Yes.
Now that's why I reported. That's why I quoted the format.
Yes.
So that in
The
future,
format says only solemnly affirm. It does not say true to my knowledge and those breakups. So this now becomes a guideline.
Deep
You
plot
do
line.
it, sir.
Your Lordship, I appear on behalf of the petitioner. Lordship,
Yes.
my application for revocation of clause 12 I had completed. My learned friend was
28. You are for the?
I'm for the defendant
Who is
petition.
the plaintiff?
Lordship, someone was appearing. I do not
Tapa
remember.
Datto.
Yes, Your Lordship. She is not here today. Lordship was hearing her. Your Lordship keeps it, kindly retains the position in the list.
Not today. Not today. Yes.
29 Lordship, by hearing the application under Order 7 Rule 11 on behalf of the defendant.
We have prepared our notes. I'm just subject to his not citing any more judgments. I shall then give my rejoinder and note today only. I will finish.
Because, my lord, we had, my lord, made our submission. Mr. Bhattacharya was leading me. On that date, 4:30, my lord, matter got taken up late. We could not distinguish their judgments. So, my lord had permitted us to put our distinguishing in the note. So, lord, we have no further submissions.
Okay, no problem.
Then may I do my rejoinder just now and finish? Lordship has heard this. No, sir, so it becomes quick. That
power button.
Lordship, kindly my rejoinder. It will be my notes also I shall give and rejoinder at one go. I'll finish it off. Lordship will kindly take a look at my notes.
Yes.
I do not think, Lordship, the prayer is for part specific performance of the development agreement. They have not asked for specific performance of the entire development agreement. And my principal ground of rejection of plate is section 12.1. Lordship remembers paragraph 2. 12.1 specific
relief act.
Except as otherwise
hereafter
provided in this section, the court shall not direct specific of part of a contract. The plain does not state that the plaintiff is not entitled to claim specific performance of the entire contract for any of the reasons contemplated 12.2 to 12.2. On the contrary, their pleading is that they are entitled to specific performance of the entire agreement. Paragraph 22 of the plaint. The plaintiff has applied to the defendant to specifically perform the development agreement at 17th August, but the defendant has not done so. Copy your letter. Ready and willing to specifically perform the said development agreement. And kindly see the prayers which I have set out in the first page. They limit that to only decree for specific performance of the registered development agreement as pleaded in paragraph 24 above by executing a power of attorney only. So, and Lordship kindly sees the power of attorney which was there. That is a uniqueness, page 3 of my note. The power of attorney which was there earlier, which only thing they want is a replacement of that. The power of attorney does not allow them to do any development. Kindly see clauses 15 and 18 from the power of attorney. This I had placed extensively in my.
Yes.
This power of attorney is restricted to obtain sanction and the clearances from KMC and other statutory authorities. They are not for any development of the said premises. Be it noted that this power of attorney is being granted in favor of said attorney without any consideration, and no interest or right of the attorney is created on the property, which is the subject matter of this power of attorney, and that further they said that attorney shall not hereby obtain or have power to make any construction development work at the said property. Only this power of attorney is what they want, and they admit that a part of the development is yet to be carried out. They've given in a list of They are saying minor, according to us, major. So with this, my next argument follows that this kind of a power of attorney, and which is expressly not irrevocable. Expressly not irrevocable. Firstly, this will only allow them to get the sanction plan renewed. But they will not. So they will sit with the sanction plan. They will never get their decree for specific purpose. My property will be stuck forever. And this is exactly what section 12(1) is against. Then D clause 4.1 of the development agreement. Not a D, yes. They have argued, nor have they dealt with this. But this is my principle.
This power button is not with interest.
Not with interest.
Yes.
And it is not even written as irrevocable. And it doesn't give a right to construct. And Lordship, it is determinable on the face of it. So I have cited those judgments of determinability.
Yes.
And then I have gone on to, it is in its nature determinable. So the power of attorney in nature is determinable. So I can very well, the court, as per court's decree, power of attorney will be given tomorrow. But there is no bar. Day after tomorrow I can revoke it. So will the court pass a decree which is futile? Never. That is, I have given those judgments. Page 5, paragraph F. When somebody asks for a futile decree, a decree which on the face of it futile, the court will never grant the decree. Firstly, it's a case they have relied upon, paragraph 3, kindly see page 5, 14 Calcutta 92. That a development agreement is specifically enforceable. I am not joining issue. 14 Calcutta, here the full bench held that a suit for specific performance of the development agreement is maintainable. On that proposition, the defendant in the present application is not joining issue with the plaintiff. The defendant's case is the plaintiff is not entitled to any of the reliefs as claimed in the plaintiff. In this regard, full bench judgment is as follows. The contrary cannot be proved conclusively at the interlocutory stage of any suit, and a fortiori, it cannot be said that a suit for specific performance of a development agreement is not maintainable. There is gulf of difference between a plaintiff not being entitled to the relief sought for and the suit not being maintainable. So I say relief is not entitled to. Suit is certainly specific performance can be granted. And now this 2020 Supreme Court, which they cited out again, this is entirely on my proposition that there can't be a part performance. They've not dealt with the point. What the judgment now? 2020. Have you 2019 SCC? Kindly see this judgment which they must have handed up to my lord. Santosh Amma judgment 2020-19 SCC. Do you have an extra? Go ahead. Extra printout at it now?
Yes, it is.
For sure. कुछ paragraph मिल के ना क्या?
Yes.
Kindly give me 1 minute. Paragraph number we have given wrongly here. कोथा है? Not paragraph 20. Kindly give me 1 minute. Santosha Mad, yes. I think some other. Kindly, I think 22 it should not be in the note. It's 72, 73. Paragraph 72 and 73, what I am relying upon. Page 97. In the note it's mentioned 22. 72. Kindly see page.
Yes.
It is well settled that the court ordinarily enforces a contract in its entirety by passing a decree for a specific form. However, section 12 of the specific relief act carves out exceptions where the court might direct specific performance of a contract in part. Section 12 is set out here and below for convenience. Kindly see section 12. Next page, page 98. Except as otherwise provided in this section, the court shall not direct specific provisions of a contract. When subsection 2, where a party or to a contract is unable to perform the whole of his part of it, but the part which must be left unperformed bears only a small proportion to the whole in value and admits of compensation in money, the court may, there's nowhere the case made out that that this part can't be performed and that can be compensated in money. That is neither the case nor the prayer. And 3, where a party to a contract is unable to perform the whole of his part and the part which must be left unperformed either forms a considerable part of the whole, though admitting of compensation in money, or does not admit of compensation, he is not entitled to obtain specific performance. But the court may, at the suit of the other party, direct the party in default to perform specifically so much of his part of the decree as he can perform. If the other party, in a case falling under clause A, pays or has paid the agreed consideration, this case is not made out. And para 73 is entirely in my aid. Where a party to the contract is unable to perform the whole of his part of the contract, the court may, in the circumstances mentioned in section 12 of this SRA, direct the specific performance. Here, your pleading is that I'm entitled to specific performance of the entire contract. I'm ready even to perform the entire contract. Then you do not seek it. Now, Lordship kindly comes back to my note, to page 6 of my note. Then the next principle, here they've exactly quantified what financial loss they have suffered. In the instant case, the extent of loss which the plaintiff would suffer in case specific performance is not granted has been assessed in detail at paragraph 11 of the plaintiff. If compensation would give adequate relief, then mandatory injunction cannot be granted. I had cited those judgments that when you yourself assess what is the extent of loss suffered.
Yes.
The next part is the contract to future contract. Kindly see paragraph 6. A prerequisite for further performance of the said development agreement of 17th February is a fresh contract being entered into by the plaintiff and defendant in clause 5.3 of the development agreement. Set out below. The developer shall construct and complete the construction within 36 months from the date of receipt of building permit sanction plan. However, this may be extended on mutual consent. Both have to agree. In this case, admittedly, the building plan was sanctioned on 18th November 16, mentioned in their letter of 9th November, and the period expired in 2019. So unless mutually parties agree, the court can't bring about a contract. The clause 6.4 of the development agreement, which is set out below, also requires a future contract being entered into by and between the parties for allocation of area between themselves. 6.4, the owner and developer hereby agree to identify their respective allocation within 30 days from the date of preparation of the plan sanction. Nothing has been done of the plan by specifying the same in detail and or within such period as may be mutually agreed by and between the parties. Unless the aforesaid two contracts as contemplated in clause 5.3 and 6.4 are entered by the parties, this much extension and this is the allocation or the development agreement cannot be fully performed. Apropos the above, the defendant has two false submissions. Agreements regarding allocation of built-up area and regarding time extension are required to be brought into existence as per clause 6.4 and 5.3. The court cannot bring about a contract between the parties. Well-settled judgments, I had cited them.
Yes.
And the other part, page 8, which which way you see it, its outcome is the same. Inasmuch as the said development agreement has vital elements, that is 5.3 and 6.4, which contemplates contract to be entered into in future in terms of clause 6.4. The development agreement is void. There can be no contract to enter into a future contract. An agreement to that effect is void. That's it. This is really
sentences, my lord, everything that was said here was also said, my lord, at the time of moving the application. So those submissions, my lord, we captured, my lord, the answers in our notes. Apart from that, my lord, all the submissions that were made were also, my lord, this is the second interlocutory application under Order 7 Rule 11. This is the first interlocutory application for injunctive relief. That was moved before Justice Saraf. There is a detailed judgment, all points considered.
Yes.
That's been taken care of. And we place that judgment as well.
And division bench has
My lord had asked, my lord, does the power of attorney create the interest? My lord, the specific performance sought, my lord, of the development agreement. Under the development agreement, I am the developer, I will develop and I will get 35% of the interest in the land. So that's where I get my interest from.
Correct.
To develop, my lord, I need to apply for sanction to the KMC. So the agreement also says that I will give them a nominee, my nominee, and they will give the power of attorney in their name so that we can go and apply for the sanction. Now the defense ought to be taken is that special skills are required. So therefore this can't be given.
Mr. Mukherjee, I'm appearing online.
I have finished my argument.
Did my submissions and my notes of arguments are also ready. My lord,
yes,
the only dispute, as Mr. Mukherjee was pointing out, was that they do not rely on the personal skills of Miss.
I'm not arguing. I'm not arguing.
No, that is not argument.
I'm not
That's the point
at all.
That is not the point raised in the written argument.
Not for Order 7 Rule 11. That may be relevant
He has
for
not taken the point of on the. He has
I have
taken...
submitted my notes of arguments. I have.
Thank you. Thank you.
Grateful.
Both the parties have concluded their argument and filed their written notes of argument. PAV.
Grateful, my lord. Grateful. Your lordship patiently hears us, every one of us.
Grateful, lordship.
Grateful to your lordship.
That is the duty.
Yes, man. Lordship has been patient for us both physically and also when you're in the virtual mode.
Yes.
Grateful.
Next.
My lord, in this matter, my lord, I am for the petitioner, my lord. Sorry, my lord, I am appearing virtually, my lord, because of the adverse condition, my lord, I couldn't go, my lord. But this is basically, my lord, an application in the nature of a mercy petition also, whereby, my lord, we have sought for a order for recalling and setting aside of an ex parte decree and judgment dated 27th August 2024. Though subsequently some modification was made on 6th December 2024, but the date of decree is 27th August 2024. And my lord, there is a delay on our part also, my lord, for which I have also filed a Section 5 application. My lord, the crux of my argument, my lord, which is, my lord, based on certain facts, is that the defendant, my lord, had a good defense in to place, because the agreement on the basis of which, my lord, today, my lord, they have got secured the decree, my lord, that was superseded by another agreement. But I cannot argue as on date on merit, my lord. But what happened, my lord, in this matter, initially, my lord, when the writ of summons was attempted to be served, my lord, that could not be served because the property on which the defendant was residing, that was, my lord, under the Securitization Act, my lord, possessed by the bank. Now, in the agreement as well as in your lordship's judgment, your lordship will find that there is a specific recording of fact that my learned friend's client, who is the plaintiff in the matter, my lord, he was, my lord, put to the possession of one portion of the property, first floor of the property. That is recorded in the judgment also. Therefore, he was knowing fully well that the property has been taken by the bank. And, my lord, thereafter, what happened, my lord, so far, on the basis of the check on which they have filed the plaintiff, my lord, against the dishonor of that check itself, my lord, they have filed another Section 138 before the Bankshall Court. And in that proceeding, my lord, I was arrested. And if I take your lordship to the once, my lord, first.
When is the judgment? What is the date of the judgment?
My lord, that is the 27th August 2024, modified on 6th December 2024.
6th December 24. And when
your judgment is 27th August 2024, and modification was made on 6th December 2024.
When you came to know about the judgment?
My lord, I have came to know about the judgment on 29/11/2024. But, my lord, I will be candid enough to mention, it is my duty to mention that when my bail, they have filed an application for rejection of my bail before the lower court, before the Bankshal court.
Correct. On which date? On which date they filed an application for rejection of your bail?
They have filed an application. We have got the copy on 29th October 2024. That we have pleaded in para 7. Yes, 29th October 2024. We have got the certified copies of all the documents, and the next date was fixed on 29th November. And immediately before the next date, that is on 29th 11, we have held a conference with the learned lawyer, during which we have come to know that there is a decree. And in the meantime, my mother was hospitalized. I mean, the defendant's mother was hospitalized, who has also expired. Therefore, there is a delay. Admittedly, there is a delay. But if I and I have to cite certain case laws also, which I will be placing only possible when I am appearing physically. But they have also filed an execution petition.
Was asked, they were asked to file the payment 1 lakh, 16 lakhs, 1 crore 16 lakhs and 45,000 rupees before getting this relief from them. From the, they have not done anything for last 5 months have passed. They have not paid a single paisa deposit. So this petition, both should be dismissed immediately.
No, that is correct. That will dismiss whatever it may be. What about they file an application for condonation of the delay? 129 days. What is your contention on that?
The condition, they have received that they have shifted from one place to another place, and how can we know where they have? It was only by the court below that they could be arrested from. We could be arrested from another place in Calcutta, 100 something. So they were not there. They did not disclose where they are. How even the paper advertisement.
So that's why they are telling that you filed an application for cancellation of the bail before the trial court, disclosing that you got the decree. From that order, from that application, they came to know about the decree passed by this court. Now, subsequently, they held whatever the story they have made. Now there is 120 days of delay for filing the application. On fact, what is your submission?
In this matter, I'm
3 बजे का matter है क्या?
Degree was passed.
Who is there? Okay, come tomorrow.
Instead of tomorrow, may it be on Monday, because tomorrow I will be at Agartala. Very sorry, but Monday, if it can.
Counsel for the applicant / judgment debtor has argued the matter at length. Due to paucity of time, hearing could not be completed. Let the matter appear on 6th August.
Deeply please.
6th August.
1 minute.
Yes. Check your diary.
No, my lord.
तो मंथली चाहिए एकदम
5th August. The time may be fixed.
Time not. If you time want, then it will go to after vacation.
My lord, if we are already 16 years old.
So 8 August.
That is heavily burdened, Lord, I have seen in the other matters.
8 August. 8th August.
Deeply please.
In 3 matters.
My lord, item
41 also.
Yes, next call.
No time.
No time.
Time may kindly fix today.
Time after vacation.
Kindly fix this time. Suffering for that. So
No time in my diary is packed. Yes, call.
Before my lord takes up the fixed matter, just the matter next, that's item 32. Lordship,
Item number 32, Your Lordship, I'm appearing for the respondent. Kindly pardon
the
my
affidavit in
background. I'm on
reply has
commute.
to be filed. Kindly grants us an extension to file the affidavit in reply.
You.
The petitioner.
Of GA 2.
Yes.
GA?
GA1, Your Lordship.
G1, Your
The
Lordship. Is
application.
this
30.
32.
no, it's CCIPT 1 of 2025, Your Lordship. That is the application in itself.
Item 32, Your Lordship. Kindly grants us a week's time to file the affidavit in reply. It needs to be affirmed.
32. Counsel for the
Petitioner.
Press for extension of time to file affidavit in reply.
Reply.
Let affidavit in reply be filed by?
It is ready. It just needs to be affirmed. Keeps it next week.
1
or
week.
thereafter.
Release the matter on 7th August.
Grateful. 7th of August.
Grateful, Your Lordship.
Great.
Yes.
Wait, please, Lord. The bank respond number.
Okay.
कॉपीज नहीं तो 2 लोग चाहिए No. But I prepared, my lord, some list of dates, creditor wise, party wise list of dates, my lord, bunching them up for your lordship's convenience. For 3 creditors. এবার অন্যদের কপিগুলো দাও
9, 10, 11.
Yes, 9, 10 and 11, my lord. 11, my lord, is HDFC Bank. 9 and 10 are 2 others. In which, my lord, we've given, my lord, the list of events which will assist your lordship, my lord, in collating the facts later.
Sir, may I also have a set? If you have a copy. Otherwise, I'll photocopy.
No, why? Since we are given.
না না হ্যাঁ রেখে দাও নো নো
দেখি না আলাদা আলাদা
see Lord, I'll tell you lordship Lord, if my learned friend doesn't have my lord copies for everybody, it may not be possible with 10 parties. We'll my lord photocopy and circulate. There's no difficulty. You just give us one set.
We have given you 3 sets already.
Okay.
No, that is 3. This 3.
Yes. 3 sets of 3. 3 into 3 has gone. 3 into 3. Now, if anyone else wants, we have also got.
We'll manage that. You continue.
Okay, continue.
Don't worry. I
continue.
No, we will continue. Don't worry, Mr. Chaudhary. I told you on the earlier occasion.
Okay, continue.
Please refrain from this byplay, at least in this matter.
Okay.
You're on a very tricky wicket. This byplay won't get you anywhere. Continue. এমন করে বলছে যেন আমি সময় নষ্ট করার জন্য বসে। My lords, lordships have got, my lord, more or less, my lord, an overview. Now, my lord, bringing your lordship straight into documents because it was Mr. Chaudhary's complaint yesterday that I had not shown.
Leave aside Chaudhary's complaint. You argue.
Not shown your lordship a single document. No, why? So answering, my lord, his grievance, because he's my learned friend, I must answer his grievance. Now, my lord, kindly have a look, my lord, at the most informative of all these documents, which is there, my lord, on record.
But I apologize. I later realized that it may not be seem to be a very polite thing to say. I apologize to my learned friend. It will not be repeated.
Okay.
But I have maximum respect for him. That is all.
Because we land up on the other side in so many matters. We are in so many. What is this? Please finish. As if I'm stealing, my lord, the Kohinoor. Ones who have already stole the Kohinoor have kept it.
See, the good friends fights in the court.
Yes. That is one thing. We go outside out of natural love and affection, he says.
My lord, in my 23 years,
mine
I
is
have
25.
fought with, my lord, a few people. I have tried not to be obnoxious over the years. I have fought with a few people for clients. Those clients are nowhere to be found. And it's those few people that I'm spending time with. And luckily, my lord, I've made up with them. So it's not been worth it. And I don't want to, my lord, upset Mr. Banerjee with anything that I have said.
My senior used to tell to us, clients will come and go, but our relationship
will remain.
Yes.
So when we, so that's what.
So
my lord, I
that's
will
the
come-
principle I follow. Sometimes, my lord, in the anxiety of a matter, I also get carried away. So my lord, when I have got carried away, I have no hesitation
It's
to
all right.
apologize.
It's perfectly all right, brother. No difficulty.
Okay, continue.
The only thing is this, huh? We all argue. We some win, some lose. Okay. Now, my lord, once your lordship has had an overview of the matter, may I take your lordship, my lord, to one document which really speaks a lot. Will you please stop? Will you please stop? Which will give your lordship, my lord, the best overview of the ramifications. I would have made elaborate submissions on every ramification differently, but there is an expert body which has commented on this and has brought forward the ramifications. May I place, my lord, before your lordship, my lord, page 357 of the petition. I thought I'll make a convenience compilation. Then I found that the convenience compilation was about 60% of the main compilation. And I immediately dropped the idea.
And it will be complicated.
It will be a complicated, it might turn out to be an inconvenience compilation.
Yes, page.
Please come to page 357. Okay, dear. Now, my lord, this is an order which is the final order which has been made by the SEBI. We have disclosed this. No one says that he has challenged it. Now, my lord, kindly come to page 357, final order of the SEBI in the proceedings. Kindly see who the notices were, whom the SEBI heard. BRH Wealth Creators Limited, that's R1. BRH Commodities Private Limited, that's R8.
Yes.
Anubhav Bhattar, that's R3. Shiv Kumar Damani, that's R2. Mugesh Devashrai, that's R7. Ashit Kumar Ghosh. Prosperous Vyapar Private Limited is R15. Polo Setco Tie-Up Private Limited is R16. Patan Commercial Private Limited is R17. And there are 3 other notices whose PAN is also not available. They are that distinguished. Please have a look at 6. Ashit Kumar Ghosh, PAN unavailable to SEBI. Kindly consider the ramifications. SEBI can't get hold of his permanent account number. Therefore, he is perhaps not even registered with the income tax authorities. Kindly look at another company, an entity. I don't know whether it's a company. It may be anything. It's maybe a proprietorship. 10. AB Investments, PAN not available. Kindly turns over. Blue Snow Supplier Private Limited, PAN not available.
Yes.
They are, my lord, also persons who have come in. May I just please have, my lord, paragraph 1, the background on how SEBI started this. BRH Wealth Creators Limited, formerly BMA Wealth Creators Limited, is registered as a stockbroker with SEBI registration number such and such. BRH was a member of the National Stock Exchange of India, NSE, in equity, equity derivatives, currency derivatives, and MFSS segments, and BSE Limited in equity, equity derivatives, and currency derivatives. Now, BRH Commodities Private Limited was a member of Multi Commodity Exchange of India Limited, that is the MCX, and National Commodity and Derivatives Exchange Limited, that is NCDEX. So, these are authorities these are entities which are registered with the regulators in various capacities. Now, my lord, based on prima facie violations observed in a report submitted by NSE's email dated October 4, 2019, SEBI had passed an ex parte ad interim order number such and such dated October 7, 2019, which is the interim order, against BRH CPL, Anubhav Bhattar, Shiv Kumar Damani, Mugesh Devashrai, Prosperous Vyapar Private Limited, Polo Setco Tie-Up Private Limited, and Parton Commercial Private Limited. The directions in the interim order are reproduced below. Lord, I will not trouble you, Lordship, with the entire directions, but the direction, in fact, there were freezes, my Lord, that were given, my Lord. Please have a look. Number 1, BRH Wealth Creators Limited, Shiv Kumar Damani, Anubhav Bhattar, Murgesh Devashrai Commodities Private Limited, Prosperous Vyapar Private Limited, Polo Setco Private Limited, and Parton Commercial Private Limited are restrained from accessing the securities market and are further prohibited from buying, selling, or otherwise dealing in securities, either directly or indirectly, or being associated with the securities market in any manner whatsoever, till further directions. 2. The aforesaid notices shall cease and desist from undertaking any activity in the securities market directly or indirectly in any manner whatsoever till further directions. 3. The aforesaid notices are directed not to dispose of or alienate any assets, whether movable or immovable, or to create or invoke or release any interest or charge in any of such assets, except with the prior permission of the National Stock Exchange of India Limited and BSE. The aforesaid notices are directed to provide a full inventory of all their assets, whether movable or immovable, or any interest or investment or charge in any of such assets, including details of all their bank accounts, demat accounts, and mutual fund investments, immediately to the NSE and BSE, but not later than 5 working days from the date of receipt of this order. Till further directions in this regard, the assets of the notices shall be utilized only for the purpose of payment of money and or delivery of securities, as the case may be, to the clients, investors, under the supervision of the concerned exchanges or depositories. The depositories are directed to ensure that no debits are made in the demat accounts held jointly or severally of the aforesaid notices and persons, except for the purposes mentioned in subpara 5 above, after confirmation from NSE or BSE. The banks are directed to ensure that no debits are made in the bank accounts held jointly or severally by the notices, except for the purpose of payment of money to the clients or investors under the written confirmation of the NSE or BSE. The exchanges, clearing corporations, and depositories shall appoint forensic auditor to track misuse of clients' funds or securities and to identify the net assets oblique liabilities of noticee number 1, BRH Wealth Creators Limited, and noticee number 5, BRH Commodities Private Limited, and submit report to SEBI within 90 days. The exchanges shall deal with the complaints claims of the clients against the member and may return the amount of client fund and securities to the clients, and may also use assets of the noticee number 1 to meet clients, exchanges, clearing members, clearing corporations obligations.
But Mr. Banerjee, 359 clause 7 is not complete here. After 3 line, it has missed all.
And no, 359 the photo stack.
Clause 7.
Oh,
this is missed. Okay, you have any extra copy? Only one copy may be due.
Yeah, I'll just give
Okay, you continue.
Yes, but this is important. I mean, this is like.
Okay, you give one copy.
I was talking about the blind spot yesterday. God said, I'll take revenge. The perfect blind spot. The most important part, not there in the photo stack.
Yes.
Please come to Roman 7. So this is the intro. Please have, may I place 7, 8, and 9 again?
No.
7, 8, 5. Now, my lord, after this, kindly come, my lord, to page 360.
You do one thing, you keep and give the copy, one copy of this. 359, one copy, give.
And then 359 একটা copy, judge সাহেবকে আলাদা করে দিয়ে দাও.
Yes, next.
The exchanges, clearing corporations, and depositories were all directed to appoint a forensic auditor to track misuse of clients' funds or securities and identify the net assets, liabilities of BRH and BRH CPL and submit the report to SEBI within 90 days. Thereafter, vide number such and such dated January 2, 2020, confirmatory order. The directions issued within the interim order were confirmed against all the persons covered in the interim order. Now, this was done, my lord, therefore, after hearing all the persons. Now, 5. NSE submitted the final forensic audit report, FAR. This is the report, my lord, we are speaking of, in the matter to SEBI on March 3, 2020. The period covered under the audit was from April 1st, 2016 to September 30, 2019. Some data sets in the audit were extracted and analyzed for the period beyond September 30, 2019. SEBI, along with BSE, NSE, CDSL, and NSDL, had also earlier inspected the books of accounts and other records of BRH between October 1st, 2018 and 5th October 2018 for the period 1st April 2017 to 25th of July 2018. Similarly, SEBI, along with MCX and NCDEX, inspected the books of accounts and other records of BRH CPL between November 26, 2018 and November 28, 2018, covering the period 1st April 2017 and 30th October 2018. SEBI thereafter issued a show cause notice, SCN, dated October 29, 2021, alleging the following. A. Misutilization of client securities. Roman 1. Pledging of client securities by BRH and BRH CPL. 2. Diversion of funds by BRH and BRH CPL through loan against securities, LAS. Misutilization of clients' funds by BRH. Misutilization of clients' funds by BRH CPL. Misutilization and diversion of client securities and funds by BRH through related parties. Page 361, Malo.
Yes.
Discrepancies in email IDs and mobile number data of clients. Misuse of power of attorney POA as depository participant DP by BRH. Wrong/non-submission of data by BRH and BRH CPL. Non-cooperation by BRH. Non-redressal of grievances of investors by BRH. Register of pledge not maintained and details of pledge shares of clients not provided by BRH CPL. Bounce mail notification of electronic contract notes not provided by BRH CPL. Subsequent to the issuance of the show cause notice, an opportunity of personal hearing was granted to the notices on October 20, 2022. Noticee 3, that's Milord Anubhav Bhattar, appeared in person on behalf of himself and also represented notices 1 and 2. So, Milord Anubhav Bhattar, who's respondent number 3 in your lordship's, in this case, Milord, represented both R1 and R8 before the SEBI. Yes. So, R1, R8, and Anubhav are on the same boat. Now, Milord, kindly comes, Milord, back to page 361. Noticee 3, notices 4 and 5 appeared in person via video conferencing. Mr. Amit Agarwala, advocate, appeared on behalf of notices 6 to 11. The notices thereafter also made written submissions. Summary of written and oral submissions, my lord, I will not take your lordship, lord, into, because that will be. Now, please come to page 370, the consideration. Suffice it to submit, my lord, here that all the submissions were that we are not related parties of BRH. We have nothing to do. We are separate entities. That was the defense put forward, as will be put forward here. Now, kindly see consideration. Paragraph 9 at page 370. I am now moving to consider the issues on merit. I propose to take up the allegation in the show cause notice pertaining to the misutilization of client securities by BRH and BRH CPL and diversion of client securities and funds to related parties together. A. Misutilization of client securities by BRH and BRH CPL. Misuse and diversion of client securities and funds by BRH through related parties. Now see the findings, my lord. Kindly come to 371, para 10. The show cause notice has alleged that the securities of clients were pledged by BRH and BRH CPL, and funds including amounts raised through such loans against securities were diverted. before proceeding to consider these issues, it would be appropriate to look at the measures put in place by SEBI to prevent misuse of client securities. Please have a look at these measures. These are measures that in existence from 2-3 decades before.
Yes.
So it's not as if anything has happened in 2016 which has turned the table. Please see. 2019 according to them. Please see, Milord, the second last line of para 10. I note that SEBI has issued circular number such and such dated November 18, 1993. Clause 1 of the said circular provides as under. 1. It shall be compulsory for all member brokers to keep separate accounts for client securities and to keep such books of accounts as may be necessary to distinguish such securities from his or their own securities. Such accounts for client securities shall, inter alia, provide for the following. A. Securities received for sale or kept pending delivery in the market. B. Securities fully paid for pending delivery to clients. C. Securities received for transfer or sent for transfer by the member in the name of the client or his nominees. D. Securities that are fully paid for and are held in custody by the member as security / margin, etc. Proper authorization from client for the same shall be obtained by member. E. Fully paid for client securities registered in the name of member, if any, towards margin requirements, etc. Now, Lord, the second one, it's a 2008 one. 11. SEBI circular number such and such dated April 17, 2008 provides that stockbrokers should have systems in place to prevent misuse of client collateral. The relevant portion of the said circular reads as under. Brokers should have adequate systems and procedures in place to ensure that client collateral is not used for any purposes other than meeting the respective client's margin requirements / pains. Brokers should also maintain records to ensure proper audit trail of use of client collateral. Now, my lord, kindly come to paragraph 12. Further, SEBI circular number such and such dated September 26, 2016 on enhanced supervision provides for uploading of clients' fund balance and securities balance by the stockbrokers on stock exchange system provides that. Now, this is a further layer of security which the SEBI has provided. Transfer of funds between name of stockbroker client account and name of stockbroker settlement account and client's own bank accounts is permitted. Transfer of funds from name of stockbroker client account to name of stockbroker proprietary account is permitted only for legitimate purposes. So this fund can't go from the stockbroker client account to the stockbroker's own proprietary account, except on legitimate purposes such as recovery of brokerage, statutory dues, which are charged, my lord, as tax, etc. At the time of transaction, fund shortfall of debit balance clients, which has been met by the stockbroker, etc. For such transfer of funds, stockbroker shall maintain daily reconciliation statement clearly indicating the amount of funds transferred. Please look at the checks and balances, and then you will look at the violations. I don't know where my money is parked, and I don't know whether I'll get it back after 5 years or 3 years if this happens. Number 13. As per the key, here, my lord, one thing is admitted. I have always maintained a credit balance. Not a single day has gone in which any monies were paid on my account which had to be taken. I have always maintained that balance. Now, 13. As per the pledge information, now look at this, my lord, second twist. As per the pledge information submitted by BRH, there was a substantial increase in pledge during the quarter ended, that's QE, December 2018. So, October, November, December 2018, these 3 months, there was a substantial increase in pledge. The client securities that were pledged, which stood at INR 169 crore at the end of QE June 2018, increased to INR 448 crores by the end of December 2018. pledging is going on of your and my shares, my lord, before another one by this guy. Now, kindly see how things are. Blood boils, my lord. The corresponding debit balance, which was owed by its clients, was only rupees 156 crore in quarter ended December 2018. Now look at the mismatch. This mismatch of INR 292 crores, that is 448 minus 156, between the client securities pledged and clients having debit balance indicated that BRH was pledging securities of clients not having any debit balance. And when is this restriction from, my lord? A lot of things will come before your lordship saying this was introduced in 2016. No, this was introduced in 1993 onwards. Yes. Para 10. So there's no standing practice and sitting practice here. There's only one practice, transparency and honesty. Now, my lord, kindly sees not, may I read on. Pledge details for two sample dates, September 28, 2018 and September 30, 2019, is extracted from the FAR and reproduced below. FAR is that forensic report. This is the extract. Please see, my lord. September 28, 2018, on one day, securities worth approximately 45 crores INR belonging to 9,493 clients having credit balance were pledged by BRH. Let this sink in. It took me 10 minutes to sink in when I was on the earlier occasion. It was just a bird's eye view. Then I decided to dive deeper with proper assistance. It took me 10 minutes to sink in the level of fraud and the level of audacity, both. Now kindly see. BRH pledged approximately 130 crore, which was more than the client indebtedness amounting to approximately rupees 35 crores, 5965 debit balance clients. Now, my lord, September 30, 2019. Securities worth approximately INR 107. Please see, the day before is 45 crores. The next day, 107. Just compare these 2 days. These are two sample dates pulled out to show the level of siphoning and dishonesty. Yes. September 30th, 2019, Millard. Securities worth approximately INR 107 crores belonging to 7451 clients having credit balance were pledged by BRH. BRH pledged approximately rupees 68 crores, which was more than the client indebtedness amounting to approximately INR 7 crore, 2819 debit balance. That means if they say that for the purpose of client indebtedness I had pledged, then also they are caught out there because client indebtedness was 7 crores and they had pledged 68 crores. Plus 107. This 107 plus 68. So these are just 2 days.
107 belonging to, okay.
Yes, 107 belonging to 7451. Yes. These are 2 dates, my lord, isolated, pulled out by SEBI from the report. Every day has a different saga of, my lord, unfortunate events, saga of dishonesty.
Yes.
Now, my lord, kindly see 14. From the FAR, that's the report, it was observed that in certain instances, clients' securities were transferred from clients' demat accounts to the demat accounts of BRH and thereafter to the account of BRH CPL for pledging. So one is taking, giving it to the other is pledging. It is also noted that these clients whose securities were pledged in this manner were not clients of the commodity segment or traded in the commodity segment during the pledging period. Even better. BRH CPL is a commodities enlisted operator. Please come to me, Lord, that first page just once, just pausing here for a moment. Please come to 358 para 1.
Yes, yes.
BRH is that number 8. He is a member of BRH CPL, was because now he's been shown the door. BRHCPL was a member of Multi Commodity Exchange of India Limited, MCX, and National Commodity and Derivatives Exchange Limited, NCDEX. Now kindly link this with para 14 at page 373. Last sentence of the two. It is also noted that these clients whose securities were pledged in this manner or by BRHCPL by taking from his brother, correct, were not clients of the commodity segment or traded in the commodity segment during the pledging period. So these were not even clients who were trading in R8's commodity segment, for which he was enlisted under the MCX. And petitioner is one of them. I have no trading in commodities. I only have trading in shares. Please have a look. Paragraph 15.
Yes, yes.
Based on securities pledged data received from CDSL, it was observed that BRH and BRHCPL had pledged client securities with 6 financial institutions: HDFC Bank, JM Financial, Bajaj Finance Limited, ICICI Bank, Axis Bank, and ICCL for availing loan against share facility. I note that LAS statements of 3 out of 6 banks / NBFCs which had extended loans to BRH and BRHCPL were analyzed in the FAR. It was noted that INR 513 crore was disbursed by these 3 FIs to BRH and BRHCPL as loan against shares during the period 1st April 2016 to 30th of September 2019. It is also noted that the FAR identified 23 instances where LAS funds totaling INR 150.13 crore were transferred to 7 related parties of BRH, the details of which are given below. So now the transfer is to related parties. So even they are taking loans against shares. My shares given to 1, transmitted to 8. 8 is taken. Even related parties are taking. Kindly see, my lord, what public money is in India. Roman 1. INR 80.61 crore, 54% to Polo. These are all notices. INR 50.67 crore, 34% to Patan. INR 8 crores, 5% to Agarwalas. Subodh Agarwala, Subhash Chandra Agarwala, and Prahlad Rai Agarwala. These are all members of, family members of R5 and R6. Subodh, Subhash, Prahlad. Ex-directors 5 and 6 who have said bye-bye and say we have nothing to do with it. See, their family members are there who are receiving transfers of LAS. Lord, kindly take a note, Lord. Polo is R16 and Patan is R17. I've given your lordship a sheet in front of the list of dates where all the respondent numbers are written for your lordship's consideration.
Yes.
Polo R16, Patan R17, Subodh, Subhash, and Prahlad are relatives of relatives and or family members of Avinash and Sudhanshu, 5 and 6. Now, INR 5 crore to Prosperous, that is R15. Yes. INR 4 crores to BRH Stainless Limited, who's not here a party here, but he's also a related party. INR 1.80 crores to AB Investments, who doesn't have a PAN. INR 0.05 crore to East West India Projects Limited, Private Limited. Lord has seen. Roman 7. Lordship recalls, my lord, that AB Investment doesn't have a PAN. His PAN could not be found. Yes. Now 16, page 374. Apart from the above, I note that complaints were received by SEBI alleging that Anubhav Bhattar, director of BRH, had siphoned off funds from BRH to related parties. Based on the observations of forensic report and replies obtained from the related parties, NSE submitted their analysis and observations with emails dated December 31st, 2020 and January 1, 2021. Country was reeling under COVID. These people were at it. The summary of observations made by NSE is as follows. Kindly see AB Investments. AB Investments was a client of BRH. After examining the records of BRH, it was noted that an amount of rupees 2.9 crore is payable to AB Investments in respect of the transactions undertaken by it on the exchange platform. However, it was observed during the audit that the net outflow of funds from BRH to AB Investments amounted to INR 5.48. Here, kindly see the siphoning. In view of the same, it was noted that an excess amount of rupees 2.58 crores had been transferred to AB Investments by BRH, siphoning. Now see Polo. Polo Setco Tie-Up Private Limited. Polo was an NBFC. It was itself an NBFC. During the inspection conducted by NSE, it was observed that securities of other clients worth INR 31.10 crore were misappropriated through Polo. It is also noted from the FAR that Polo had a loss of approximately INR 17 crores in the F&O segment during the period covered by the forensic audit. However, despite losses in the futures and options segment, a net outflow of funds amounting to 150.54 crores, including funds amounting to 80.61 crores from the LAS account from BRH to Polo, was observed by the forensic auditor. I note that the said noticee in its reply has stated that it was not a client of noticee number 2 and it used to take loans from BRH CPL in the normal course of business. It was also stated that such loans taken in the past have been repaid with interest. Now SEBI is dealing with this. I see no merit in this argument taken by the noticee. I note that in terms of Rule 8F of the Securities Contract Regulation Rules 1957, stockbrokers cannot engage in any other business involving financial liability. Otherwise, siphoning will take place. So there's a bar. This 1957 rules, my lord. 10 years after independence. So not a 2019 mechanism. Now kindly see. Therefore, the contention of the Polo that it used to avail loans from noticee number 2, even though it was not a client of BRH CPL, would itself entail that the noticees were engaged in activities that were in contravention of the applicable legal provisions.
Yes.
Financial regulator coming to these conclusions below, not any fly-by-night operator or just a casual commentator. C, 375. Prosperous Vyapar Private Limited. No doubt it is Prosperous, my lord. Prosperous was registered as a client of BRH. It was observed that securities worth INR 105.69 crore were sold in the account of Prosperous. Since BRH had not reported any securities in the account of Prosperous, except for one ISIN in the month of August 2018, which was sold subsequently in the month of September 2018, it was noted that the securities sold through this account belonged to other clients of BRH. As per the holding reported by the forensic auditor, as of September 30, 2019, securities amounting to INR 8.31 crores are payable to Prosperous. During the audit period, the F&O loss amounting to INR 0.6 crores was observed in the account of Prosperous. However, the outflow of funds from BRH to Prosperous, which was observed during the audit, amount to INR 20.14 crores, including funds amounting to 5 crore from LAS account. It's undergoing a loss in the F&O segment. Despite of that, from BRH to Prosperous, funds are being diverted and sent. Look, I mean, textbook examples of fraud. Sobraj would have been proud of this. Now, kindly see D. Blue Snow Suppliers Private Limited.
But you're lucky they are in India only.
Yes, I mean, one thing. No, I'll tell you, Lordship. I'll tell you, Lordship. I'll give you Lordship. Slightly side digression for 10 seconds. They have not become. My Lord knows. Why can an ostrich not fly, but a crow fly? Because the ostrich is heavy.
Correct.
Therefore, unless you have become sufficiently heavy with your ill deeds,
you can.
In flying, it's reverse.
Correct.
You have to go, then you go. So, because that is negative karma, so the rule is reverse. These people are still midway, my lord. They are chicken. Heavier than the crow, but much lighter than the ostrich.
So now they're collecting.
Now they're connecting together. It will make a bunch of chickens. Very soon, my lord, if this continues, they will become a bunch of ostriches. And then they will fly. And we will have to waste the taxpayers' money to plead before different governments and say, please, there's an extradition treaty, please send them back, There'll be manifestos saying they will be brought back, which will be forgotten. They will never come back. And when RCB, one second, when RCB wins for the first time the IPL, the person who celebrates most is the person for whom lakhs and crores of taxpayers' money has been spent to try to bring him back to recover 100,000 crores of money which he has flown away with. And he's giving podcasts, my lord. Lordship has seen on YouTube. I have seen. What's that person's name? The interviewer? Raj Shamani. Raj Shamani is taking a podcast. How did that emanate? They bumped into each other while they were walking. That was the explanation. And here's Shamani sitting. Here's Mr. X sitting. And he's like, I have always done everything for the benefit of the country. Why should I? I've been misunderstood. With shrugs. And there are certain, and Shamani says, true. You are really an entrepreneur. True. You have really fallen from grace. It's as if there's a concerted, Lordship was seeing Jugalbandis, violin and tabla. Concerted violin and tabla Jugalbandi going on for the world at large to know that this person is not a crook. Every book in Indian law has been violated. Every liberty has been, every sponsorship has been taken. No, my lord, we must ponder, sit back and ponder. Things like these don't come every day. It's not the usual run-of-the-mill, sale of goods, sold and delivered, price not recovered. These are the people, my lord, who sprout from our regimes, they are given protection. These are the people from whom, my lord, after I make this submission, Lord, I raise a bill. It will go to the solicitor. If he is benign, I'll get a payment within a short time. If he isn't, that's a different story. If I get that bill, and if that bill is paid to me, 10% tax is deducted at source, which directly goes to the government. So with your lordship's salary. These are the people who are
not tax.
And these are the people who are looting this money, and they have the gumption to arrive in court and say, but I am not related to you.
Okay. The parliament session is going.
Please come.
But no one is appearing for respondent number 1.
Naturally. See. Now they have just started. This is incredulous. This has to happen in a place like, and that person is on. Not just one more second. Please, if you have not heard the entire podcast, sometimes out of sheer anger, one doesn't finish it. What will I see? This is like seeing a bad film. Just close it. I don't like this. Close it. But please, today, when your lordship goes back home and after my lord resting, what my request as your lordship's brother in the fraternity, please go and have a look at the entire podcast. If your lordship does not go into self-induced trance leading to coma, I will not change my name. Here is a crook sitting with a person. A crook is sitting with a person and he is explaining his virtues.
What has happened?
What has happened and how he has been misunderstood. And that person, like a pujari, is saying, oh, ho. And then he's ringing a bell. Oh, ho, ringing a bell. And this goes on. This is available on in public domain. These are not stopped, my lord. These podcasts are not stopped. 1 second, one telephone call will stop it, my lord. These are not stopped. Need I say more? My lord, coming back to Blue Snow. Please come to 375. D, paragraph D. Then they'll have the best of counsel coming in and saying, but, and all that. D. And the buts will be of different intonations. But. Blue Snow Suppliers Private Limited. Blue Snow was not a client of BRH. Blue Snow has received a total amount of INR 5.27 crores as license fees from BRH. However, the forensic auditor had pointed out the total outflow of funds amounting to rupees 6.94 crores from BRH to Blue Snow. Thus, a difference of INR 1.68 crores was observed in the total amount credited to Blue Snow over and above the obligations that BRH had to over it. So once you have taken the money from LAS, what do? Start making sham transactions. You have cleaned my kitchen. 100 rupees is your money. Raise an invoice of 100. I'll give you 500. That 400 is the siphon. Then outside we will share it. We'll put it in Hawala. We'll enjoy it in Hawaii. This is the transaction. Exactly what happens.
345 नहीं hearing it. Come next day.
Any day, I'm ready. And this is just the tip of the iceberg, Milord. Not in terms of time, in terms of shock value. More awaits.
The bank is also the sufferer of the same problem.
Yes, everyone suffers. I will show how the bank has suffered. That is also there.
But bank cannot say.
Bank will not make any due diligence. My lord, today my lord's property, I will go and I will give to the bank. Bank will take it, say that, no, but you wrote that, Mr. Banerjee.
Even not necessary to you give your property. Other party will give and the bank
will take and give.
Subsequently, when you go to the sell the property,
you will find that that is a property of someone who doesn't exist, and that no, sometimes property doesn't exist. I have done a case, my lord, 6 banks, 1 property, mortgaged.
Counsel for the plaintiff has argued the matter at length. But time hearing is not be completed. Let the matter appear on. कुछ है डेट नहीं है सुबह से वही चल रहा है problem is the date now.
No problem. Whenever your lordship wants to keep this. But this is something which requires to be placed in detail.
My friend is enjoying interim order.
My personal assets have been injuncted.
I leave it to your lordship.
Now, this court has saved your personal asset.
Yes. Otherwise, this is a classic one.
Very sad. Safe from further dissipation.
Safe from further dissipation, attachment, taking over.
What Mr. Banerjee has shown here, so I find you are saved from the court's office.
You should be thankful. You should be thankful.
Subject to hearing
Subject to hearing him, of course. Subject to hearing.
I don't think this being the savior is portraying to be.
No, I am not savior. I am saying the order of court is the savior. बाद में रखिए फिर. What do you have?
You got this.
पाए थे क्या तो भूले जा रहे.
11th at 11th August 2025 at the top.
11th August.
11th
at the top. I am not giving time.
Yes, so top would be top.
The interim order is extended till 14th of August 2025 until further.
18th August.
No. It was still today. It was still today, madam.
It was still today. 11th August. Interim order also extended till 11th August.
My lord, and madam is of notice, my lord, of the order of extension today. She can't come today. Oblige your lordship.
Lord, I appear for the matter fixed at 3:45.
Yes.
Mr. Dutt is leading me.
Yes.
Mr. Dutt is in some difficulty today. Your lordship knows that today is there some problem. He's not actually in town also, my lord, for some reason. If my lord, some date can be fixed, my lord.
We had concluded, my lord, on the last occasion.
Yes, my learned friends have concluded. We were to give a very short reply, my lord.
What is the matter?
A revocation of.
But that revocation of leave matter, my lord. Administration, my lord, granted.
Counsel for the applicant prays for time. Accordingly, case is adjourned. Let the matter appear on 12th August.
My lord, I'm so deeply.
12th, 10th is
12th
Sunday.
August. अच्छा non-commercial.
12th August.
8th August. 8th August.
$8, my lord. Fine.
Time not
Grateful
the
to
same as the same three the time.
Time is not. Come on then.
We'll take our chances.
Yes, next.
33, my lord, I appear for the petitioner. Petitioner plaintiff, my lord. My lord will recall 33. My lord will recall this is a matter arising out of my lord's order of 30th August 2024, where my lord had directed my lord the defendants my lord to set apart a sum of rupees 40 lakh 7,012 rupees. Thereafter, part by part during the pendency of the contempt proceeding, one demand after the other was handed up to my lord. The order which was originally passed by my lord was taken up in appeal, confirmed by the appeal court. Thereafter, substantial period passed. We prefer the contempt application 2025. Now, my lord, on the last occasion, my lord, there was a direction of the registrar to file a report today, which should be there with my lord today. To my calculation, my lord, they have, I'm sorry.
Last order, what is the
Last order, 17 July 2025, my lord, had passed an order. May I please, my lord, counsel for the defendant? I'm sorry.
Yes, yes.
Para
It is
2.
there, it is there. I
Yes,
don't understand, how much amount has been deposited? Only 13 lakhs. How much amount you deposited?
13 lakhs was deposited. Prior to that, an FD of 15 lakhs was provided. And then thereafter, 12 lakhs was provided by way of a demand draft.
My lord, if my lord
Demand
takes,
draft dated 09/04/2025.
To file a report, how much amount is deposited even in the instant matter? Let the matter.
There should be, my lord, 25 lakhs with the registrar.
Stated anything. No, only stating that 13 lakh, 13 lakh.
There has to be
even not 12 lakh, not 15
as
lakh.
per our calculation, my lord, may I just indicate what has happened? There are several orders passed. Initially, they had come, Mr. Shorgupriya Mukherjee was appearing, he'd come with an original fixed deposit of a cooperative bank in Varanasi.
Correct. That has been taken.
That has been taken and deposited with the register. I am not disputing that. After that, my lord, two demand drafts, if I am not incorrect, my lord, of 13 lakhs and 12 lakhs are supposed to be lying with the
12 lakh
register.
is not reflecting here.
And my lord,
So, there's a copy from the department,
hand it over to the court.
if I may, Lordship. Where the department has received the demand draft on 17th April. Copy of the demand draft itself is attached. Original.
$12 lakh you deposited. SKB Associates, advocate on behalf of the contemnor, DD number so dated Varanasi Singh. Whether this has been encashed or not?
We don't have that information.
We got an order. Just a minute.
ये 13 लाख कैसे डिपॉजिट हुआ है एंड सेम इज इन्वेस्ट अच्छा
Yes, that has been deposited and invested. And 13 lakh is deposited.
13 lakh is deposited and
12
invested.
lakh is also deposited.
So, my lord, my submission, if 25 lakhs is lying with the register, I'm assuming, I'm taking my learned friend's word for it. My lord, only one submission now. 15 lakhs by way of fixed deposit is there. 25 lakhs is there by way of demand drafts which have now been invested. That comes to 40 lakhs. My lord, only one submission. I will leave it up to my lord. This is between the contender and the court. My lord's order was of 30th August 2024 at page 532 of the contempt petition. My lord, if my lord takes volume 4, 532 is the operative portion. Only that line I'll place, my lord, and then I'll leave it up to my lord. Volume 4, 532.
And then we just accept and move on.
532, my lord, we'll see.
जरा फाइल भेजना और ऐसा ओरिजिनल साइट को भेज
There's a direction for the defendant to keep apart a sum of rupees 40 lakhs. I'm sorry.
534.
532. 532.
Yes.
My lord, we'll see there's a total amount of 40 lakh 7,102 which was to be deposited or rather kept 7,102 as on 532, my lord. Volume 4. That's the operative portion of my lord's order. 532. Page.
Though the earlier occasion court had rejected the prayer for interim injunction or itna.
Yes, my lord. Yes, my lord.
40 lakhs would be
As an ad interim injunction directing.
keeping aside the 40
Yes.
lakh 7,000.
Yes, this is my lord's order, which is under my lord, subject matter of this content. 30th August 2024. The checks that have now come forward and demand drafts are now in the middle of June. They have admittedly not complied with my lord's order. There's been substantial delay. My lord, contempt, my lord, I'm only pressing the contempt petition still further, my lord, because it is clear that the defendant and the contemptors, my lord, were not interested in complying with the orders of court. There's belated compliance for which, my lord, they cannot go unpunished. This has been affirmed by the appeal court, and thereafter several times time was taken. Page 535 at 536, my lord, we'll
What
see.
is the total amount now? 13 lakhs?
That's 40 lakhs total. 40 lakhs.
40 lakhs
13
paid
lakhs.
till date. 13 lakhs,
12
12
lakhs.
lakhs, and then 15 lakhs,
15 lakhs.
FD.
That
15 lakhs
comes
is FD.
Yes, that comes to 40 lakhs. In my submission, my lord,
40 lakhs.
there is still, firstly, belated. Secondly, my lord, still not clear compliance of my lord's order. Now, my lord, I leave it up to my lord. I don't want to press this further. My lord can record my submissions, my lord. I only pray, my lord, that appropriate orders be passed
Yes,
against.
what about the 7,100?
Lordship, the delay was
No, 7,102.
What is the 7,100? 40 lakhs you deposited. 40 lakhs 7,102. What will happen? One thing. Thereafter, the order was passed on 30th August, and you have deposited the amount. June 25.
Yes.
June 25.
And thereafter July. The last one was in July.
April 25 and June 25.
Lordship, the FD is for an amount of 15 lakhs. Upon interest, the party will be receiving 16 lakhs 9,369 rupees, for which we have we are humbly praying that 7,000 rupees may be adjusted in that.
Where is that fixed deposit?
Deposit copy.
It's in our affidavit.
Fixed deposit is
Page number 13 in our affidavit.
page number
13.
Affidavit can do.
Well, that is also recorded in Malot's
15
order.
lakh.
16
15 lakh. It is if it is 16 lakhs,
9,369. The 7,000 can may be adjusted from that amount.
That is also
So why
11.
this delay?
Yes.
Why delay? When the court has passed an order, it is the duty of the judgment of the contemptor to pay the amount. Okay, I am disposing of it. The petitioner plaintiff has filed the present contempt application volume 1 का है contempt application on the allegation of willful and deliberate violation and non-compliance of the order passed by this court dated 30th August 2024, wherein this court directed the defendant slash contemner to secure an amount of rupees 40,07,102 by keeping the said amount in a separate account till 4th October 2024. Where is the order for depositing the amount?
Depositing the amount was in the contempt. In the contempt. If my lord takes the order of 16th April 2025,
16th
April 2025, my lord has passed a detailed order wherein my lord the entire facts of the case are recorded.
Counsel for the petitioner slash plaintiff draw the attention of this court dated 16th April 2025 passed in the contempt application wherein it reveals that the contemner has filed affidavit along with the Xerox copy of fixed deposit under reinvestment plan receipt number 78 of District Cooperative Bank Limited in connection with account number 00120144 times 0 3685 of the District Cooperative Bank Limited, Head Office Varanasi, for a total sum of rupees 15 lakh, and the maturity date is 11th of February 2026, and the maturity amount is rupees 16 lakh 9,369. Full stop. The contemner has also submitted a demand draft in the name of the registrar original site of this court, being demand draft number 404021 dated 9th April 2025 for an amount of rupees 12 lakhs of Punjab National Bank Varanasi branch, Uttar Pradesh. Full stop. On receipt of the said Uttar Pradesh, full stop. The alleged contemner has further deposited the demand draft of rupees 13 lakhs of rupees 13 lakhs
That's a demand draft of 4th May 2025. My lord will find that in 5th May order, 5th May 2025 order, they handed. My lord, 5th May 2025 order, there's a check. My lord, 1 second.
That was
no, thereafter. Demand draft is my lord 20th May, 20th June 2025 order, my lord will take. That's recorded.
Draft of kitna bola?
20th June 2025.
13 lakhs.
Yes.
पहले check was इतना it is check
Demand draft dated 20th May 2025.
Demand draft big number 404240 क्या लिखा 12 नहीं
For an amount of rupees 12 lakhs of Punjab National Bank, Maharashtra, Uttar Pradesh.
full stop. Subsequently, the alleged contemner has further submitted another demand draft being number 404027 dated 20th May 2025 for a sum of rupees 13 lakhs drawn on Punjab National Bank, Varanasi, Sigra, within bracket Varanasi branch, Uttar Pradesh, before the registrar original site of this court. Full stop. As per the report of the register original side, this court find that an amount of rupees 12 lakh deposited by the alleged contemner is invested in the fixed deposit of Indian Bank being TDR number 0086998 on May 2nd, 2025, and the maturity date is 6/6/2026. Full stop. That another is, I don't know whether it is deposited or not. He has not submitted any report. Full stop. By an order dated, the one order is passed not to in that fixed deposit.
Yes, to invest in the fixed deposit last order for the balance 13 lakhs, 17 June.
The fixed deposit
Received.
30th
16th April. 16th April 2025 records the fixed deposit.
Where is the original fixed deposit of your that cooperative bank? You have deposited here.
Fixed deposit has
To whom?
Before the register. You the registrar lordship.
That is the copy. Where is the original?
The original was submitted by way of
letter. Covering letter. Affidavit. Original is
No. That was the Xerox copy. FD টা না এটা ডিমান্ড ড্রাফটটা furnished we have furnished the FD on 17th April itself. 17th April. 17th April এটা দিয়ে দিয়েছি আমি ওরা রিসিভিং করে দিয়েছে
let the matter come tomorrow. I will call for the report. एक काम इसको रहने दीजिए, कल उसमें फर्दर डिस्कशन। एक काम करो, ये इसको ना रजिस्टर को बुलाइए मेरा, ये लोग मैथमेटिक्स सिखाएंगे। Come tomorrow, I will take the report, then I will pass it. So that in future there will be no communication.
Yes.
Not today. Yes, next. क्या करते हैं? अरे रिपोर्ट कब भेजते हैं हम लोग?
Lordship, item 34.
Item number
34, your lordship. I appear for the petitioner in contempt of your lordship's order dated 8th of August 2024. If your lordship would kindly take page 34 of your lordship's brief.
34.
34. If your lordship recalls the JJ Deluxe matter, lordship, with regards to electrical switch gears, Mr. Bachawat had argued.
Yes.
And then a party from Delhi had come and opposed your lordship. Lordship, the order is at page 34.
No appeal is filed.
Pardon, your
appeal
lordship.
is not filed against this order.
Lordship, appeal, they have preferred 2 appeals, both dismissed, your lordship. And during the pendency of the suit, this is what they carry out. They are violating your lordship's order, which has been...
And what has happened to the Delhi suit?
Pardon, it is still going on. They are proceeding with the Delhi suit, your lordship, I'm told. Lordship, the order is at 34. If your lordship would kindly take the operative part of your lordship's order,
62.
that is at page 62. Lordship sees.
Respond number 1 and 2 in their men's servant, agent, assigned dealers, distributors, and claiming from the or to them the restraint from passing off or allowing others to pass the trademark JJ Deluxe.
Yes, and various other JJ formative marks. So not only restricted to JJ Deluxe, but also all other JJ marks. Now your lordship would kindly see what they are doing, your lordship.
Okay, let the notice be issued.
Lordship. Lordship issues the notice.
How many contemners? One.
Two contemners. Respondent numbers 1 and 2 are the contemners numbers 1 and 2.
Public petitioner has petitioners.
Petitioners, your lordship.
Plaintiff public petitioners have filed the present contempt application against the contemners on the allegation of violation, willful and deliberate violation of the order passed by this court dated 8/8/2024.
But you would kindly record willful and deliberate violation upon notice. They have said in the reply to contempt that they are aware of the order.
Upon notice of
Yes.
Upon notice to the alleged contemner. Okay. Upon notice. Full stop. The petition is directed to issue notices upon the alleged contemners. List the matter on. It is Delhi.
Lordship, we can serve. They are appearing in the suit, so we can serve upon
whatever it is. So I am fixing on 12th August.
12th August. We'll serve.
Matter appear on 12th August.
Grateful.
The petition is directed to petition. Plaintiffs are directed to file the affidavit of service on the next day.
We shall do the same. Extremely grateful.
Next. क्या है नल क्या है प्रिंट नल करके क्या है वो तो क्या है नहीं कॉस्ट आप अपना कॉस्टेटर में देखिए लिस्ट में 35 में क्या है वो नल execution case none appears not today. Next.
Lordship, in this matter, I appear for the decree holder, my lord. Lordship, in spite of specific undertaking to pay the decretal amount in installments, they have failed to do so, my lord. Only, Lordship,
Yes.
The
judgment debtor Sanjay Kumar gives undertake that the balance amount of 43 lakhs will be paid. What is the total decretal amount?
Total decretal amount, my lord, total claim was 53 lakh 61,000.
Amount is 42.
No, the present sum of rupees 39 lakhs 61,505 is pending.
Decretal is 42 lakhs 64.
No, my lord. Decretal is 53 lakhs 61,505.
Can you come to the tabular statement? Decretal amount is 42,64,714.
Yes, yes, sir.
Kindly see the tabular statement.
Yes, my lord.
42,64,714. Correct.
Yes, my lord. Yeah. Decretal amount and then interest was.
Then you calculated the interest from 1st April 2021 till the filing of this.
Yes,
the total is 53.
Yes, my lord.
53,61,505.
Yes, my lord.
So how much amount they have paid? Have they paid?
Yes, they have paid a part of the amount.
When?
Last payment was done, my lord, in
3rd October 2024.
No, they have paid on 3rd of December 2024 a sum of rupees 4 lakhs. Prior to that, they had paid a sum of rupees 10 lakhs on 3rd October 2024.
That's right, 3rd October 10 lakhs.
Yeah,
then
and thereafter, which is not.
Then when the second amount was paid?
That was on 3rd of December 2024.
3rd of December 2024.
And thereafter, no amount has been paid, and at present, an amount of rupees 39 lakhs 61,505.
So they are not appearing.
My lord, they are appearing.
So where is today? Nobody is here.
So
what do you want?
My lord, we want that.
Today nobody is appearing. What is your submission, sir?
Then keep it for tomorrow, my lord, because there is a.
Not today. No, record. So, counsel for the decree holder is present and submit that. And the decree holder has paid an amount of rupees 10 lakh and 4 lakh, 14 lakhs.
Yes, my lord.
14 lakhs.
14 lakhs.
Has paid an amount of 14 lakhs. And they undertake before this court that they will pay the balance amount, but till date the balance amount has not been paid. As none appears on behalf of the judgment debtor, for the interest of justice, the case is adjourned. Let the matter appear on 7th August 2025.
Lordship.
14. Yes, next. Decree holder case is adjourned. Yes.
Your Lordship, there was a confusion on the last occasion.
What is the
Which
confusion?
the confusion was that two warrants of arrest were issued on two addresses. One issued on February 2025 and one by your lordship's predecessor having determination, and your lordship was also pleased to issue another warrant of arrest in April 2025 to a separate address, which we came to know later on. Now, on the last occasion, we came across the report which from which the confusion arose. We had pointed out that to your lordship, and your lordship was pleased
Acha,
to
this
record.
matter na?
Yes.
Okay.
Now, now there is another report which has come up. No. Huh? Your lordship kindly grants leave to Mr. Huh? Your lordship, there is no further confusion.
সেকেন্ড রিপোর্টে বলছে এটা নেই সেকেন্ড যেটা রিপোর্টটা চেয়ে
এটা প্রিন্ট আউট নেই।
বলো 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 ছিল জানি না কোথায় এখানে যেটা ফাইল করছে এখানে বলে দিচ্ছি যে ওটা নেই করা যায় না guessing is not there which is a lie special officer appoint করুন
Yes. Your lordship kindly comes to the report of 14th July 2025.
Yes.
Your lordship kindly comes to the underlined portion under.
What? What you want?
Two.
Which order?
The report of 14th July 2025.
14th July?
Yes, your lordship.
No, 14th
The
July.
the letter of the sheriff of office of the sheriff of Calcutta to the learned registrar original site, which is pursuant to your lordship's previous order.
What was the last order?
Yes, your lordship.
24th June. The ISA court forwarded the report to the learned public.
Your lordship had directed to file the report. বাবা দাঁড়াও দাঁড়াও পড়তে দাও আগে না জজ সাহেব না পড়লে আমার বলে কি হবে
অনুযায়ী তারা আমাকে রিপোর্ট চেয়েছিলাম রিপোর্টটা দিয়ে রিপোর্টটা কি আলাদা
আবার উল্টো বলেছে
এই অ্যাড্রেসে না
if I
Yes.
now if I may point out your lordship in your lordship's last order of 24th June 2025 your lordship finds in paragraph 3 the address mentioned at the bottom of paragraph 3 that is the new address your lordship.
Which paragraph 3?
The order
24th June 2025 your lordship's order. Paragraph 3, at the bottom, there is an address D21 Vijay Nagar, Hanuman Nagar, Kankargarh, PS Patrakar Nagar, Patna 800020.
Counsel for the decree holder submitted on 2nd May. The decree holder has submitted the requisites to the office of the Sarif of this court, requesting for execution of the warrant against the judgment debtor, namely so and so, so and so. Yes. Counsel for the judgment debtor submitted submitted. There is no report furnished by the office of the Sarif. How it can be? Judgment debtor.
Now, Your Lordship, I'll point out what was the confusion on the last occasion. Pursuant to the order of February 2025, the warrant of arrest was issued to at the address mentioned in the cause title, Your Lordship. But we thereafter we had come to know from the decree holder that they are now at a separate residing at a separate address, which is this address. And hence we pointed out to Your Lordship.
That's why I'm asking, where is the new warrant has submitted by you?
That is,
no.
we have
Where is the warrant? There is a report that you have not submitted.
That we had already shown.
No.
Yes, Your Lordship.
Where is that warrant? You're taking the order from the court. You're not going to the office and mentioning that before the court. Where is the order submitted? Where is the warrant submitted by you?
Warrant sub. Your Lordship, previous to the last occasion only, we had submitted that and we had shown to Your Lordship on the last occasion.
How it can be 29/4?
This is the
24 June. I passed an order 24 June. After that, what you have done?
Your Lordship had issued Your Lordship had issued the warrant previously and in April. Pursuant to Your Lordship's order, we had gone ahead and lodged lodged the requisites for the warrant of arrest. Now, Your Lordship, in the meantime,
sir, when the new order is recorded on 24th June 2025, how you will submit the warrant in April 2025?
Your Lordship, if I may, kindly bears with me for 1 minute. The issue is this. Your Lordship, we had already lodged the warrant of requisite for the warrant of arrest. Now, in the meantime, there was a report which came to Your Lordship, which was with regard to the previous warrant of arrest. Your Lordship, it gave an impression that it was pursuant to the second warrant of arrest, Your Lordship, which Your Lordship was pleased to issue. Now, for that confusion, we had come to Your Lordship on the last occasion that although we had submitted the requisite for the warrant of arrest, no report has been submitted in furtherance thereof. Now, pursuant to that, Your Lordship had passed the last order. Now, Your Lordship kindly sees that.
So, you file an affidavit stating what is the address correct, file a supplementary affidavit, I'll pass a prepared order.
Your Lordship,
along with all documents,
Your Lordship, may I come back on another day?
The decree order is directed to give, file a supplementary affidavit disclosing the correct address of the judgment debtor. Within a week, let the matter appear on 12th of August 2025.
Your Lordship,
एक काम करो, ये मैटर को भी और वो मैटर को भी लेकर रजिस्ट्रार को भेजो. What is doing there?
Before Your Lordship rises, may I only clarify one thing?
Nothing. I don't want. Your advocate is not able to.
May I, because I've been dealing with this. I can.
I have given a 15 days time to ascertain. Neither you nor master nor the office nor the Sarif.
The day Your Lordship passed the order, the very next day we wrote, I can satisfy Your Lordship within 30 seconds,
Where is your warrant?
Warrant of arrest. What had happened, there were two warrant of arrest issued. The first warrant of arrest, the report came after the matter had come up in the list. So, at the time of hearing, the report on the first warrant of arrest was before Your Lordship,